memo দিয়ে দিয়েছি।
Good second. Item 7.
Not press.
One time point. One time say this one coin upon down to be sympathetic. One conclusion, sir.
Arun Kumar is
Sorry?
my senior counsel Arun Kumar is hospitalized due to cancer. Hence it may be adjourned next day, sir.
His senior is in the hospital due to cancer, so he wants an adjournment.
Is it so?
Haryana Medical College.
He's hospital. Mr. Mishra is hospitalized. Your name, sir? Apna name, sir?
On a picket.
PK Patra on behalf of PK Mishra for the petitioner. Adjournment is sought for. ଆପଣଙ୍କର ଏଇଟା ଯୋଉ ଲାଷ୍ଟ ଅର୍ଡର ପରେ ଏଇଟା ହେଲା କି ମାନେ ଲାଷ୍ଟ ଅର୍ଡର ଇଜ ନଟ୍ ମାଲିଗନେଣ୍ଟ ଲାଷ୍ଟ ଅର୍ଡରଟା ପଢିଛନ୍ତି did he suffer for this because of last order? Counsel for the petitioner, after advancing some arguments referring to the grounds of challenge in view of the categorical findings given by the court that the complainant did not produce a single document to prove that he was in fact the proprietor of the firm Taj Supplier, 6 further time. Then I have to record your submission that he is suffering from cancer, which I do not do.
Okay.
Is he suffering from?
Yes.
He is suffering from cancer.
Throat cancer.
Very sad. I counsel for the Patra. The adjournment is sought for on behalf of the petitioner counsel due to personal difficulty. As prayed for list on. କେବେ ଚାହୁଁଛନ୍ତି ସାର୍ ଆପଣ
Vacation.
ଫେବୃଆରୀ କରନ୍ତୁ 19/2 ମାର୍ଚ୍ଚରେ ଆପଣ ସେଗୁଡା ଦଉଛନ୍ତି 18 ମସିହା କେସ୍ ମାର୍ଚ୍ଚରେ ଦଉନାହାନ୍ତି 14/3 Item 7.
7, my lord, I have filed the memo for not press.
এটা যে সুইসাইড সেটা 302
না এটা ଘରେ ପଶିକି ମାଧ୍ୟମ କରିକି ନେଇ ଯାଇଥିଲେ ସବୁ। They have already been convicted as per my instruction.
What a non-appearance everything. Mr. Sahoo, Deepak Kumar Sahoo for the petitioner. Counsel for the petitioner files a memo dated 18/12/2023 indicating that the trial has been completed and the petitioner has been convicted by the judgment of the trial court. In view of the above, the petition stands disposed of.
Published.
Item 2.
Should may call this matter after vacation so that I will file the affidavit in the meantime. S.S. Rai for the petitioner. Mr. Devasis Naik, AGA for the state. Counsel for the petitioner 6 accommodation to file affidavit in terms of the earlier order dated 17/11/2023. Affidavit. Terms of indicating the past allegations of criminal activity, if any, against the petitioner. 21 January, as prayed for list on. 22 January. 22. Obvious.
Item 3.
We called again at 2 p.m.
Item 4,
Your Lordship, on behalf of Mr. P.K. Naik, I pray for an urgent.
I'm sorry, I forgot your name.
My name, Your Lordship.
Yes.
J. Jena, Your Lordship.
J. Jenna on behalf of P.K. Naik for the petitioner. The Learned Counsel for the petitioner. Adjournment is sought for on behalf of the Learned Counsel for the petitioner. You have filed affidavit on behalf of the petitioner?
The affidavit seems to have been filed, my lords, but I don't have a copy of it.
13/12/2023, affidavit has been filed. The Learned
No
Counsel for
copies.
the petitioner seeks accommodation to advance arguments. Adjournment is sought for on behalf of the Learned Counsel for the petitioner to advance arguments. Affidavit on behalf of the petitioner dated 13/12/2023 through his son has been filed, indicating the past allegations of criminal activity against him. Copy of the said affidavit shall be served on the Lord AGA. An extra copy shall be served on the AGA to enable him to obtain instruction. Keep a repair affidavit. How much time you can serve it by tomorrow, within 2 working days. You want it after vacation,
Yes, Your Lordship.
as prayed for.
authorized.
List on 18/1/2024 to grant further opportunity to the petitioner. The Lord AGA shall obtain up-to-date instructions. Yes, next.
Item 5,
May I please, Your Lordship?
Yes.
Item 5 may be taken up tomorrow, Lordship. That comprehensive affidavit ଟିକେ ଛାଡି ଆସି ଫାଇଲଟା wrong file ଧରି ପଳେଇ ଆସିଥିଲି କୋର୍ଟରୁ।
କାଲି ନେଲେ ହବ କଣ?
ଆପଣ affidavit file କଲେ? ଆପଣଙ୍କ ନାଁ ସାର୍?
M.S.Sahoo.
Mr. M.S.Sahoo for the petitioner, Mr. Devashish Naik AG for the state.
Tomorrow, Lordship, ଆସିବ ମଧ୍ୟ।
Has it been filed? File କରିଛନ୍ତି?
Affidavit file କରିଛନ୍ତି?
Your Lordship, ଆଜି ଫାଇଲ କରୁଛି ଟିକେ
ତୁମର କେମିତି ହବ?
day after tomorrow।
ବ୍ୟାକର କେମିତି ହବ? କଣ ପାଇଁ ଆସିବ? ପଚାରୁଛି ଆପଣଙ୍କୁ ସେଟା ପରା। ମୁଁ ବୁଝିପାରୁନି କି ବ୍ୟାକର ସମର
I times that matter has
କଣ ପାଇଁ ଆସିବ କାଲି ତୁମର? ଆପଣ ତ affidavit file କରିବେନି। For what it will be coming tomorrow? ହଁ, ତାପରେ କଣ ହବ? Is it invitation card?
day after tomorrow ଆସିବ।
ଆରେ for what, sir?
I release that petition on bail.
How can it be? I will do magic. The Learned Counsel for the petitioner has not, the affidavit on behalf of the petitioner has not yet been filed.
So,
Despite the matter has been being adjourned on 11/5/22 since 11/5/2023.
so date, Lordship.
Arey, you are obsessed, sir. You are obsessed. Close down your eyes and ears also. I'm asking you repeatedly for what you want a short date.
Your Lordship, that
You are wasting time like anything, not concerned about the petitioner. I must tell you with lot of, responding to your anxiety, you are not filing affidavit.
Your Lordship,
And why are you filing affidavit? I will say that since you are having criminal activity, proclivity, I will release you on bail or I will ask them for instruction. Have you ever seen an order like that?
Your Lordship,
Don't be excited so that you go completely out of track. I have been repeatedly asking you that upon affidavit file actually call by so it will be listed. You release the petitioner. How I will release the petitioner? Because he is having criminal activity.
you also two criminal general.
Whatever. So they will obtain instruction. Why are you looking at this? Say, throw tantrums.
Already instruction has come.
Throw tantrums in court. This is not your house.
Your Lordship,
You are unable to follow anything. You are not able to follow anything. You are not filing the affidavit. That I am dictating. You are going on repeating the same sentence.
Your Lordship, government record instruction ଆସିଛି to criminal activity.
ଆଜ୍ଞା ଆପଣ ମତେ ବୁଝାନ୍ତୁନି ଆଜ୍ଞା ମୁଁ ଯେତେ କମ ଆପଣ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ କରୁଛନ୍ତି ଏତେ ମୁଁ କମ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ କରନ୍ତୁନି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ର ଆସିଛି କି ନା ମୁଁ ପଚାରିଲି କି did I express any doubt? Yes. Why you are smiling and going on a commentary, throwing tantrums as if it is your home? You are talking to your family member. This is serious courtroom deliberation. Government ର ଆସିଛି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ର ସରି ପରି କୁହନ୍ତୁନି, you are wearing a robe, otherwise I have nothing personal against you. Sorry କାହିଁ କହୁଛନ୍ତି? You say anything and then you say sorry.
Comprehensive activity ଆସିଛି ମୁଁ ଆଜି file
Why did you not file? I am asking you.
Your Lordship, that family member has that lower court counsel has in
Why you are not filed? Then why you are insisting that it will be taken up tomorrow? Though the affidavit has not been filed, the learned counsel for the petitioner insists that the matter shall be taken up tomorrow. About criminal incidents আসছি যেটা আছে
Not similar nature. Simply.
the learned counsel, though adjournment was granted on 1/12/2023, even after 18 days, the affidavit on behalf of the petitioner has not been filed. As prayed for by the learned counsel for the petitioner, further accommodation is granted to file the affidavit in terms of the order dated 1/12/2023. The learned counsel for the petitioner submits that he shall file the affidavit today. During course of the day, copy of the said affidavit shall be served on the learned counsel for the state to enable him to obtain instruction. Further, if the affidavit is filed during course of the day, same shall be taken on record. Scan copy be updated. List on 12/2023
Obligation.
লিস্টিং বিষয়ে কিছু আইডিয়া নাই, ফাইলিং রে কিছু আইডিয়া নাই। এটি ফাইল কলে কেমতি হব সেটা আসিও কিন্তু রেকর্ড
Day after tomorrow,
কালি আসলে কেমতি আসে, হাউ ডাজ ইট কাম?
day after tomorrow, maybe
ডে আফটার টুমরো মেবি।
record.
This is a paperless court. Are you filing it? Are you filing a scan copy? Ignorance is bliss, but absolute ignorance is a problem. Yes.
item 6,
And kindly file your affidavit today, as you have undertaken. Yes, we have a lawsuit. So last order plus I have the entire order sheet, as well as the deposition of all the prosecution witnesses. Plus I have given the list. The process can be resolved. I have and to copies to both my learned counsel appearing for the informant as well as for the petitioner. Soft copies. Soft copies. Yes, you have gone through or you go through take it
I have
tomorrow?
received documents, but I find that order sheets are not complete, as has been stated in the memo. After 25/8/2022, the next order sheet is 1/11/2023.
হ্যাঁ তড়প ରହିଯାଇଛି পেজ ମାର୍କ ନାହିଁ ତ 24/6 ଗୋଟେ ଅଛି
25/8 ପରେ ଆଜ୍ଞା 1/11/23 ର order sheet ଦିଆଯାଇଛି।
ଆଠ ସାତ 22 25/8 କହୁଛନ୍ତି 25/8 ପରେ 1/11 ମୋର ଆର୍ଲିୟର ଅର୍ଡର ସିଟ୍ ଅଛି ଦେଇଥିଲେ ପଚାର। Yes, Mr. Panda, what is your submission? You to go through this.
After the order dated 25/8/22,
That he has, that
wherein the matter was adjourned to 8/22. The next order sheet that has been supplied is 1/11/2023. So the memo to the effect that entire order sheet has been supplied is not correct. That's what I want to say.
original court code. Let's just time to search. That was obtained earlier also, that was there on the court in my file. Well, ଆପଣ ତ ଗୋଟେ arrange କରିଦେଲେ ହବ। ଯଦି ମଝିରେ କିଛିଟା ଅର୍ଡର ଆଗରୁ ଅଛି ପଛରେ ଯୋଉଟା ସାର୍ଟିଫାଇଡ୍ କରିବି ସେଟା ନାହିଁ ତାକୁ ସିକ୍ୱେନ୍ସିଆଲି ଆରେଞ୍ଜ କରିଦେଲେ ହବ କରିଦିଅନ୍ତୁ। সেটা সে পেজে খালি ইনসার্ট করে দেবে হবো আচ্ছা আপনি দেখুন ন দেখলে জানি হবো না দেখলে জানি হবো So now it has been placed before me after by the administrative order of the Hon'Ble Chief Justice, Acting Chief Justice, that
In terms of the standing order, it should have gone before Justice Satpathy because he disposed of the earlier application of the co-accused.
no that order I have passed that has gone to the Hon'Ble Acting Chief Justice.
Lords that are being placed before their lordships, before whom matters have been withdrawn, being infructuous, before whom matters have
So it's a disposal order.
Yes.
Even if it's a disposal order.
Doesn't say, my lords, that an order has to be disposed of on merits.
No.
In order to be listed before the same judge.
The death of the petitioner being infructuous লেখা আছে না concept. The order says that it is infructuous.
That's bad. On that day, he committed suicide.
Because because that accused was died. What is the impact of it? But now the registry has placed it before me, so I have no choice also. Yes.
Now, my lord, shall I place?
Yes.
This is your lordship. I'm in custody here since 21/10/2021, my lords.
Yes.
This trial which I am facing, my lords, was initiated on the basis of an FIR, which is at page 7 of the brief, my lords.
Yes.
And in that FIR, lodged against one M.S.Sahoo, the informant alleged that on 8/10/2021 on Friday,
Since he has passed away, against you, what is the specific allegation? Overt act attributed or specific allegation?
against me, my lord, I was arrested on
Driver something.
confessional statement by the co-accused who is deceased. He made a statement, disclosure statement recorded on 27 of the Indian Evidence Act, wherein he said that he had sent me to procure tires, my lords, old tires. And those
So against you, the allegation starts after the entire fatal incident, Alice fatal incident occurred. Much after that, that is the prosecution case. Yes, Mr. Kotkia? Because he comes into picture. Yes. When the tires were ordered to be purchased by even prior to that.
they were not purchased, they were brought.
Bought, whatever. Borrowed. No, prior to that, what exactly the overt act you are attributing? This person has taken money and was given to one Saurabh Das, who was already been examined. And Saurabh Das, by phone pay transaction, he has transferred it to the deceased. So that deceased will come to the Mahalinga, the Kalesh. And on the next day, the deceased has come. Then no, sir. I'm saying regarding the crime. You are saying you are trying to make a chain for the principal accused. No, but what active role or overt act he has done, according to you? As per me, first he has given money. To the deceased. Given money to the deceased through Saurabh Das. 7,000 rupees has given. No. So that's this particular accused person. Yes. Has given money for what, sir?
Money was given by my employer, the deceased accused, to be paid into the account of the deceased Mamita Meher. And I have gone and given that money to the person Millers who has credited it to her account. Mr. Katsura is not saying the proper.
No. Let us be serious on merits. So I'll be asking you, sir. I'll try to be as sharp as possible with my limited. She carried the money from the accused. Yes. and handed it over to somebody else. So he's a courier of that money. Yes. What else? He's taken and so that am I clear? Yes. Yes. Then on the Mr. Katya, why I'm asking this? Suppose he's not the courier. Yes. He is the perpetrator. Yes. He gives money to purchase a katta. Say, I'm just completely taking away this story. So he purchases a katta and uses it to kill somebody. So then the role is different. No. So here he is the courier. Yes. What else? Plus here the charge has been given, and the other part is that I will not be expressing an opinion on any evidence. Only reference for the consideration of bail. Yes. Yes. Then he was asked to purchase the tire. Or brought the tires. The latter part, plus I'll come to that. Plus, first, the charge is employed by whom? This fellow is employed by whom? The deceased guy is by Govind Sahoo. He is accused. Who is no more? Main accused. He was serving Govind Sahoo. He is the driver. He was early of the Govind Sahoo. Okay. So he was acting at the waist of Govind Sahoo. At the waist of Govind Sahoo, first of all, this prisoner gave money so that you, as far as the entire transaction is concerned, this the deceased, unfortunately, the victim committed suicide. Or she was killed. She was killed. So stop there. So she was killed. In killing her, what role he has played? Yes, first role he has played. He has given money to Saurabh so that it will go to the account of money. How can you say that by transferring money to somebody's account, she gets killed? That is one of the circumstances. I am coming. Not circumstances. That's not a circumstance of killing. That is a circumstance of you are proving the guilt of the principal accused. It is a case of circumstantial evidence. I understand, sir. I understand this is circumstantial evidence. So as far as he is concerned, what is his role as far as killing that person, that unfortunate victim is concerned? Plus, in a nutshell, what I'm saying, on the day of occurrence, because she was taken to Bhawanipatna, the principal took the victim to Bhawanipatna. And throughout the entire day, only Govind Sahoo had the communication with this person. That is CDR, that reveals from the CDR. Then you are aware of the contents of the conversation? So that you can get. Only you are not aware of the contents of the conversation. So you are saying that this perpetrator of the crime, alleged perpetrator of the crime, was in constant conversation with this particular person. Because charge has been framed most honest in 366, 302, 120B, and that's not a problem. Obviously, without 120B, you cannot rope in even. Yes. Or 34. Yes. 34. 34 is there. Yeah, 34 is there. Okay. 34 and 120B is there. And this person was constantly talking with this person. Yes. So let us assume that it is proved also. Yes. Next point. See, Govind Sahoo, the principal accused, has told him that you go and bring 2 tires from such and such person. And he went by a scooty and brought the 2 tires and handed it over to Govind Sahoo. They are at the spot of occurrence. And subsequently, was that role of those 2 tires being utilized for the murder or destroying evidence? It was for murder. It is how the tire was utilized for murder. Because she was born to death. The pit, there was, because prior to the day of occurrence, the pit was, because there was a construction of one stadium was going on. There, 1 day prior to that, Govind Sahoo was tire. Or pit ko jante nahi. Suppose he got the tire. This fellow was dug up that pit. The allegation. He brought the tire. Yes. So at the spot of destruction of evidence, destruction of the corpus delicti. Yes. So they put the story is that to destroy the corpus delicti, they have put tire, wood and everything. Yes. So what is the role attributed to this fellow? No, that is not clear. Not clear. Okay. That is not clear. Fair enough. It is clear. Because he brought the tire. Yes, he also says that I brought the tire. Yes. And also that tire, the remnants of the tire also has got brought out from that pit. And the bone, whatever has recovered, bone, and there has been recovery of bone. That's we are not discussing. That shows that that is the bone of Mamita Meher and the deceased. Sir, I am not asking that. Sir, I am asking you a very simple question. This fellow's complicity in commission of killing of that victim, 34, with the item 34. What act is that he gave money to someone to get a transport to that. Yes. and he brought tires. After that, yes, it was burnt in that pit. Yes. The corpus delicti is destroyed, and you have recovered bones. Whatever remains are there. Yes. So that has been found out to be by DNA or something scientific. Yes. That is to be the deceased. Yes. So this is so the other part is that he was in constant conversation on the day the occurrence took place. And also there were some articles of the deceased was in a bag. This petitioner handed over to his wife. Bag was received by this person, and we were proving that for some time he was receipt of the bag of the deceased after her death. No, not after her death, before her death. Prior to her death, because that you can say when is going that. So that is there like the point was. No, you do not. So the victim's belongings were found. There in the house of the present petitioner. Ultimately, his wife handed it over to the investigation agency. That this is the bag which has been kept by my husband. Yes. What else? What else? These are the entire allegation against this matters. Yes, Mr. Ponda, what is your response? Or you don't want to say anything? It is better to say.
I respectful submission, my lord says.
No. Apart from this, you are an officer of the court. I am also asking you that question. No, further negative question, Mr. Ponda.
Since my learned friend has argued.
No. He is not arguing.
My learned friend for the informant finish, I will reply.
No. I'm not there. I'm saying that I'm asking you a negative question. Since you're officer of the court, is there any other allegation according to you which he has not said?
Lord, so far as what he has said, these are the materials.
These are the materials.
But some of these materials, my lords, have been put in a way that they are incriminating, which they are not. That is
anyway, that's on the merit. That's as far as the final arguments are concerned. Yes, Mr. Mishra. Milord. Last question again, because now it is a positive question for you. Apart from the learned AGA, what he has submitted regarding the attributions of activity, anything else, any activity he has left? I am coming to the left. What my learned Mr. Katke has left. The date of occurrence, Milord, say the problem. Let me complete. Let me say, don't give an impression that you are not allowed to speak. No, that's not the question. Only the question is fair to the court. Yes, the question is very specific. You are not arguing a matter, you are answering a query to the court. Yes. The court's query is the involvement of the present, not exactly involvement, it is beyond that. I am wanting that exact complicity, exact overtact attributed by the prosecution. Yes. So you are saying saying something is left by Mr. Katke also. Yes, Mr. Ponda agrees that he has not left anything. But he says that as far as whether it is incriminating or not, that's a question of attributable of the present petitioner, my lord. Attributions against the petitioner. Straight away come to that. Yes. One key has been recovered from the present petitioner. Mobile phone, dress materials, everything. Then you are not listening to him. He says he brought the child. Please stop. Leave this habit of he says the entire bag was recovered. You are talking that what was contained in the bag. Yes, or belongings. So please don't waste your time. And sir, I am not asking. IR has been brought by the present petitioner. Don't repeat. Mr. Mishra, you are not listening to him. He says the entire belongings contained in a bag. Whatever was there in a bag. You are saying there is a key ring, there is a hair clip, there is buttons, perfume. So why we are not there? We're not going to attribution about this person. Sir, you are saying that key ring was not in the bag or outside the bag. That's the question I'm asking you. It is something else, because Mr. Katke is very clear that it was recovered from the wife of this person, a bag belonging to the deceased, and that bag contained the person. The personal belongings of the deceased. Number one, the bag belonged to the deceased. The contents of the bag also belong to the deceased. So, upon the keyring that I questioned, where from and when it was recovered. Look, the keyring of the Maruti Wagner, where the body was brought. That was with the present petitioner after commission of the crime. Upon the in the under section 27, again, you are missing the point. You are missing the woods for the trees. Sir, Upon the question, it is alleged that he drove the wagoner by which the body was brought to that pit. Is it your case there? No. Then you stop there. Then you are diluting the case what he is making. He's so because he understands. Because
Categorically stated who paid the money. PW 11 your lordship kindly see categorically stated
who paid the money?
who paid the money.
ଆପଣ ସେ ପୃଷ୍ଠା ଉଠାନ୍ତୁନି ସେ ଯୋଉଟା ସେ ଯୋଉଟା he paid the money, he took the money, paid to some das and he paid to the victim. ଏଇଟା ତ କହୁଛନ୍ତି ସେଇ transaction ଟା.
Exactly.
ଛାଡ଼ନ୍ତୁ ତାହେଲେ you are repeating and just wasting time. ଆପଣ ଯୋଉଟାକୁ my question is very specific.
My answer
your answer is completely haywire. Sir, ମୋର very specific question ଆଉ ଥରେ କହୁଛି ଯେ ଆପଣ ଯୋଉ attribution ସେ କହି ନାହାନ୍ତି you tell that. ସେ କହିଲେ ଯେ ଆପଣଙ୍କର he brought the tire with the scooty of the pleasure deceased put in the ସେଟା କହିସାରିଲେ ସେଟା ସେ କହିସାରିଲେଣି ଆପଣ ଯଦି ଷ୍ଟଡି କରିଛନ୍ତି you have found out anything other than what he has said.
and the involvement of the present petitioner is also there.
ସେଟା ଆପଣ submission I am not preventing you from submitting anything. You have to answer the court's query first, then you submit whatever you like. More
He brought the tire from this
Vikas Agarwal. Have you heard Mr. Katakia? Yes. So please add anything which he has left. He did not hear it. Mr. Kota did not say anything because I asked him this question. Yes, and why you are going on based on speech? And ଯୋଉଟା acquisition question ଟା କଣ କହିଲା ଆପଣଙ୍କୁ? What is the question put to you by court?
Court has put me a question. Apart from Katkia submission, what more?
No. Never. बढ़िया था. You see the ଆପଣ YouTube ଟା replay କରନ୍ତୁ. Then I have to again yes, sir, replay होता. Sir, आपका question is very specific, which was asked to Mr. Panda. See, apart from the specific overt act attributions by the prosecution, what has been stated by the learned AGA, do you have anything else to add which he had missed? You are just going on repeating what he has said.
Yes, Katkia, what said that is correct.
Because you see, Mr. You have to be serious. ଚାବିଟା ତା ପାଖରେ personal belonging ତାର ଚାବିଟା ମିଳିଲା. Then I ask you ଚାବିଟା କୋଉଠୁ ମିଳିଲା? ନା ବ୍ୟାଗ ରେ ଥିଲା.
Now, bag is vehicle where the ଆପଣ
ଦିଟା ପାର୍ଟ ଭେହିକିଲ ଚାବି ଅଲଗା ଡିସିଜ ର ଚାବି ପର୍ସନାଲ ଚାବି ଅଲଗା. ଆପଣଙ୍କୁ ମୁଁ ପଚାରିଲି ଆପଣ ହଁ ବି ମାରିଲେ. ମୁଁ କହିଲି କି ବିଲଙ୍ଗ ଟୁ ଦ ଡିସିଜ୍ଡ you say yes. Deceased Maruti chabi what it is hinting at the car which carried the dead body, the corpse or the dead body that was driven by her. Your answer is no if I followed you. So then what is the, because you see he's the driver. He's the driver. But a driver having the key of a vehicle which he drives day in day out makes no difference. So that is how he is smart enough to not to mention that. Okay, that cannot be a basis of suspicion. But suppose you are the direction of the prosecution is that the car which carried this fellow was driving that car. No, it's not. Fair enough. At least to that extent, I understand that you are not. Yes. So according to you, all three of you agree as far as the attributions are concerned. Yes. Next, make your submissions, Mr. Panda. No, you wanted him to submit. Upon submit for them, submission kuhantu. Yes. The court's query is over. Now you make your submission.
not admitted fact that the
Who was admitted? Whenever they admitted, Mr. Misra, whenever you say admitted facts, the sentence should be the facts admitted by so and so, so and so. Yes. Nada kohibe. Melo. Ki admit kala, kon admit kala. You may have to respond to this, Mr. Kotkia.
Yes.
Because if he is digressing from whatever you have submitted, then you are at, conflicting ends.
Yes.
Initially, he said that he wants to add, but I think that whatever you are saying, he's saying only that,
Yes.
apart from the key of the Maruti car. But Maruti car, when he's saying that Maruti car he was not driving the car, then obviously whoever finds the key, how is it material for the prosecution to prove? Only thing is that you have to prove that the Maruti car was carried, yes, containing the dead body. There is another angle also. Whether the dead body, no, it is now. No, you reserve your submissions because if he says something,
Yes.
who has admitted what?
Yes, I am the informant is admitted. I have filed lodged the affair under section 366. On the affair allegation that
informant has admitted what?
admitted that I am the informant who lodged the affair under section 366.
Admitted कहीं कुछ नहीं अपन तो कोई भी
I have lodged the affair. That is that.
ये admission की दरकार नहीं.
And second, not that at least 14 witnesses has already been examined out of 168.
ଆପଣ 168 witness କରିଛନ୍ତି 168 ଟା circumstances prove କରିବା ପାଇଁ Mr. କଟକିଆ 168 ଟା ଚାର୍ଜ ସିଟେଡ୍ witness ରଖିଛନ୍ତି 168 ତାର ଗୋଟେ ଡିକ୍ଲାଇନ୍ ହେବେ ଆପଣ ଇନ୍ସପାୟାର ହେଇଗଲେ କି ସେ ଯୋଉ ଫାଷ୍ଟ କନସିଡରେସନ ଫର ଟୁ ଗ୍ରାଣ୍ଟ somebody bail. Yes.
During the examination,
trial କେବେଠୁ start ହେଲା?
trial has been started
First witness on 29th September
29th September 22.
ନା ନା ଚାର୍ଜ ଯୋଉ ଦିନଠୁ ଫ୍ରେମ ହେଲା
ସେ ଦିନ ଚାର୍ଜ ହବ ନା ରାଇଟ ରାଇଟ
The examination was made on
अरे ट्रायल में पता ले पापा
29th September 22.
29 20 चार्ज शीट फाइल चार वेतन प्रेजेंट on 25th August 2022 25th August बेसी दिन नो and first witness has been examined on 29th September.
Yes.
On 1 month after.
So far as Lord, the PW1 to PW8, none of them are whispered about the present petitioner. Now the question is,
No, Mr.
question is there,
Mr. Misra, I am sure. I am not acquitting or convicting anyone. You are sure for that. You are too experienced not to. So I am not going there. First of all, what is the attribution?
yes, we have completed.
So you are so then to prove that how far they will be successful, that's another thing.
Yes.
But so to my so you think it this way. Let us assume that everything is proved. Everything is proved against this person. I am not asking you what is the incriminating material.
Yes.
Incriminating material.
So now the consideration of bail is concerned, I am confined to that.
So as far as consideration of bail is concerned, so let us assume that everything is best material is produced to prove the charges against this person. But these are the allegations. So the endeavor of the prosecution is that they will prove tire. He brought the tire. He was in conversation with the deceased, and that he brought the tires after the occurrence.
Yes. I will come into this.
And the bag containing the personal belongings, the bag belonging to the victim, containing the personal belongings was also recovered from the wife of the petitioner. It is proved. Let us assume it is proved. Yes. So you don't have to go to the evidence.
Yes. Why am I going to the evidence now?
Your Lordship,
During the process of trial, the present petitioner and the main accused, they have sent some person for threatening. That is also deposed by PW9. That this threatening person to us, I mean to the witness informant, to the witness Goodell Harijan, not to answer in our favor. He has filed and prosecution filed a petition for that same reason. That was also taken into account. Second point, my lord, so far the bail is concerned.
so that was before death of the principal accused or after death of the principal accused?
During the process of trial.
Before the question, answer the question.
Pardon?
You said that the principal accused, the threatening came to one Goodell Harijan from the principal accused and this person. So that threat was before his death or after his death? Before his death. Yes. Okay. So you answer that.
Second, Saurabh Das, who is a material witness. What is the role of Saurabh Das? The amount has been...
Sir, please don't chew my head, sir. You are a vegetarian, I am a vegetarian. Sir, you are going off track. No, I'm not asking, sir. I'm not, sir, please. When the court is saying, I assume the best evidence is produced to prove the allegations against this person.
Yes.
I'm not doubting any evidence now, as of now.
Yes.
So, upon Saurabh da kind kouchanti. Saurabh Ganguly, how does it matter?
Because the relationship of the accused, principal accused, and the present petitioner.
Relationship कौन है?
The relationship usually this present petitioner paid the amount.
अरे सेटा आपण सेटा बेस्ट होची जोटा से कहले जे दिस फेलो कैरिड दैट मनी टू सौरभ दास ट्रांसफर्ड इट टू द ये सेटा तो सॉरी सेटा तो ऑफिशियल को भाबिला आपण आउट ऑफ सौरभ दास কথা কইছেন
Say Saurabh Das.
ছাড়ন তো
R1 is PW14. Hemant Mishra was done the CBI.
आपण अगेन सर मु कहूची जे आपण आपण जेते पचारिबी जे सौरभ दास वेरासिटी ऑफ द स्टेटमेंट ऑफ सौरभ दास देन इट इज वैल्यू I am saying that whatever evidence produced against this person is to be accepted. I am bothered about that also.
There are several 164 statements as
Again, the coin but relevant kotha कहउछन्ती threatening by the
I am to get
that threatening by whom? Threatening by whom?
by the present petitioner and deceased Gaurav. Sorry, Govinda Sahu.
अरे आपनकर सेथरे पिटिशन फाइल करछन्ती यस मिस्टर कटकिया this petitioner has threatened anyone? That is your allegation.
That is PW9.
Petition file करछन्ती PW9.
Yes, boss. The witness volunteered that there is a threat from the side of the accused. Today, the agents of the accused persons went to his house and gave threatening to him not to dispose of the
Accused means ये जो persons हैं कुहन जो again video में ना सेपुरो अपन पढ़ान्तु बीसी रे प्रॉब्लम ता हबो जने कहला वाला कहले किछ बुझी हबो
Instead of ध्यान sir.
So, this what the witness volunteered. I'm reading the entire paragraph, two paragraphs, small paragraph. The witness volunteered that there is threat from the side of the accused. Today, the agents of the accused.
साइड ऑफ द अक्यूज तो सेटा गोटे बढ़िया साइड ता गोटे बढ़िया वर्ड पसिएची इंग्लिश रे ओडिया रे
कोर्ट तो
लिखले साइड ऑफ द अक्यूज माने लेफ्ट साइड राइट साइड फ्रंट साइड सेटा तो लिखलेनी अरे की कहा को नेम कले कि से दिस फेलो हैज थ्रेटन
Because today, the agents of the accused persons went to his house and gave threatening to him not to depose the truth and to divulge what they will instruct him. As such, he instructed the same to the special PP by submitting an application. On perusal of the application, it is evident and apparent that the witness had perceived the threat perception from the side of the accused persons, though not directly, indirectly by his agents. The London Council for the accused person submitted that it is fabricated submissions of the witnesses. Neither the accused nor his agents have ever given any threatening to the witnesses to divulge the truth. In view of the submission and argument of
एफआईआर लॉन्च करथिले इन्वेस्टिगेशन हला
FRH.
सेटा हां से कोन हला तपरे देखुतांतो से कहितांतो आपण के बात भीतर देखो यस ये मिश्रा
Yes, prosecution has also taken 164 statements. One of the witness.
अरे आपण again we are going back to the prosecution case and sir it is assumed that best evidence has been produced or will be produced because they are yet to examine 168 to 14 sir I am not asking how the prosecution case is being conducted आपण एई जो लोक विषय आपण कोंतु
Again, same लोक विषय ही कहूची.
हां
164 statement रे
164 स्टेटमेंट रे से टायर आनिथला बैग आनिथला एडा सब अछि तो या कहउछंती कोन स्टेट अवे टू से लाइन को सीधा आसंतु
आसुची. तापरे गोविंद साउर ड्राइवर राधे चंडी आसिला. गोविंद ताकू स्कूटी देकी कुआडे पठाइला. 15 मिनिट रे राधे चंडी
थरे कहली I have told you that is thorough well proved you say something which is relevant for consideration as per apart from sir I am not arguing here I am not arguing this is not the concluding arguments or the final arguments in the trial आपण एटा को ट्रायल कर सारलेनी
नो माय लॉर्ड.
this is only 439 I am only 439 ने आपण सबमिट करंतु let us assume that you have all the materials and evidence best evidence against this fellow
Not that point I am pointing.
That issue I am pointing. Did I ask you that, sir, you have not produced anything? Then you will answer that. You go on. Whatever you want to do, you do. You will not follow anything or yes, you carry on. Well, the statement has been recorded by the prosecution with the involvement of the present petitioner. 164 statement गुड़ाक जो अच्छी सबुथिरे समस्त प्राय speak in English. Yes, I am some. Sir, nobody has asked you that he has not been named in the sir. That's not the plea. You are answering as if it is a submission that this petitioner is not neither named or nor he has been mentioned in any of the 164 statements. No one has said that. In all the 164 statements, will not be present petitioners. Who has said that his name is not there? Who said out of the two persons you are learned, but 164 or the judge? Do they hear you that? Do they ask you that 164 statement doesn't contain his name? Contains his name? Did I ask you that? No, my lord. Then why you are going and repeating, sir? Yes, madam. And the impulse order itself also shows. आपका presumption of innocence से कौन decision अच्छी by presumption of ये अच्छी. Till now, in our system of trial, a person is presumed to be innocent or is to be guilt. Is to be innocent. Is to be innocent. Unless any difference of opinion, Mr. Ponda? According to the law as it is situated,
I strongly believe that there is a presumption of innocence so far as any accused is concerned.
Mr. Patkia, the presumption of innocence, that is the law. That's the law. Again, I'm highlighted by the so many high courts and the Supreme Court guilty. Always yes, presumed to be innocent. So basically, we are not discussing whether he will be convicted, he will be hanged. That's another thing. Yes, it is one part. So far, this all the new solution is that 164 statements contain his name, his reference. Mr. Misra, if you find anything other than bringing that to that. So that main incident of crime, anything other than that handing over the money that was money was handed over to some das and he transmitted it to the victim. So you go, if you have discovered anything beyond that, then please come to that. So that beyond that respond. Beyond that, there is no discovery at all. Okay. So far the 164 statements, there has been reference to this person. Yes. And 161 statement also the same. That is 161 statement you are relying, then you have to show that this court can consider that. The relevancy, admissibility and weight. And res geste. These are the four principles of evidence law. And still it is not amended. The new law also is hardly. So 161 is neither relevant. Yes. Now, first of all, the greatest difficulty it may be relevant, but it's not admissible. Then it's not part of the res geste. So 161 rely करंतु because I can't say that 161 statement either for the prosecution or for the victim. Mr. Ponda will say that I will rely on 161 statement. I cannot. That's a difficulty for a court. Yes. Anything else? So far prima facie is concerned, at this stage, those persons who have not been examined at all in the court at law, their statement can be seen as a prima facie. That is my prima facie which pale ni order 13 rule 1 and 2. So prima facie na co prima facie. Prima facie whether the accused is involved in the crime or not. So who is saying that he is not involved? That makes the point. Then sir, we are not discussing whether he is not involved. Yes. Sir, Sedale, I think Mr. Ponda would have taken up with the fit of his voice. So Sedale nobody has named him, is not named, no statement. No evidence. That is not his argument. And the statement of the wife of the present petitioner and father of the present petitioner can be same statement which referred by Mr. Kotkia or some other statement. Kotkia has not referred the statement of the father. Father to say that his wife kotha jo any other statement, the same statement. Okay. then father कौन कहले? That you should have the statement corroborated the wife what he has said. Oh, father corroborating wife, then it's not necessary also.
Yes.
Okay.
And other night ହେଲା Sabha Chandi. And purchasing, brought the tire also corroborated by the.
ଆପଣ ଯଦି କହିଥାନ୍ତେ ଯେ father has also something said which is equal incriminating, that because you are saying father has corroborated the accused wife's statement.
Yes. And one Satya Bhai, who is the witness to the seizure,
He has seizure କଥା ଜାଣନ୍ତୁନି କାହିଁକି ନା ସାର୍ dispute କଲେ ସିନା ସିଏ. You are just ମାନେ banging your head on the wall. So that ଆପଣଙ୍କର ମାନେ instead of ସତ ମାନେ ଆପଣ ଯୋଉ ଟିପା ଜାଗାରେ ସତରେ ବାହାରିବ ରକ୍ତ. କାହିଁକି ନା ଆପଣ ପ୍ରୋବ୍ଲେମ ହଉଛି ଯେ ଏକ୍ସିଡେଣ୍ଟ ଆର୍ଗ୍ୟୁ କରୁନାହାନ୍ତି. ସିଏ କହନ୍ତି ଆଜ୍ଞା there is no statement. Then you have to bring this 164 statement. There is no mention regarding this person. You have to state that. So please be conscious of what is the submission of the.
why I am saying that this seizure, Satya Bhai.
So because Mishra, you are assisting the prosecution. Your role is to assist the prosecution.
Yes.
If prosecution has missed anything, then you say, or you are replying what Mr. Ponda is saying in favor. Then you are assisting the thing.
I am assisting the
So he
prosecution.
has said all these things.
Satya Bhai's statement is clear regarding the seizure of the layers of the tire.
हुंतु कि मिथ्या मिश्र हुंतु, it is immaterial. It is not disputed. Not disputed. That's the problem.
That's all. My friend wants to say.
Yes. Mr. Kotte, anything else to you have to say?
No, I just want to.
से जो चेक कले सेटा एफआईआर है कि कोन हला
FIR है.
है कि कोन हला तार इन्वेस्टिगेशन में कोन बारो
I have to get the exact FIR. It is
एफआईआर तो लेवल किछि एनीथिंग अगेंस्ट दिस लोकडा विषय मारछि किछि जो लोक विषय
FIR टा हेछि गोटे.
एफआईआर तो हेछि से कहले नि आपण सेटा कहले जे रिपोर्ट हेछि से जो द विटनेस वॉलंटियर्स टू से दैट
I have a small argument with the lordship.
Hmm.
That is because that victim was taken to Bhavanipatna from Chandotara Chowk to Bhavanipatna by the principal accused Govind Sahu, let us say. And she was alive there.
नहीं प्रॉब्लम कौन है कि वर्तमान दिस इज नॉट अ बेल पिटिशन फॉर गोविंद साहू.
I'm coming to that.
So whenever you are arguing even prompted by the prosecution,
That I have kept in mind.
no, not only that, you have a much bigger role because they don't understand. Overzealous investigation, overzealous citing of witnesses, overzealous trial always favors whom?
It is
So this is academic.
Yes.
This is pure academics.
It was
I'm conscious of what I'm saying.
yes.
It favors whom? Whenever there is overzealous investigation and argument and materials, it favors whom? According to your perception, as a lawyer, responsible lawyer.
Accused Govind Sahu.
No, it always favors anyone who is the accused. Say XYZ J1.
Yes.
General theory hochi, whenever you go beyond the purview of investigation, become overzealous, so you are not helping the prosecution.
No, it is not overzealous.
The problem is that again you are there. Again you are connecting to this case. And I didn't say that. I tell you that you have the responsibility because they don't understand this.
Yes.
They have a problem of understanding this.
Yes.
You have to true to the prosecution. If you want to true to the prosecution, always stick to the basic facts and try to highlight that.
Yes.
Anything overzealous is against the interest of your clients.
Yes, ma'am.
Yes. So that you must remain conscious.
Yes, ma'am.
Yes. So you see, excitement and overzealous, this kind of thing always spoils the case.
Yes.
For prosecution.
That is always
Because you see, because there is presumption of innocence. Again, I cover coming. So it is not that he has simply, what is the job of the defense? He has simply to disprove, dig holes into the prosecution story. So once you make it flamboyant and all these things, it becomes much easier for the defense to
yes.
dig holes in your case, and any hole in the prosecution case is a favor for obviously.
Yes.
And in this kind of case, is there anything that the burden of proof ever shapes? Nothing. The burden of proof always lies on burden and onus both are on you.
Always lies on.
This is not that kind of a case that the burden will shift to the person.
No. In a criminal, this is a criminal.
Then you refer to the basic, but I mean, solid, rock solid evidence, rock solid material. Kind of patthar ke lakir. Other than this, ki kaun koila, ekala, sekala. So that I was trying to convince Mr. Misra that you are not, I am not rejecting any evidence, not convicting or not acquitting anyone. Yes. Yes.
Bail appeals are like a
Absolutely.
prosecution.
Absolutely. So bail the jaha parameters thibo se arohi. Test kariya podi. And was publicity of the accused is not. I mean, I think they are not. I remember what he said. He is not disputing complicity of accused. Complicity is there. Whatever punishment that whatever the final he will be there. Yes. Now please carry on. Because keeping that in mind that your role is different.
No, I'm just thinking to one point because the victim elector house went to the. I'm just point by point. Went to Chandrakara check. There was a shop Chandrakara check from where was he by the vehicle of himself. He went to she went to Bhavanipatna, and till Bhavanipatna was she was in touch with her friends, and thereafter from Bhavanipatna she was brought to the Mahalingam. So after coming after traveling a certain distance, thereafter was her mobile was switched off. Then what happened that only the person who is no more, the accused Govind Sahoo, he knows. But point is whether the deceased died while she was being carried by the vehicle from Bhavanipatna to Mahalingam, or she died, or there was life in that body while the body was put in the dish and she was burned to death by using all this tire and other articles, wooden articles.
এটা ଆପଣ କାହିଁ କହୁଛନ୍ତି ମତେ କହିବେ? Yes. Yes. So why you are saying making this?
I'm explaining because only a body will be said to dead body when there will be no life in the body.
अरे सीधा कहीं के discuss करूचे जे whether there is life in the body or it was brought.
Because section 34 is there.
No, 34 तो छाड़न्तु. 34 नहीं बोला कहली कि आपनको. आपण एटा जो आपण after आपण what you are arguing I cannot follow.
Yes, I'm explaining it. I'm explaining it.
मैं कौन पैसे डा अरे पर्पस आपनकर कौन let us assume दुटा कथा हबो. The body the person was alive, brought alive and charged live in that pit.
Yes.
Let us assume because she was already dead. By some means.
Then if that was assumed, then this person has assisted Govind Sahoo in providing all this.
State material कौन अच्छी कौन दो state? State state कौन तो जैसे he assisted in that is does it form that part of the prosecution story that he assisted in killing? State में कौन तो that?
Yes, the Govind Sahoo instructed the petitioner to go to certain shop. To certain person. Sort of that's like I'm reading that person.
Yeah, right. One no problem. आपन निजो को track पड़े लें. Then गाड़ी रे बलांगीर रू बाहरी ले बलांगीर रू बाहरी की महालिंगम गले भवानीपटना गले X जागरू बाहले let us not take names XYZ गला ता भितरे this fellow has assisted him. सेटा में come to that. Yes, that evidence. So he was in touch with the accused. Assistance आपन तो CDR कहिले आजने कथा होतिला because if he was available to be there, Mr. Kotkia, what you are saying, I said that don't be overzealous while submitting.
Overzealous only.
Sir, you are putting up to contradictory theories. A fellow who is available and participating, he is not to be contacted over phone.
No, he was at Mahalingam with this person.
You see, if I found out his CDR, then you must know what is his location was over the phone.
Yes.
So then you are saying two things completely opposite.
Yes, Lord.
This fellow actively participated in bringing that body dead or alive.
Yes.
He was complicit in committing the murder. Then he was not required to be contacted over phone. What was his location when you must have determined? What was his location?
Yes, location of the.
You see, Mr. Patkia, anyhow, I'm not be giving any comment on that.
Yeah.
Please be sure. Because I'm sure that I'm conscious that I'm not no observation regarding merits. But upon that, since it's a serious courtroom deliberation, that he participated in the crime, then you are spoiling your case.
Plus,
because by saying so, he actively participated in murdering the victim.
No, that is there.
No. Please allow me to complete. You have said that there is a possibility this fellow assisted if the body was live. Then why he was required to be called and why his location was something else? Because then either you saw both the persons were present in the car by showing their location, or you say since there was no communication between them, he was there himself. No, let us assume he was carrying a mobile phone. or not carrying a mobile phone. If he's not carrying the mobile phone, then you cannot know his location. If you know his location, then you present it before the trial court. Yes, but don't say yes on the face of it, which is contradictory. If he is being contacted continuously, because your story, Mr. P.K., Mr. Mishra's story, Tushar Mishra's story, is that he was continuously in touch with this person, CDR says. So if that is so, then how he actively became participant there? Because you are attributing yourself. Yes. The problem is that you are attributing yourself. It's not that it is the defense story, because defense has not come with any alibi. Let us assume defense will come with an alibi. Then you can say, that alibi, you have to simply, your job is to simply to prove the alibi wrong. Yes. Because that's it. But anyway, yes, you carry on. But be conscious that by propounding completely contradictory on face of it, you are not helping the prosecution. No, with due respect, I am reading a portion with greatest of respect and utmost knowing all of your practice background. I must say this. This actually should not happen from you. On the one hand, you are saying he was in constant touch with the CDR. Second leg of your submission is that he actively participated. Yes, let me probably I am not clear. No, you are so clear. You are so clear that I am giving you a clear response. It's the other way around. You are so clear in your submission that there is a possibility that he actively participated. Then you present that before the evidence and the trial. Let him press trial. Why you have let him off then? No, he was why you have let this person off in a heinous crime? If you have direct evidence against him that he participated in the murder, yes. I have three of you said that. Why you have let him off? That is 120B and 34 there. 120B, 34 is something else. Who said you read that other day that he also serves who stands and waits. And 360. So that decision where Mr. Das cited the Privy Council or Rangoon.
That is that
AR 1925 Privy Council, page 1.
25 Privy Council is there. What a 25 Pakana also no Punukari Kota, Babli Magisha, Purguru. Punukari Kota, Babli Magisha, Pakana say series no. Apanakara, 8 hours is a same. Apanakara, complicity proof Korea. Standing is enough. Standing is enough.
There the accused was the brother of Aravind Ghosh. And the Privy Council said they also serve those who stand and wait. The plea was John Milton that he had never entered into the post office and was standing outside.
That said, Mr. Pandey is saying that we have all read as law students, as to still I continue to be a student. So Pakkalara revelation is something else. The trunk murder case is something else. But complicity is enough. You have to simply show that he was guarding. That's enough. So that's not a problem. So that is why I was telling Mr. Mishra that I am not now accepting or rejecting any evidence. So that is how they quoted that poem of John Milton. It's a poem, part of the poem. Stanza, I got one line of that poem. So that is another thing that always in law school, they'll put this question that they went to Dhaba Milan and had food. So whether that will happen for food at Dhaba Milan will amount to 34 or 120B, that was the question. So that's another thing. So basically no one can escape. If he's a party to but if he has participated, then the evidence you have presented, you have let him off. There is no evidence you have produced. Rather, contrary evidence you have produced that he talked over phone, you have the CDR, his location. Yes. So location, participation and talking over phone are juxtaposed. Please appreciate that. Different places. Yes. Going south, the accused was coming from Bhavanpatna on the way. There will talk and other part is that you are also highlighted this post occurrence activity, bringing the tire. Yes, there is a possibility you are saying that in the pit when the unfortunate person died, she could have been alive also. Yes, but basically for prosecution it is not a problem also. When she died, either she was destroyed or she died alive. Both the things, it's a murder, still a murder. But if you are in doubt whether she is alive or not, I am not arguing for the loss. No, sir. It is even since it is quite debated and all that since last two, 3 occasions. So I want to be sure that whether anything is left, which Mr. said that this is left. father's evidence. But ultimately he says that father only corroborates the wife. Doesn't throw any more light on that. Right. Yes. Anything else, please?
No, I will not argue any further. No, so I will give a stop note if required.
The note is not necessary. Because one thing be sure, I will not be delving into any kind of evidence. The reason being, again, I have to, whatever the observations I am giving, I will be referring to these submissions and all these things. There are witnesses. I must say that there are witnesses. There are witnesses regarding his, what you can say, you can name them. ମାନେ you can say, ଆପଣ କାହା କଥା କହୁଥିଲେ PW କେତେ କେତେ କହିଲେ ନା ଭୁଲିଗଲେ ପରେ
ନାଇଁ ମୁଁ ଭୁଲିନି
କହୁନାହାନ୍ତି ତାହେଲେ ଫଟାଫଟ କୁହନ୍ତୁ
PW relying upon that PW 9, 11
ଗୋଟେ ମୁଁ ଆପଣଙ୍କ ସଜେସନ ଚାହୁଁଛି to all three of you, Mr. Panda also, very senior and seasoned. Why should I refer to anyone? Because again I will clarify that either prosecution or the defense, it shall not. I am not giving any opinion. It shall not be. So that is how I try to avoid. ଆପଣ PW ପରେ ଆପଣଙ୍କ once 14ଟା ହେଲା ପରେ Mr. Mishra ମୁଁ କାହିଁ କହୁଛି PW 15 ଭିତରେ examine ହବ, something incriminating will come against him.
yes
Nobody knows.
trial should
PW 168 ଯିଏ ହବ 168 ତ PW 168 examine ହବ
169 ଅଛନ୍ତି
69 କୁ examine ହେଲା 69 PW 116 15 ରୁ 169 ଭିତରେ କିଏ ତାର ବିରୁଦ୍ଧରେ କଣ କହିପାରିବେ? So why to speculate on that and say that something is because you are saying and yes,
PP may decline many of the witnesses may be declined by PP 168 को सत्र होचंदे similar statements of prevalent कौन PP has always the right of course so there are many witnesses may be
problem लगा कि आज जहाँ discussion है ना अपन जो कह देंगे अपन का जॉब भी सारंग तो है सीधा होगा anyway because no Mr. Katko, it's a Herculean task. It's a Herculean task to, I mean, if I can use the word, juxtapose the evidence of all. You never know. You character if I use the language, but it's very difficult to present a story, and your job is to present that. Their job is to dig holes. Then anything else you have to say, Mr. Panda will begin. Okay. But the rejoinder. It's a rejoinder कौन होगा? No. हाँ ठीक है. Yes, Mr. Panda.
Well, my respectful submission is this.
So, Mr. Panda, one thing. So, we are not differing with Mr. Kotkia as far as the PW's 164 statement is concerned. Same thing with Mr. Mishra.
I am
and 164, but yes, your submission is that as far as incriminating material is concerned, whether that is incriminating, but there, Mr. Panda, that's not a consideration for a bail court. It may be incriminating, it may not be incriminating, still a person will be refused bail. Because it is too early to judge it.
I agree.
Yes.
But nevertheless, your lordship must be made aware of the fact that the statement that has been made before your lordship,
that's it. The monster ଆପଣଙ୍କର Mr. Kotkia ଦେଲେ ଏ ଯୋଉଟା ସଜେଇ ଦେବେ ଟିକେ ସେଇଟା ଟିକେ ଆଙ୍କର Mr. ପଣ୍ଡାଙ୍କର ଏଇଟା ବି ସଜେଇ ଦେବେ
part of the documents check କରି ଦିଅନ୍ତୁ
ସେଟା ପେଜ ମାର୍କ ନାହିଁ ତ ବହୁତ ଡିଫିକଲ୍ଟ ହେଇଯିବ
deposition ଟା
ନାଇଁ ପେଜ ମାର୍କିଂ କରିଦେବୁ ସରି ଡେଟଟା ଦେଖିକି ଦିଅନ୍ତୁ ପେଜ ମାର୍କ ନ ହଉ ପଛେ କିନ୍ତୁ ମୁଁ ଥରେ ପେଜ ମାର୍କ ନହେଲେ ଇଟ୍ସ ଡିଫିକଲ୍ଟ ଟୁ ଗେଟ୍ ଦେଖିକି ଦିଅନ୍ତୁ ୟେସ୍ ମିଷ୍ଟର ପଣ୍ଡା
Lord, your lordship may first take into consideration the timeline.
Okay.
The disappearance of Mamita Meher is said to be from 8/10/2021. FIR is lodged on 13/10/2021, wherein I am not named by the brother members.
Principal accused is named?
Principal accused is named. Now, my lords, as per the prosecution case, I was brought into the picture on the basis of a statement made by the co-accused leading to discovery. This discovery was of what? Was of certain bones, fragments of bones, which was subjected to DNA analysis. Now, the charge sheet which has been filed, the charge sheet says like this against this petition. That investigation reveals, this is I am placing from the charge sheet, paragraph 2.19 millions. Investigation reveals.
Yes, may I just interrupt you for? You are saying the probability of prosecution story could be such that they will not be. I mean, it's feeble. It's not. It's weak.
Right.
So that's a short point you are making. You don't have to go to the
What I
details.
intend to submit is prosecution makes a lot of brouhaha about my association with the main accused, Milords. Admittedly, Milords, they agree that I am his car driver, Milords.
No, to that extent, they're fair. They don't say it, they don't dispute that you are an employee and you are a regular employee. Regular employee. They also admit to that extent, you must also give them compliments for their fairness.
Yes, Milords.
Yes. They don't say anything else. Yes.
They also agree, Milords, that when the deceased was allegedly alighted from the bus and picked up in the Wagoner vehicle, of which they have taken camera shots and other things, I was nowhere in the picture.
No, you must have heard that Mr. Katya says that clearly.
Lord,
Mr. Mishra also. Because Mr. says he is recovered, but there is no implication there.
What I am saying is this, that their records itself make it clear that I was not involved there and I was not present there.
They say there is a possibility.
This, what they have recovered, the camera footage, Milords, from the bus stop and other footage which they have collected, nowhere, Milords, my presence is there.
I will not comment on that. I have comment on the merits of the prosecution.
I am only replying to what the prosecution is saying. In any event,
I persuaded them to avoid that.
yes.
But since they have said you will reply, I understand.
In any event,
Please, sir.
it has been stated by my learned friend appearing for the state that there is a statement of my wife and the statement of my father as said by learned friend appearing for the informant, and which has led to recovery. There is no recovery, Milords.
No, it is little bit. You may be right in saying so, but they say that the bag belongs to the deceased. They have taken the statement of the wife from whom the bag was recovered.
No, Milords.
The bag was recovered from whom?
Yes. The bag was recovered, Milords. The seizure list was made on 27/10/2021 at 8 p.m. at Sindhikala Police Station, Balangir, Milords. And the recovery, Milords, is of certain key rings, driving license of the petitioner. I am placing the entire thing. Insulin glargine injection IP, Rexona aloe vera underarm odor protection roll-on, 25 gram Odomos non-sticky mosquito repellent cream packet, 25 gram Odomos non-sticky mosquito repellent cream tube without cap, key ring with a white red color small doll, key ring with a purple color plastic god Ganesha head, 20 gram wild stone forest spice deotak, empty dark brown color small Arundhati jewelers plastic box with a pink color cloth pouch, Honda key attached with 2 steel rings with a steel belt embossed on Kalia Honda Kontabanji, telephone numbers on one side, another side authorized service center Honda, 1 Khimji identification report small card, summary number such and such in a polythene packet, 1 Indian Union driving license smart card, name of Radhasyam Chandi, son of Chakra Chandi, address Mahaling PS Kega, issued on 16/18, tax invoice, customer copy of Arundhati jewelry.
So you are saying I died. So that is how I tried.
Yes, Caesarity from Dr. Prakash Kumar Malik at post Odhua, PS Basudevpur, district Bhadrak, at present SO DFSL Balangir. There is not a single Caesar list in the records.
I knew this, Mr. I was persuading them. Don't go into that because this will be now never-ending story.
It has not been supplied to me. If this is
Again, Mr. Ponda, I'll not refer to that. I'll not refer to that.
Yes.
I'll not say refer to that. That they say that they have recovered. You say that nothing was recovered because it's a matter of trial.
the recovery is here. The Caesar list is dated such and such.
12 was already stated.
No. You see, now you realize that from the beginning why I said you, rather requested or persuaded you, because once you start this, then it becomes a shadow trial. He will answer this. Now he has answered that belongings, what he is saying, that belongings of the deceased was not recovered. That is a short submission.
Now your lordship may see a submission.
So anyway, I'll simply say that you bring certain things that to contradict the
I
statements.
say that there is nothing on record to corroborate those statements. That's submission.
That is your comment, and I'll not observe anything on it because I'll not go in that track. I'll simply consider the bail, say that they have made your submissions. You have said that there is no. You reply to that, stating that these are not correct. Yes.
Reliance is placed on the evidence of that witness. That is PW 11 millions. Saurabh, yes, applied.
Yes.
Please look at PW 11. Saurabh Das.
I told them, both Mr. Mishra and Mr. that don't start, but as if we are in a trial of this thing. Yes, 11, so Saurabh Das, please.
Paragraph 2.
Yes.
Before that, your lordship may see what he does. Where I am, CSC center at Mahalim. That is, he has a service center, that citizen service center at Mahalim. He says at para 2, I was examined by police in connection with this case on 29/10/2021. On that day in the evening hour, IIC Kontabanji came to my cask, showed me a bank statement of deceased Mamita. He inquired if I had deposited rupees 7,000 in her account on Saturday, 10/21. I replied affirmatively. Thereafter, IIC sought for the history of the statement, to which I supplied. He also asked me at whose instance I deposited the money. To his query, I replied that Govinda instructed me over phone to make the deposit, to which the accused Radhasyam will pay in my kiosk.
This is Radhasyam.
I am Radhasyam.
Okay.
Then accused Radhasyam handed over the cash to me, which I deposited in the account of Mamita Meher.
So to that, Mr. Katia has been fairly, he has said that he carried the money. He did not say anything else. Maybe it was somewhat more.
I mean, no connected with this.
Mr. Mishra might have said
Exactly. Mr. Mishra said, so I am replying. Now, there is another allegation against me. The reference is to PW9 statement. Would your lordship see PW9? That I have certain witnesses. Has your lordship got it?
Yes, 9 is
Gudul Harijan.
Yes.
I do not know the informant Bunty, name suggested by special PP. I know deceased Mamita. I know accused person standing in the dock. Then, what my learned friends rely on is, witness volunteered that there is threat from the side of the accused. Today, agents of the accused persons went to his house, gave threatening to him not to depose the truth and to divulge what they will instruct him. I believe my learned friend for the state placed emphasis on this.
Yeah.
Now, would your lordship see what he has stated? My lords may look at his cross-examination.
She was cross-examined on this volunteer statement because he was on dock.
Yes.
He addressed a key date again.
Aଜ୍ଞା cross-examination କହିଛି. I do not
ବକରେ ଯାଇକି ଏଟା କହିବା ପାଇଁ କିଏ କହୁଥିଲା? ସେ ତ ଏଫଆଇଆର ଦିଆ ହେଇଥିଲା.
ନା ନା ସେତେବେଳକୁ ଏଫଆଇଆର କଥା ତ କହିଦିଏ ସେ କଥା
ସେ କହିଛନ୍ତି ଏଫଆଇଆର ଦେଇଛି ବୋଲି।
କହିନି କିଛି।
Yes, cross examination.
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ର ଫାର୍ଷ୍ଟ ସେଣ୍ଟେନ୍ସ ଟା ହେଲା ଆଇ ଡୁ ନଟ୍ ଫିୟର, ମୁଁ ଡରେ ନାହିଁ। ଟ୍ରାନ୍ସଲିଟରେସନ
Translated ହେଇଯାଇଛି।
In the morning hour, the agents of M.S.Sahoo called on me and instructed me not to speak. That I have seen in the case. What that record is. Person who called me in the morning hour are his relatives. One Kurti Chandan and Ranjit Sahu have given me threatening not to speak the truth. It is a fact that Kurti belongs to different caste to that of accused Govinda. Family members of Govinda have been residing in his house. Ranjit happens to be nephew of accused Govinda. House of Ranjit and Govinda is opposite each other, being intervened by the village road. Not a fact that the family members of Govinda and Ranjit are not in talking terms. House of Kurti situates at a little distance but in a different side. So, what has been recorded by the learned trial court millards in brackets after his chief has been recorded that he doesn't know the informant and knows the deceased and the accused persons. That has been clarified in cross-examination that the persons
Paragraph. Cross.
paragraph 5,
Yes.
that the threats were at the instance of the deceased accused, not me.
Yes.
I believe I am clear.
Yes. I don't know. He was whether he was advised by the PP to state this in the doc pending in examination in chief without the FIR on record. Because the issue is that this will not prove the complicity of Govinda Sahu even.
Exactly. But I can't say all on that.
No, obviously you are not saying, but I will do that because next discussion is much better. Yes. I will not go anything that.
Defense
His job is to prove the complicity of Govinda.
defense counsels are a vanishing breed, millards.
Sorry? Vanishing.
Defense counsels are a vanishing breed.
Of course. It's a great art and and India has a tradition of 200 years or more than the defense counsels. The original British counsels who are in Bombay, Strangman and all that.
I traveled to most of the sessions divisions. Earlier, I used to see people of caliber there. Now they are no longer there.
And that
Nowhere. Then, millards,
So, that day I was referring to Sardar Rajinder Singh.
yes, Mr.
I
Raj.
couldn't recollect his name. In Madhya Pradesh. His Sardar Saab's son is there, so he's also practicing.
He has come and appeared in this court several times.
That discussion we were having, that how precise, how categorical he was in his while moving the bowl of Jhabbar. That
He was arguing in J.B. Patnaik's matter also in that special court.
I saw him that he used a very big this magnifying glass with a inbuilt light. Because he was able to read the letters typed out even.
Then, millards, the entire prosecution harps about death. They have not been able to establish that Mamita is dead from their own records. I have filed.
To that extent, let us not go. We are not on the trial.
Yes. No.
So
It's not that we are on trial.
I understand.
I'm being charged under 300.
Mr. Wanda, in one line, you are saying there has been homicidal death has not been proved.
Yes.
I understand, but I will not say anything.
That's why I have annexed the DNA report.
DNA is not matching. That's okay.
Yes, that's what the DNA report says.
Matching.
So let him read them. You see, the problem is that because that is how I persuaded you. Please don't go into the.
Contents 26 of my brief.
Don't go to the contents and the exact thing. You make your submissions so that it will be. Annex 3 copy of the DNA results.
Yes, my lords may see page 26. It begins at page 25. The DNA profiling evidence for establishing identity. Now, the results of the examination is at page 26. the examiner writes, source of exhibit 1 completely burnt was not found suitable for DNA analysis. Sources of exhibits L and M were not subjected to DNA extraction.
Sir, you are reading, sir, 26.
26, the first line I am reading.
Oh, acha, top.
I.
I went to the conclusion top. So anyway, yes.
The source of exhibit 1 completely burnt was not found suitable for DNA analysis. Sources of exhibits L and M were not subjected to DNA extraction as they were from the same sources as that of exhibits K and J respectively. Sources of the remaining exhibits were subjected to DNA extraction. Global filler was used as a trademark. PCR amplification to generate DNA profiles. Genotyping was performed on ABI 3500 genetic analyzer. Data was analyzed by using gene mapper, IDX V15 software. Hypervariable regions SV1 and 2 of mitochondrial DNA were amplified using mitochondrial.
This is the method.
Yes.
This is the method.
My lords. Results are sources of exhibits A, one long hair said to be recovered from the crime scene. B, one long hair said to be recovered from crime scene. C, one long hair said to be recovered from crime scene. D, one long hair said to be recovered from crime scene. E, two long hairs said to be recovered from crime scene. F, one long hair said to be recovered from crime scene. G, a piece of burnt bone said to be of the deceased victim. And H, few pieces of burnt bone said to be of the deceased victim did not yield autosomal DNA profiles. You may see here underlined that they did not yield. So due to destruction of DNA material. Yes, I don't deny that. The sources of exhibits J, bloodstain said to be of Mrs. Tulsi Meher, this is the mother, and K, bloodstain said to be of Suchandra Meher, yielded autosomal DNA profiles as shown in enclosed table 1.
Yes.
The source of exhibit G, piece of burnt bone said to be of the deceased victim, yielded mitochondrial DNA profiles of HB1 and HB2 regions and are not matching with the mitochondrial DNA profiles of HV1 and HV2 regions of the sources of exhibits J. Bracket में bloodstain said to be of Mrs. Tulsi.
What happened to K? Did it match with K?
K कथा था
Okay. So let us not discuss. Amara, it's
conclusion the deceased victim is not matrilineally related to the source of exhibit J. Hence, biological relationship of parent offspring, mother-daughter does not exist between the source of exhibit J and exhibit G. This is as clear as crystal, I believe.
Yes, but no comments now.
No, I am not asking your lordship to give any comments. I am only responding to what the prosecution
I understand that.
I am compelled to respond because of the vigorous statements of the prosecution that yes, it matches. But either my understanding of the language is incorrect, or I have not read the language properly, or I don't know the grammar. But what I understand from what I have read and understood from the language for the last 60 years, my lords, I believe, is that the DNA profile did not match with that of the mother. I believe I am correct and I am clear to that extent. So therefore, my lords, my submission is that I have been in custody for a considerable period.
You are in custody since?
I am in custody since 21/10/2021.
Yes.
Trial will be protracted. It is protracted. Evidence on record, my lords, at best makes out a case of me assisting the other deceased co-accused in destroying evidence.
Or burning the...
It's not one thing, my lords, about that.
No, Mr. Panda, since you have studied to a certain extent the details of the evidence.
Miller.
So, what about their theory that she was alive till she was burnt in the pit? Have they adduced in evidence? theory is there.
So far, there is no evidence adduced in trial. Nothing also in the 161 statements or 164 statements on record. Rather, what their charge sheet says is that their scientific evidence says that the deceased and that Mamita Meher and the deceased co-accused, they were together from the bus stop till Millard's, the body was disposed of, which they say was disposed of in the pit. And so far as this Vikas Agarwal is
The
concerned,
question is like, have they tried to put that question in the trial?
Never.
I mean, proposition, not a question.
never. Not to the informant, not to the victim's father who have been examined.
No, they have a difficulty, limitation also. If they try to prove an alternative theory, then this question I was asking.
These things, Millards.
Yes, Mr. Devas. Anything else from anyone?
I'm only about that tires, Millards.
Okay, pass. Yes. So call that.
I'm only placing the 164 of that Vivek Agarwal there to tires as there. I'm not placing the 161. ସିଏ କହୁଛି
Page, sir. PW.
It is 164 statement.
164.
Nah. Okay. Vivek Agarwal 164.
Yes, 164.
Vivek is charge sheet witness number 48, I believe. His charge sheet witness number 81. His statement is ମୁଁ ମାହାଲିଙ୍ଗ ଗାଁର ଗୋବିନ୍ଦ ସାହୁକୁ ଜାଣିଛି। ଆମ ଘରଠୁ 3-4 ଘର ଛାଡ଼ି ରୁହନ୍ତି। ସନସାଇନ୍ ସ୍କୁଲର ମାଲିକ ମାହାଲିଙ୍ଗ କଲେଜ କମିଟିର ପ୍ରେସିଡେଣ୍ଟ ଅଟନ୍ତି। ସେ ଆମ ଗାଁ ସ୍କୁଲ ପଡ଼ିଆରେ ଏକ ମିନି ଷ୍ଟାଡିୟମ କରିବା ଠିକା ନେଇଥିଲେ। ମୋର ଏକ ପିକଅପ୍ ଭ୍ୟାନ୍ ଅଛି ଯାହାର ରେଜିଷ୍ଟ୍ରେସନ ନମ୍ବର 1। ସେହି ଗାଡ଼ିକୁ ମୁଁ ଗୋବିନ୍ଦ ସାହୁର ବାଡ଼ି ଯାହାକି ଆମ ଘର ପଛପଟେ ଅଛି ମୁଁ ସେଠାରେ ପାର୍କ କରେ। ଗତ 3 ମାସ ତଳେ ମୋ ଗାଡ଼ିର ଜେକେ ଟାୟାର ଖରାପ ହେବାରୁ ମୁଁ ବଦଳାଇ MRF ଟାୟାର ଲଗାଇଥିଲି। ପୁରୁଣା ଟାୟାର ଗାଡ଼ି ପାର୍କିଂ ଜାଗାରେ ରଖିଦେଇଥିଲି। ଏହା ଗୋବିନ୍ଦ ଦେଖିଥିଲେ। ମୋର ଗୋଟେ କିରାନା ଦୋକାନ ଅଛି ସେଠାରେ ମୁଁ ମୋ ଭାଇ ଅନୁପ ଦୁହେଁ ବସୁ। ଗତ 8-10-21 ଦିନ 12:30ରେ ଗୋବିନ୍ଦ ତାଙ୍କ ଫୋନ ନମ୍ବର ସଚରେ ମୋ ସାନ ଭାଇ ଅନୁପକୁ ତା ମୋବାଇଲକୁ ଫୋନ କରିଥିଲେ। କହିଥିଲେ ତାଙ୍କର 2ଟି ଟାୟାର ଦରକାର ଅଟେ ଓ ଆମ ବାଡ଼ିରେ ଥିବା 2ଟି ଟାୟାର ଦବାକୁ କହିଥିଲେ। ତାଙ୍କ ଡ୍ରାଇଭରକୁ ପଠାଇବେ ବୋଲି କହିଥିଲେ। ମୋ ଭାଇ ମତେ ସେ କଥା ଜଣାଇଥିଲା। ପ୍ରାୟ 3:30 ବେଳେ ଗୋବିନ୍ଦର ଡ୍ରାଇଭର ରାଧେଚଣ୍ଡୀ ଗୋବିନ୍ଦର ଧଳା ସ୍କୁଟି ଆଣି ପହଞ୍ଚିଲା। ଆମେ ତାକୁ ସେ ଟାୟାର 2ଟା ଦେଲୁ। ସେ ନେଇ ପଳାଇଲା। ଗତ 19-10-21ରେ ଟିଭି ନ୍ୟୁଜ ଦେଖି ଜାଣିଲୁ ପୋଲିସ ଷ୍ଟାଡିୟମର ଗାତରୁ ପୋଡ଼ା ହାଡ଼ ମାଂସ ଟାୟାର ପାଇଛି। ଗୋବିନ୍ଦ ସାହୁ ସନସାଇନ୍ ସ୍କୁଲ ଶିକ୍ଷୟିତ୍ରୀ ମମିତା ମେହେରକୁ ମାରି ସେଠାରେ ପୋତିଥିଲା। ଏହା ମୋର ବୟାନ ଅଟେ। ତେଣୁ ଦିସ୍ ଇଜ ଦି ଷ୍ଟେଟମେଣ୍ଟ ହ୍ୱିଚ୍ ହାଜ୍ ବିନ୍ ରେକର୍ଡେଡ। ଗୋଟେ ପିକଅପ୍ ଭ୍ୟାନର ଯୋଡ଼େ ଟାୟାର ଆଜ୍ଞା ରାଧାଶ୍ୟାମ ଚଣ୍ଡୀ ହଉ କି XYZ ହଉ ଗୋଟେ ସ୍କୁଟିରେ ଆଜ୍ଞା ଲଦିକିରି ନବା କେତେ ଦୂର ସମ୍ଭବପର ସେଇଟା both my learned friend on my right and my learned friend on the left will tell your lordships because I think they are used to riding on scooties or were used to riding scooties.
Usually they are calling everything generic ହେଇଗଲା। ନିର୍ମା ସବ ଯେମିତି ହେଇଗଲା ସେମିତି। So ସେଇଟା maybe it is active or whatever.
In any event, ସେ ଯାହା ବି
ମ୍ୟାନର ରେ ଶୁଣନ୍ତୁ ସେଇଟା ମ୍ୟାଟର ଅଫ ଟ୍ରାଏଲ ସେଟାକୁ ଆପଣ
ଯାହା ବି ହଉ
ସେ ଚିଫ ରେ କଣ କହିବ ସେ କେମିତି ଲଗେଇଥିଲା
ତାଙ୍କର ସବମିଶନ ହେଲା ଯେ ଏଗୁଡାକ ମୁଁ ସ୍କୁଟିରେ ନେଇକିରି କିଣିକିରି ଆଣିଥିଲି। ତେଣୁ ଏ କିଣା ଟାୟାର ନୁହଁ ପୁରୁଣା ଟାୟାର ପଡିଥିଲା
ଜଳେଇବା ପାଇଁ
ଯୋଉଟାକି ମୋ ମାଲିକ କହିଥିଲେ।
ସେ କହିନାହାନ୍ତି
ତାପରେ
କିଣିବା କଥା କହିନାହାନ୍ତି
ଏ ବିଷୟରେ କିଛି ନାହିଁ।
ଜଳେଇବା ପାଇଁ ଟାୟାର ମଗର ଆନ୍ଦୋଳନ ଯୋଉ ଟାୟାର ଜଳା ହୁଏ ଯୋଉ ରାସ୍ତାରେ ସେଇ ଟାଇପ ର ଟାୟାର
ସେ ବି ଆଜ୍ଞା କେମିକାଲ ଆନାଲିସିସ୍ ହେଇନି କି ସେ ଟାୟାର ଏ ଟାୟାର କଣ ଜଣା ପଡେ।
ମୁଁ ସେଟା ପଚାରିଲିନି ମୁଁ ସେଟା I believe not that I will not analyze the evidence in any manner either way.
In fact, I am also not analyzing.
No, I understand, sir. Your job is that you have to answer the propositions. I understand. But it becomes very difficult once we go in that way, that analyzing then. Mr. Yes, please. Mr. Devashish Ponda for the petitioner, Mr. Janmajay Kotakia.
One line.
Yes, please.
That is because that what my learned friend has submitted regarding the DNA report. So probably due to oversight, my learned friend has not seen one document of State Forensic Science Laboratory that is dated 9/11/2021. There was
Page ଅଛି କି? It forms part of the record.
yes. The actual source of the portion of the femur bone exhibit key who is identified as from the biological daughter of Suchendra Meher and Tulsi Meher. So the femur bone already identified ହେଇଯାଇଛି ଆଗରୁ ତାପରେ ଯୋଉ ହେୟାର ଗୁଡା ଅଛି ଲଙ୍ଗ ହେୟାର ଗୁଡା ସେଗୁଡା ମ୍ୟାଚ୍ କରିପାରୁନି ସେଠୁ କିଛି ବାହାରୁନି
ନାଇଁ
କୋଉ ପେଜ କରିଥିଲେ
ଆପଣ ଦେଖନ୍ତୁ ଡକ୍ୟୁମେଣ୍ଟ
ମୋ ଡକୁମେଣ୍ଟ
ଡେଟ୍ ଟା କହୁନାହାନ୍ତି
ଆନେକ୍ସର 3 ତ ଦିଟା ପେଜ 25 ଗୋଟେ 26 ଗୋଟେ
ଡେଟ୍ ଟା ଦେଖନ୍ତୁ ଡେଟ୍
ଆରେ ସେଇଟା ବୁଝିପାରୁନାହାନ୍ତି ସାର୍ ସେଇଟା କଣ ହେଲା କହିଲେ ଆଇ ଦେଖନ୍ତୁ 26 ରେ most like what is hinting ସେଇଟା that creates much more problem for you. The source of exhibit 1 completely burnt was not found suitable for DNA analysis. What is that?
that will be exhibit I below.
That is I Roman I is bone.
That is few pieces of burnt bone said to be of the deceased.
Mr. Katya, that he has not said. I am answering you that.
yes no
No. You have to see that. They will argue. The defense will argue now.
yes
Mr. Panda has not said that. That is not a good source of DNA was found by the laboratory of this Center for DNA Fingerprinting and Diagnosis Department of Hyderabad. So how that source could be utilized at the state laboratory to become a good source for DNA? That's another thing. More kind of discussions actually creates this problem. I'm not commenting that. But on the face of it, I'm saying. Now he will answer that. You see, you match what is your DNA source?
it is a femur bone
Burnt bone, femur ho ki jo femur bone ho ki jo bone ho. But burnt bone recovered from the thing.
yes
Then you have to then answer. Then why that was not produced if it is a different bone? Then why that was not sent to Hyderabad?
no that's
First question.
different
Second, what he will say, like he has now found out so many holes in your story. They will say, prosecution will say that this genetic material because of high degree burning, it destroys.
so that is long hair that is
No.
some person bone and long hair
One bone breaking 26. You have sent it to Hyderabad. What was burnt? I English capital I. What was burnt then? What is the source? Permission देखिए. Page 26.
ବେଲ୍ ପିଟିସନ ର
अरे 25 देखନ୍ତୁ 26 ଦେଖନ୍ତୁ ତାଙ୍କ ପିଟିସନ ଆନେକ୍ସର 3 ଦେଖନ୍ତୁ
yes
थोड़ा H ଦେଖନ୍ତୁ I ଦେଖନ୍ତୁ 25 ପାଇଲେ
19 ଅଛି
ଆଜ୍ଞା
up to page 19 ଅଛି
ପିଟିସନ ଟା ନାହିଁ ତାକୁ ଆପଣ କାଇଣ୍ଡଲି ହେଲ୍ପ ହିମ୍ ହି ଇଜ ନଟ୍ ଗେଟିଂ ଦ ପେଜ
ପେଜ 24 ହେଉଛି ଇମ୍ପ୍ୟୁଲ୍ଡ ଅର୍ଡର ସରିଛି ତାପରେ ପେଜ 25
ଟିକେ ଦେଇ ଦିଅନ୍ତୁ ଜୁନିୟର ମିଷ୍ଟର ପଣ୍ଡା କାଇଣ୍ଡଲି ଜଷ୍ଟ ହ୍ୟାଣ୍ଡ ହିମ୍ ଓଭର ୟୁ ଲୁକ୍ ଆଟ୍ ଦ୍ୟାଟ୍ 25 ଦେଖନ୍ତୁ ଆନେକ୍ସର 3
ଆଜ୍ଞା
लिस्ट देखो कौन कौन आप देले हैदराबाद कौन पठेले ଆପଣ ଲଙ୍ଗ ହେୟାର ପଠେଇଲେ ଏ ଟୁ ଏଫ୍ ଯାଏ ନା ଏଫ୍
yes long hair exhibit A
then GH ଦେଖନ୍ତୁ GHI ଦେଖନ୍ତୁ
bone bone
bone bone this is bone bone I ହେଲା ଯେ
yes
then bloodstone ଆସିଗଲା ହେଲା So GHI, you have sent, so that GHI is also, you have sent for at Bhubaneswar.
No. That is earlier plus other bone plus those were sent to Bhubaneswar.
Going to Sudan.
Yes.
That is that creates a that problem for you. Well, then why you did not send that? But then now you realize then कौन problem है गला अपन करो 26 को जान तू.
Results from the DNA test performed on the exhibits.
Just say the heading that first line just slowly पढ़ो.
Results from the DNA test performed on the exhibits provided are sufficient to conclude that the source of exhibit G, deceased victim, is not matrimonially
Confusion
to the source of exhibit.
I am at different line upon outer line. 26 रे first line टा पढ़न्तु. The source of exhibit I completely burnt was not found suitable for DNA analysis. So आपण sanctity ताले कौन रहला आपण search and seizure रे?
And the source of exhibit cell and M were not subject to DNA.
And it is good that now we are only having a waiting hall system.
Yes.
Because then if somebody is watching, then this kind of discussion doesn't help you.
No, you must be kind of.
So then आपण ताबरे कोन अलग पठेले अलग सीजर
fast bone
फिमर केंति जानिले हु सर्टिफाइड इट्स ए फिमर आपण तो आपण को होल थ्योरी होला जे इट वाज बॉन्ड चार्ज बियॉन्ड बट इट वाज डिस्ट्रॉयड
जो पार्ट हेई परलानी
इट कैन बी फिमर बोन एनी बोन बट आपण सेटा काई एठी होलान ताले
सेटा या बोले
ना सेमती हुए नहीं
21 exhibits plus 20
सभी इन्वेस्टिगेशन करा जाए ना विथ ग्रेटेस्ट ऑफ माने रेस्पेक्टेड क्वाज होनी करे इट्स ए पार्ट ऑफ द इन्वेस्टिगेशन आपण सब दिन गोटे नुआ जिंस सीज करी पठेबे कि आपण सुनंतु टिके आया यू आर नॉट आंसरिंग द प्रपोजल जस्ट सिंपली से आई एम टेलिंग व्हाट हैपेंड आपण जो साइंटिफिक एविडेंस कलेक्ट करियो सेटा गोटे थरा करा जाए और तार ऑटमोस्ट सैंक्टिटी मेंटेन करा जाए बिकॉज़ एनी कंटामिनेशन इन सर्च and seizure and packing will help the whom? The accused. So obviously आपण जदि एमिति कहिबे जे गोटे पठेलु हैदराबाद आ गोटे सैंपल पठेलु ये that will be a problem for you. आपण बोन रो GHI जोटा पठेछन हैदराबाद से खाली आई टा रेफर करछंती एंड जोटा को बेस्ट सैंपल मोस्ट लाइकली सो दे चूज द बेस्ट सैंपल जोटा अवेलेबल थिबो. The DNA material has been charged, bond due to high degree bonding. Those materials which are sent to Hyderabad, but some bond bins haven't sent. What is the requirement for sending into Hyderabad? No, that is because so never present an uncertain story in any kind of trial. No, that is what you are making it so vulnerable. No, because there are some bones yes, which are if you are serious in trying an accused. These are not to be done. No, there is no first attempt, second attempt. No, say report ता कोठी अछि देखियो कोन ता डिस्क्रिप्शन कोन अछि देखियो हम से देना मु दे दु जब सेटा ता माने नाही ता देरे से देना सेटा अरे चार्ज शीट रे सेटा अछि की एविडेंस से मार्क के एग्जिबिट केते कोन नांती सीधा तो कहिबे सी सो दैट सी जानिबे हु टाइम एग्जिबिट तो मार्क हे नो बिकॉज़ दे हैव नॉट बीन एग्जामिन्ड. But list of documents कौन ता गोटे थिबो तो हैला कौन से that is because report dated 9/11/2021
केते सीरियल नंबर केते कहले चार्ज शीट रे
एटा एग्जिबिट A टू
कॉलम 10 रे डॉक्यूमेंट्स रे केते लिस्ट
देखि जंदे आपण देखि ना आपण कोन आंती
मु केन देखि छु
आपण भलो देखि Let's claim achieve therefore the source of person of failure when exhibit Q is identified as from the biological doctor Suchandra Meher and Tulsi Meher and clause 3 lekha jo autosomal DNA profile generated from exhibit A12 one short hair with root and A14 one short hair with root and matching with autosomal DNA profile generated from exhibit A something out of M.S.Sahoo on God's cloth report table 1 of annexure A. That report is of 9/11 गोविंद साहू से प्रेजेंस कोरबेट करछला गोविंद साहू कथा पड़ी सेटा अछि आपण कोटा प्रोड्यूस कले जोटा कहउछन जे मैच कला बोली ताको संग रे को सेटा की करू उसका पार्ट ऑफ रिकॉर्ड एंड ही मस्ट मु बाबुली देखिना देखिना स्किप करू जानि
देखि कोन
प्रथम प्रूव इज
ये प्रूव पीडब्ल्यू केते नंबर प्रूव
हबो पछरे ओहो
ଦେଇଦବୁ ପେସ୍କର ଦେଖନ୍ତୁ କୋଉଠି ଲେଖା ହେଇଛି ମୁଁ ମିଛ କହୁଛି ମିଷ୍ଟର ସାଟିଆ makes a statement which is astounding.
ସ୍କିପ୍ କରୁଛନ୍ତି ମୁଁ କହିଲି
Skip. I don't skip.
ଏକ୍ସାମିନର ଆସିଲେ ପ୍ରୁଭ୍ କରିବ। ମୋ ଟୁ ଟା ଦେଖନ୍ତୁ ମିଷ୍ଟର ୟୁ ଆର୍ ଲୁଜିଂ ଇଟ୍ ମିଷ୍ଟର। ଆପଣ ଟୁ ରେ ଗୋଟେ ଲେଖା ହେଇଛି ଆପଣ ତାପରେ ଗୋଟେ କହୁଛନ୍ତି ମାନେ ଆପଣ ବୋନ୍ କଥା ଲେଖା ହେଇଛି ଟୁ ରେ ଆପଣ କୋଉଟାରେ ତଳେ କ୍ୟୁ ମାନେ ତଳେ ବୋର୍ଡରେ ଯୋଉ ଲେଖା ସେ ଲାଇନଟା ଆପଣ ଜଷ୍ଟ ଫର ଲସ୍ ଷ୍ଟାଣ୍ଡ ପକେଇଛନ୍ତି। This creates then not a problem. ଆପଣ ଟୁ ଟା ପଢନ୍ତୁ ବଡ ପାଟି ଜାଣିପାରିବେ ସିଏ ବି ସେୟା ଲେଖିଛନ୍ତି ସେଇଟା ଦେଲେ ସେଇଟା ଆପଣ ପାରା ଟୁ ଟା ଦେହରେ ପଢନ୍ତୁ। ଆରେ ପେଜଟା ଗୁଡା ଦେଇଥିଲେ ସାର୍ ସେଇଟା ଦେଲେ ନା ଆଙ୍ଗୁଠି
ଚାର୍ଜସିଟ୍ ର କଲମ 10
ଆପଣ ସ୍ଲୋଲି ପଢନ୍ତୁ ପାରା ଟୁ ଯୋଉଟା ଆପଣ ମତେ ଦେଲେନି ସେଇଟା ପାରା ଟୁ ପଢନ୍ତୁ ସ୍ଲୋଲି। ବଡ ପାଟିରେ ପଢିଲେ ହବ ନା ନହେଲେ ମୁଁ ପଢୁଛି ଏଇ ଯୋଉ କ୍ୟୁଟା ପଢିଲି ଏକ୍ଜିବିଟ୍ କ୍ୟୁ ପଢନ୍ତୁ ନା ଆଜ୍ଞା ପାରାଗ୍ରାଫ ଟୁ ପଢନ୍ତୁ ଆପଣ କଣ ଡିସୋରିଏଣ୍ଟେଡ ହେଇଗଲେଣି କି ପାରାଗ୍ରାଫ ଟୁ ଟା ପଢନ୍ତୁ that is the reason why it was sent to Hyderabad ପାରାଗ୍ରାଫ ଟୁ ଟା ପଢନ୍ତୁ ଆଜ୍ଞା from exhibits marked as A long hair with root B long hair with root slowly ପଢନ୍ତୁ so that ସେଇଟା overlap ହବନି ହଁ C long hair with root D long hair with root F long hair with root Q2 portion of vertebra yes in born and charred condition A11 long hair with root A13 short hair A15 one short hair with root B1 one piece of partially one bone R muscle of deceased R1 muscle of deceased and R2 muscle of deceased complete autosomal DNA profiles could not be generated as the required quantity of DNA for further amplification and profile generation was not available. That is the reason probably it has been sent to ଫିମରଟା କୋଉଠି ଅଛି ସେ ପାରାଗ୍ରାଫରେ ମାର୍କ କରନ୍ତୁ ଫିମରଟା ଶୁଣନ୍ତୁ ଲଙ୍ଗ ହେୟାର ସିଜ୍ କଲେ ଭର୍ଟିବ୍ରା ବୋନ୍ ବଣ୍ଟ ସିଜ୍ କରିଛନ୍ତି ଭର୍ଟିବ୍ରା ବୋନ୍ ସିଜ୍ କରିଛନ୍ତି ବଣ୍ଟ ଗୋଟେ ବୋନ୍ ଅନଆଇଡେଣ୍ଟିଫାଇଡ ଅଛି ବୋନ୍ ଅଫ ଦ ଡିସିଜ୍ଡ ସୋ ସେଟା ଫିମର ବୋଲି ଲେଖା ହେଇନି ପ୍ଲସ୍ ଫ୍ଲେଶ ତ ଇନଫ୍ୟାକ୍ଟ ସେ ଯୋଉ ପିସଟା ମୋଷ୍ଟ ଲାଇକଲି ସେଠିକି ବି ଯାଇଛି ତାପରେ ପଢନ୍ତୁ ପାରାଗ୍ରାଫ 5 ଟା ପଢୁଛୁ one of the analysis of autosomal DNA profile clearly पढ़ो one of the analysis that is scientific term used usually in one of the analyst ANALYS
এটা ডিএনএ ର ଯୋଉ ଇଏଟା
in the autosomal DNA profile generated from exhibit Q portion of femur bone matches with one of the alleles at each of the corresponding autosomal STR Q ଟା କୋଉଠି ଦେଖାନ୍ତୁ ଆରେ କ୍ୟୁଟା କୋଉଠି ଅଛି ସେଟା ଦେଖାନ୍ତୁ from Q ହଜାର ଥର କହିଲେ କଣ ହବ ସେଥିପାଇଁ ପଚାରୁଛି Q what is Q yes what is Q that is at page 1 clause 6 serial number 6 pre-processing small piece from the portion of femur bone was broken crossed into powder and pre-processed on 30th କାହାର ସେଇଟା ମୋ କ୍ୟୁଟା କାହାର ସେଟା ଆସି ଯୋଉ ବଣ୍ଡ ପିସଟା ଯାଇଥିଲା ନା ସେଟା ଆପଣ ଆଡ୍ କରିଦେଲେ ବଣ୍ଡ ୱାର୍ଡଟା ସେ ଦିଟା ତିନିଟା ନା ଆପଣ ହବନି ମତେ ଦେଲେ ଆପଣ ଗୋଟେ ମଦର ଗୋଟେ ସେ ୱାର୍ଡ ଗୁଡାକ ସେଟା ଆଡ୍ କରୁଛନ୍ତି ସେଟା ବଣ୍ଡ ଲେଖା ହେଇଥିବ ଆପଣ ସେଟା ପାରା କୋଉରେ ଅଛି ଆପଣ ଯାହା ସିକ୍ସ କରିଛନ୍ତି ଜଷ୍ଟ କ୍ୟୁଟା କୋଉରେ ଆପଣ ମାର୍କ କରିବେ କୋଉଠି ସେଟା କାହାର ସିଜ ହେଇଥିଲା କ୍ୟୁର ବୋଲି ଦେଖିବେ ସିଧା ଷ୍ଟେଟ୍ ଆବେ 100 ଥର କହିବାକୁ ପଡିବ ଆପଣଙ୍କୁ ଆପଣ କ୍ୟୁଟା ଭିକ୍ଟିମର କୋଉଠି ଅଛି ସେଟା ପଢିବେ ସିଧା that is academic
ଆପଣ ଯେହେତୁ ଗୋଟେ proposition କହୁଛନ୍ତି, so I'm trying to interested to understand and know, but I'm not going to refer to any Q. Not academic. Q ଟା କୋଉଠି recover କରି ମୋତେ ଦିଅନ୍ତୁ, ମୋତେ ସେ brick ଦିଅନ୍ତୁ ମୁଁ ଦେଖିବି। ଆପଣ ଯାହା recover କରୁଛନ୍ତି ପାରା 2 ରେ ଅଛି। ପାରା 2 ରେ ଯାହା ଅଛି ସେଟା ଆପଣ recover କରୁଛନ୍ତି। ପାରା 5 ଦଉଛନ୍ତି। ପାରା 5 ରେ ଆପଣ ଯୋଉଟା Q କହୁଛନ୍ତି ସେଟା କୋଉଠୁ ଆସିଛି ସେଟା ଆପଣ source ଟା ମୋତେ ସେତେବେଳେ ପଚାରୁଛି କାହାର ସେଟା କୋଉଠୁ ଆଣିଲେ? ବ୍ରୋକନ ପିସ୍ ପ୍ରଶ୍ନ ଉଠୁନି। ଆପଣ ଗୋଟେ ବ୍ରୋକନ ପିସ୍ ଗୋଟେ ଲାଇଭ୍ ଲୋକର ନେଇକି ଭାଙ୍ଗି ପାରିବେ, ଗୋଟେ ସ୍କାଲ୍ପେଲରେ ଟିକେ ସ୍କ୍ରାପ୍ କରିକି ଗୁଣ୍ଡ କରିକି ନେଇପାରିବେ, ଠିକ ଅଛି।
ଆଉ କଣ?
ସେଇଟା ଭିକ୍ଟିମର ଖାଲି ଆପଣ ଦେଖୁଛି ଯାର one seal plastic container said to be containing portion of femur bone, one କାହାର ସେଟା? Just few minutes, please. I'm just getting the Q. That is a victim, but I'm showing a lot of bodies. Anyway, Mr. Katkia, yes, you will show that, but I am not answering that proposition of Mr. Pandit that you have not proved it. So I am not answering that. I am not entering into that. I will not be entering into that. Either way. Something will help you, him in trial or the victim, the accused in trial or the prosecution. That I am not going to do that. Be assured of that. Be assured of that. And the judgment I have rendered where I have gone in detail to the prosecution report. Look at it. About 10 to 5 pages. Still also I have concluded that that is only reference for grant of bail. Exactly memory. That should be. But Q upon what I coached para 2 and Q they are completely in contradictory. Upon the report. Para 2, whatever you have recovered as per the remands, of the deceased. So that is the reason why possible. Because it's a chart beyond, so whatever is there, it could be.
Yes.
So long hairs were recovered from the spot, but other burnt bone, femur bone identify ହେଇଗଲା and ହେଇଗଲା ସେଇ spot will be yes ମାରୁତି ଗାଡି ତ ସେଟା ବଣ୍ଟ ହେଇଯିବ, ସେଠି ବି ବଣ୍ଟ ହେଇଯିବ। somewhere in the chain where the hairs were ଯୋଉଟା କି
ସେଟା ଗୋଟିଏ ସାହାଯ୍ୟ କର କି
ନା
I'm sorry, I'm not getting that. I'm getting Q, but the source of you should have flagged it and not highlighted it. When once you are going after Q, while preparing, you should have flagged it and highlighted it. Because that's your trump card. And after reading 2, you are going to Q. You say yes. 2 is ahead of Q. Source of Q, I know that is and your own report says that it is charred and destroyed and no DNA material could be extracted.
Any event, my lords, even otherwise, that will not attach any significance to the criminality or otherwise of the petition.
Yes, because it is not attributed to him.
Exactly.
Oh, you were saying that because that is not the dead body of the victim, Mamita. That he is not saying. Did he say that? Because in otherwise, my Narasimha is saying that. No. He's saying again the same problem. You should speak like a lawyer.
Exactly.
Not like a person who is investigating, who doesn't understand anything. He is saying the scientific evidence presented by you in the trial does not support that. You see, document which is it a fascination that you are producing that DNA report? No, it's a scientific evidence. Scientific evidence to prove, to say that the last point of being the person before being burnt was there in the pit. Because or else how do you say that she was inside the pit and burnt? So that says that scientific evidence is very clear. I mean, it is written so also.
Nothing comes on that side.
The source. Then also we can read para five, will also can get it. It's clear. अरे भाई କାହିଁ କହିଲେ lots of people get it. ଆପଣ ସେ କହିବେ state ଏବେ କୋଉଠି extract ହେଇଥିଲା Q ଟା state କହିବେ plus Q ର source ଟା ଆମେ ଦେଲି but they stop that. Be fair, Mr. Katkia. I asked you, tell me where from you got the exact identified femur piece of bone. Yes. You see, something is burnt. Nothing is there. You can't know what is there, what is femur, what is this whatever. What is humerus bone or what is a jaw bone? What is you can, because it is burnt. But you see, ଆପଣ ପାରା କ୍ୟୁଟା ମୋର ମନେ ନାହିଁ I can repeat it also. ଆପଣ ଟିକେ ପଚାରୁଛି ସେତେବେଳୁ କ୍ୟୁଟା କୋଉଠୁ ଆଣିଲେ? Lordship is very clear. Lordship will read it. ଆପଣ ତ state କହିବେ, ହଁ ମୁଁ କହିବି, ହଁ କ୍ୟୁ କୋଉଠୁ ଆଣିଲେ କହିବେ. I've been waiting for you that ଆପଣ କଣ ଚାହୁଁଛନ୍ତି? You see, ultimately even ଆପଣ କହି ନ ପାରିଲେ ବି doesn't make it damage your case. Why? I'm not commenting on that. That also I have told you. You are not getting it. Yes, boss. But
It neither improves my case nor damages.
exactly. It doesn't help him also that way because I'm not commenting. I'm telling you, I'm not saying anything, analyzing the evidence that how far the prosecution has been successful in presenting the case. Mr. Derasis Panda, did you लिखिए क्या पढ़ा? The file टा घुंचे दो ना आंटी. Appearance लिखिए Mr. Derasis Panda for the petitioner, Mr. Janmejay Kotekia, additional government advocate for the state, Mr. Tushar Kumar Misra. You can please take your seat, both Mr. Panda and Mr. Misra, for the informant. First para gala, second para likhiwe. The Lord Counsel for the petitioner submits that the petitioner is in custody since 21/10/2021. Charge sheet was submitted on. Final prosecution report was submitted on 25/8/2022. Examination of witnesses started on 29/9/2022. Considering the period of incarceration and the fact that the petitioner has been and the fact that consider the period of incarceration and the allegations made against the petitioner as far as his complicity in the crime is concerned. And তার বয়স কত? The accused was use these millers aged 31 years. Considering his age to be 31 years, he may be shown indulgence as far as prayer for bail is concerned.
But the time of the occurrence, it must be 29.
Now 31 years. Now being 31 years, maybe some continue. So that he can be given a chance to come back to the community to lead a normal social life. The learned AGA, referring to the materials on record contained in the case diary, the scientific evidence, the statement of the some PWs opposes the prayer for bail. Para. The learned counsel for the informant with all vehemence also referring to the statements of the PWs, nature of allegations, opposes the prayer for bail. इतने भी नेचर ऑफ एलिगेशन लिखते हुए पर कोतरे कार ऑफ सबमिशन दे ना एजीए को सबमिशन है नेचर ऑफ एलिगेशन पर however after hearing the learned counsel appearing for the parties as noted above at length rather extensively, it is not disputed at the bar that in the meanwhile, the final prosecution report has been submitted. The principal accused has unfortunately passed away during pendency of the trial. By and large, the learned counsel appearing for the parties also agree regarding the attributions against the petitioner and the fact that he has been charge sheeted as an accused based on the statements of the co-accused and other material evidence. अपन टे सुनी थी समझते जोटा बने अपन ठीक लगी you can say it, but instead of disrupting अपन just सुनी थी Mr. Pandit, Mr. Mishra also. Para. The learned AGA as well as the learned counsel for the informant to oppose the prayer of bail have referred to the statement of a witness. See, कितने number आए हैं? No, ना एक तो गले 11.
No, the witness who claimed to be intimidated. 11 hela the witness who has transferred money to the
से जो 9 और सेटा होची अच्छा 9 कोन ठीक जगह लिखा है अच्छा बड़ा टा
case number 9 लिखा है.
हाँ ठीक है
SC case number 9 of
PW9 examined on
30/11/22
by the additional session judge Kantabanji. Learned court in sessions of the in season of the matter, where the witness volunteered that there is threat from the side of the accused. Para. The learned AGA, I'm sorry, the learned. So there is no more AGA. As he said, the learned counsel for the petitioner. These things, Mr. Katke, these things I wanted to avoid. This kind of observation in the order, because once you say this, then he will answer, then I have to record this.
No, that's right. Whatever submission are.
No. The problem is that it doesn't help. Neither helps you nor definitely doesn't help the prosecution. Correctly? Refers to the cross-examination of the said PW9 as recorded on said data saman rahiba 30/11/22 to submit that the alleged threatening if any was from the family oblique acquaintance of the deceased co-accused. Para. Is anything left out?
Well,
I'll not go to the. I'm not going to the. I only say scientific evidence and all that because if I go into that, then there will be direct reflection.
what a bit of 12:30 with
ठीक है. The learned AGA refers to the deposition of PW 9, 11 and 12 to oppose the prayer for bail. Mr. Mishra, the learned counsel for the informant, आपन PW की refer करचंती same my lord refers to the 9 witnesses of 9, 11, 12, 9, 11, 12, 12, 13 and 14. 13 and 14. Para. The learned counsel for the petitioner very categorically replied to the evidence of replied to the submissions of the learned AG as well as the learned informant, learned counsel for the informant, as far as the statement of the PWs are concerned. Subpara, but in considered opinion of this court, as far as the prayer for bail is concerned under section 439 of the CRPC, the submissions regarding the merits, some submission of regarding the weight of the depositions or otherwise may not be should not be may not be delved into at this stage. Para. Having heard the learned counsel for the petitioner, the learned AG for the state, the learned counsel for the informant, considering the material on record, as well as the rather prolonged hearing on the different aspects of the evidence presented by the prosecution. It has to be as non-specific, the order has to be as non-specific as possible. Different aspects of the evidence produced by the prosecution, presented by the learned AG and also supported by the learned counsel for the informant, and the response of the learned counsel for the petitioner. The court is inclined to grant bail to the petitioner, subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter. We shall also include the following terms and conditions. I mean, how is a person? He is economically sound, or because he is a driver? He must be.
His father is a watchman. He was a driver.
So those conditions they will impose after hearing the prosecution and but some specific conditions like he'll be available, he'll be those conditions, and he has a mobile phone. CDR is the star who is now. So that condition will be there, that he'll be available to be contacted if required. Yes, any other condition you want?
Will appear on each and every trial.
24 hours he will remain present in the post police station, that he will oppose. There. I have no problem. I'll quote Mr. Naik. Then don't allow granting bail. If he directed to remain present every day in police station, Mr. Naik said, then it's better to return at cost to trial. Whatever is there, so whatever conditions he will impose. Whatever conditions, apart from that, I will impose certain conditions which you want now. He will appear definitely. So even certain more than that, which will not be palatable to Mr. Ponda, but it will be there. Can the court allow anyone not to appear? It's not that's not. I mean, yes. There will be some more condition because you are saying that. But anyway, there is no chance of he's a local person. It is a the learned counsel for the petitioner submits that the petitioner is a local person. He shall subject himself to the. I'm putting it positively. That is a submission that he will subject himself. He will subject himself to the jurisdiction of the learned court in session of the matter and shall abide by the terms and conditions that will be imposed for grant of bail. It is submitted by the learned AG that in case the court is inclined to grant bail to the petitioner, the suitable terms and conditions should be imposed as far as he participating in the trial is concerned. Yes. Submission type right? Yes. The learned AG produced the certified copies of the order set of the learned court in session of the matter 21/12/2021. No protracted trial to refer accordingly to Mr. Ponda, even if you have argued or somewhat effectively, but I will not refer to that. No. 21/12/2021 till date. Till date. Till 15/12/2023. 15/12/2023. And the copies of the deposition of the PWs from PWs 1 to 14. 1 to 114. 1 to 14. The record the said copies of the depositions or the copies of the order, certified copy of the order sheet along with deposition submitted along with memo dated 18/12/2023 shall be kept on record. The staff को रखते हैं.
Urgent copy.
Last urgent certified copy as per. There will be direction for to the lauded court in session of the matter to hear the public prosecutor and the defense before imposing the conditions. That liberty will be there. You want to be had there, Mr. Misra? Informant? Informant. Condition regarding condition, you can say your trial will expedite. From the side. Because you have asked the last of what you can ask Mr. Standing counsel, Mr. Naik, and not explain. My answer is that this is a great injustice to all the other persons those who have not filed bail.
Shall I tell a story? This is what I myself experienced. Earlier, Milord, when I was this high, trials used to be concluded at the committal stage. Committal cases, Milords, committal proceedings were held in the magistrate's court. I have seen my father going here, there to the magistrate's court, coming back and saying that I have got acquittals in murder cases. Sessions cases also used to be closed on the same year they were instituted. Nowadays, Milords, sessions cases, if they are instituted today, they may continue till a generation has passed.
It's true.
So, this is the status that we have gone down. So I ask for an expedition of trial.
No, expeditious trial, without knowing how many cases are there, and those who are languishing much ahead of this person.
Done, Milords, because there is no PP who tells the court, Milords, that I will examine only this witness and no more. Nowadays, Milords, the system is that if a witness has stated something in his 161 or 164, he has to be coached to repeat the same thing in court. That leads to lengthy cross-examination, sometimes spanning days, Milords.
And Mr. Pandya, that doesn't help prosecution. The other problem is that
Neither
he will be blamed.
it doesn't.
As I've been hinting at him, that being belligerent or being overzealous doesn't help the prosecution.
If the PP is one like led Padmacharan Parida, he will never be blamed.
The thing is that here you have to have the grip. You have to have the grip of the case, present those witnesses.
Mr. Parida was a colleague of my father and a classmate. He used to travel by bus to conduct sessions trials. He never used to accompany his friend in his car. They used to sit on Saturdays and discuss about many things on the earth. But never while going to sessions, Mr. Parida would accompany his friend in his car, nor would return from sessions in that week.
Seven withdraw ହେଇଗଲା 7 ଟା withdraw ହେଲା ପ୍ରାୟ
7 withdrawn. Order ଟା ଡକା ହେଇଛି 7 ଟା ଫାଇଲ ଟା ଦେଖନ୍ତୁ ଆଜ୍ଞା ଫାଇଲ ଟା ଦେଇ ଦେଇଛନ୍ତି ତାହେଲେ ନେକ୍ସଟ
May I please, Lordship? My Lord,
you are Mr. Kanungo,
SK Mahapatra.
Mr. SK Mahapatra for the petitioner, Mr. Devashish Naik AGA for the state.
May I be permitted to submit one?
Yes, please.
Now, the offences implicated under section 3762N of IPC read with section 6 of the POCSO Act.
Yes.
And the occurrence took place on 3rd March 2017. However, my Lord, the petitioner was absconded and he was taken into judicial custody on 2/5/2023.
Yes.
And charge sheet was filed on 31/12/2017.
Yes. This deposition copy you are having.
Yes, ma'am.
will be yes.
What happened in this case, my Lord, is that
Whenever you are referring to, please ensure that the other side is having. Yes, because it becomes difficult to have a deliberation on that.
I beg your pardon. As per the allegations, my Lord, on the date of occurrence, the informant went to the backyard at around 3 AM.
बेस्ट पॉइंट कोन आपण से जो नैरेटिव टू भी जानतु नहीं आपण कोनटा फेवर रे अछि सेटा कहिबे ना
My humble submission.
जदी माइनर ताले डोंट गो इनटू द कंसेंट
Yes.
आपण से सेक्शन दा पढंतु अगेन एंड अगेन इट्स इन कोड नहीं जे whoever intentionally takes away from the custody of the parents or guardian that intentionally नहीं वाता Why the word is not there? So that way ଆପଣଙ୍କର ଏଇଟା କଣ ମାନେ ଲାଗିଥିବ କିଡନାପିଂ ଆଉ ଇଏ ଲାଗିଥିବ ସେଥିରେ ଆପଣଙ୍କର ମାଇନର ଯଦି ବ୍ୟାକୱାର୍ଡକୁ ପଳେଇଲା ତାର ଭଲେଣ୍ଟାରିଲି ଆପଣ ଯଦି କହିପାରିବେ I am further elaborating since we are having a lot of discussions today ଯେ you carried the minor to their parents, the parents said that you please take her along with you. If you say that, then still then it will be difficult to wriggle out of those rigors of that provision. Then you can have make an argument. तो ଆପଣ କହୁଛନ୍ତି ସେ ଆଜ୍ଞା ନିଜେ ଆସିକି ମୋଟରସାଇକେଲ ବସି ପଳେଇଲା so consent ସେ ଆଜ୍ଞା 4ଟା ବେଳୁ କଥାବାର୍ତ୍ତା ହେଇଥିଲେ 4ଟା ବେଳୁ ଘରୁ ବାହାରିକି ପଳେଇଲା that is not required sir. That is not required in the ସେଠି କୋଉଠି ଲେଖା ହେଇନି ଯେ ଇଏ ଆପଣ ଯଦି ରାସ୍ତାରେ ଯାଉଛନ୍ତି ମାଇନର କରୁଛନ୍ତି and these orders are from February. ଫେବୃଆରୀ ମାସରୁ କେସ୍ ପେଣ୍ଡିଂ ଅଛି ଆପଣ ଏବେ ଫାଇଲ କରୁଛନ୍ତି କହିଲେ ଆଜି ଛାଡି ଦିଅନ୍ତୁ ହେଇପାରେ ମ୍ୟାଚ୍ କରୁଥିବ ଯୋଉଥିରେ ମ୍ୟାଚ୍ କରୁନି ଫେର ଆଉ ଥରେ ଫାଇଲ କରିବେ ଆପଣ ଫାଇଲ କରିନାହାନ୍ତି ଆଜି ମୁଁ କଣ କରିବି ତାର ଅର୍ଡର କଣ ହବ ତାହେଲେ କାଉନସିଲ ଫର ଦ petitioner seeks accommodation to obtain instruction and advance arguments up to date instruction ଆজ କେବେ ଚାହୁଁଛନ୍ତି ଲିଷ୍ଟ ହବ ସାର୍
Any date after vacation, Lords.
It is submitted that as per instructions received from the petitioner's family, the petitioner is interested in welfare of the victim as well as the child born to the victim. And regarding that, he may be regarding the said aspect, if so advised, the lawyer counsel for the petitioner may file affidavit. The affidavit may be filed on behalf of the petitioner. Affidavit कितने दिन भीतर देबे क्या आप आइए फाइल करिए affidavit oblique आइए
Within 1 week, my lord, I will file.
और इसको छुट्टी है ना we are almost we have spent 1 month, Mr. Mahapatra. That's the that is why I am always drawing your attention. Affidavit by the next state, copy of the affidavit oblique in IA if any if filed shall be served on the learned AG to counsel for the state AG लिखियो नहीं counsel for the state to enable him to obtain instruction. केबे चौथे लिस्ट करिया पे तो जनवरी रे नहीं जनवरी रे तळे देखा जो जनवरी फर्स्ट वीक सेकंड वीक केबे चाहछन फर्स्ट वीक तो हबन सेकंड थर्ड केबे
Second week, my lord.
सेकंड वीक रे देखो 10/1/2024 to grant further opportunity. मासे नने की यदि फाइल करते 15 दिन में they could have obtained instruction regarding welfare of the victim whether there is any threat perception. This takes time. Yes. 9. May I please, Dr. Dharendra Naik, Senior Counsel, instructed by Mr. Pratik Naik for the petitioner, Mr. Devashish Naik, AG for the state. Yes, Mr. Naik.
It's a case minor where the
Mr. Sarada Prasad Das for the informant.
My lord.
Yes.
It's a case minor where the informant, the victim lady herself, whose name is Mitarani Behra, is about 26 years minor. So not a minor, my lord. And the affair was lost by her, making an allegation against the petitioner, my lord, that they had a love affair since the last 5 years.
164 statement achi.
My lord.
It's a case minor. It's a aged girl, not a minor. Love କରୁଥିଲେ ବାହା ହେଇ ପାରିଲାନି ବୋଲି ଏଫଆଇଆର ଦେଇଛି. That is the story.
ଆପଣ ତାଙ୍କୁ ମାନେ torment କରୁଛନ୍ତି. The problem is that the girl has no choice, sir. If she is tormented by the family, କୋଉ family ଫୋପାଡ଼ି ଦେଲେଣି କି ପୁଅ ନେଇକି ଘର ଗଲା ବେଳକୁ ତାଙ୍କ ବାପା ମା ତ ବାଡେଇକି ବାହାର କଲେଣି.
Allegation.
Parents of the petitioner are not agree.
Parents of the petitioner agree କରୁନାହାନ୍ତି.
Petitioner ବାହା ହଉଛନ୍ତି. ତାର intention clear ଅଛି. Petitioner wanted to marry. They were in the main pressure of the
ଚାର୍ଜ ସିଟ୍ ବି ସେଇ କଥା ଅଛି ଯେ ପିଟିସନ ସେତେବେଳେ ବାହା ହେବା ପାଇଁ ଚାହୁଁଥିଲା ପ୍ୟାରେଣ୍ଟସ୍ ତାକୁ ଆକ୍ସେପ୍ଟ କଲେନି ବାହା ହେଇ ପାରିଲାନି. But
ସେ ଅର୍ଡର ଥିଲା କି ସେ possibility of has it been circulated in social media? Objectionable photographs, allegations?
ନାଇଁ ସେମିତି ନାହିଁ କିଛି. It's clear case of they have relationship since last.
The allegations he has made in a 164, but we don't have an order to that effect. Nothing on that has been deliberated in this case.
She admits the relationship 3 years and
Yes.
over a period of
More than 5 years. And as your lordship has rightly said that mo bapa ma raji helne mane to baha helne mane case. But it can be 376 under any circumstances. And that is the charge.
I will not comment on that. We must have had the prolonged deliberation we are having. If I start, then it becomes a problem for either for the defense or for the prosecution. Yes, Mr. Das, what you are saying?
Yes, was granted an interim bail on 3/8/2023 for reconciliation for marriage, my lord. But subsequently, after release on bail, he threatened the informant through WhatsApp, my lord.
ଆରେ ସେ କହୁଛନ୍ତି ଆପଣ ତ 164 ପଢିଛନ୍ତି ତାଙ୍କୁ ଯେତେବେଳେ ଝିଅର ବାହାଘର ଠିକ ହେଲା ଇଏ କହିଲା ମୁଁ ବିଷ ଖାଇଦେବି. So there is a possibility of the girl
Agreed to marry her. Can marry him. Gal is agreed to marry him.
ଆଉ ତାହେଲେ ବାହାଘର କେମିତି ଠିକ ହଉଥିଲା? ବିଷ ଖାଇବା ପାଇଁ କିଏ କହିଲା? ବାହାଘର ଠିକ ହେଲା କିଏ ବିଷ ଖାଇବା ବୋଲି କହିଦେଲା? ପଢିଛନ୍ତି ସେଟା?
No, my lord, I have not gone through.
ସେଟା ଅଛି. ଝିଅ କହୁଛି ଯେ ମୋର ବାହାଘର ଠିକ ହେଲା ସିଏ କହିଲା ବିଷ ଖାଇଦେବି. ଏଟା ଅଦର ୱେ ରାଉଣ୍ଡ ହେଇଯାଇଛି.
ମୋର ଖାଲି ଗୋଟିଏ ସହ ଲାଇନ ସବମିଶନ ଆଜ୍ଞା ବାହାଘର ହେଇପାରିଲାନି ବୋଲି 376 ହବ କି ମେଜର
ନାଇଁ ସେଟା ତ ଗୋଟେ ଲାଇନ ସେଟା ଅଛି ଯୋଉ ସୁପ୍ରିମ କୋର୍ଟ ଅର୍ଡରରେ ଅଛି ସେଟା କିଛି ହଁ ଯେ ସେଟା ଡିଟେଲ କିଛି ଡିସ୍କସନ ହେଇନି. ଦ୍ୟାଟ୍ ଡିପେଣ୍ଡସ୍ ଅନ୍ ଫ୍ୟାକ୍ଟସ୍ ଆଣ୍ଡ ସର୍କମଷ୍ଟାନ୍ସ.
There is also decision power of High Court, my lord, by Honorable Justice Panigrahi, that giving assurance to marry, keeping relationship for a long time.
I will not go to that extent as far as comment on the merits of the case.
As your lords, please.
You can I observe that you are genuinely interested for welfare of the EA? That is your submission. Can I record that?
Welfare कौन आगे हम जो सीधा सड़क
welfare को बुझुथिबे there has to be
ନେବେ नहीं बोलते सिंधु
say upper to the strader over. Yes.
Item 3.
None appeals for the petitioner, though the matter is called twice over, once when it reached, and again upon resumption of the proceedings of the court after lunch break. None had appeared when the matter was last taken upon 3781 of 2023, 13/11/2023, 9/10/2023. The last appearance, stop correctly, the last appearance on behalf of the petitioner being on 24/4/2023. Any instruction regarding the status of trial?
Not yet, my lords.
Apparently, the petitioner has lost interest in prosecuting the matter. Para, to grant further opportunity to the petitioner, list on 9/1/2024. The registry shall obtain up-to-date status of the trial in the pending case before the court in season of the matter. Registered to do the needful. The learned AG shall also obtain up-to-date instructions.
Item 10.
May I please, my lord?
So Girija Shankara Naik for the petitioner.
Instruction will call for verification of surety, my lord. I have submitted a surety on local surety and one relative of the
I have
petitioner,
to
my lord.
obtain instructions on both because the affidavit was filed fairly 4th and 5th.
Do not received.
Not received it.
So can you not be obtained before vacation?
But because one is surety from outside the state.
Oh.
That will take some time. The local surety.
You filed the bail on 12/7.
Yes, my lord.
But you filed the affidavit on 5/12.
5/12, my lord.
It took 5 months. Just imagine.
After
No, I understand.
direction of lordship, I have filed, my lord. After
Direction of lordship.
yes, my lord.
Which order?
Last order, my lord.
Which judge? Me.
Yes, my lord. Lordship directed to file a surety, one local and one relatives of the petitioner.
No, I can.
Did you read the order?
No, my lord.
Did you read the order?
No, my lord.
No, you have to be confident to say. You have to read to be confident to say so.
Yes.
How a court can direct 439 to file affidavit regarding surety? I don't know, whatever little understanding I have. I never direct. Learned counsel for the petitioner submits that he has instructions on behalf of the petitioner that there shall be at least one local surety and one family member standing as surety if bail is granted.
Yes. I filed, my lord.
I cannot be the counsel on behalf of the petitioner. I have left that. Even if I wish at times. The learned AGA seeks accommodation to obtain instruction in response to the affidavit filed on behalf of the petitioner regarding the family member of the petitioner and the to stand as a local surety. The other is local person.
My lord. Yes, my lord. Local person.
The other affidavit being by a person who is local resident and wants to and may stand as surety if the petitioner is granted bail by the court. Para. The list on how much time?
My lord, sir. Second week of January, my lord.
You ask the local police to pursue them.
My lord.
Mr. You take 5 months to get that affidavit. As prayed for list on kete gote second week hochonti na 12 1
My lord.
item 11.
11 adjournment was sought for. Mr. M.S.Sahoo for the petitioner, Mr. Standing Counsel for the state. The learned counsel for the petitioner submits that he may be accommodated to file affidavit on behalf of the petitioner indicating the past allegations of criminal activity modified further affidavit. Affidavit type prefix code further affidavit. As prayed for list on 11-1-2024 to grant further opportunity to the petitioner. Copy of the affidavit that will be filed shall be served on the learned counsel for the state to enable him to obtain instruction.
Item 12.
So
Last second, we have been directed to take the threat for instruction regarding the threat perception, my lord. We have not received it.
Can you expedite it before vacation? We'll take a chance on Thursday.
My lord, my respective submission, since they have not given here, my lord, one thing has been happened. My lord, that in para 5 of the order, it has been directed to SDPO. In fact, in the Sohid Nagar case, it has to be SCP. That is
Fair enough. That's not an issue.
Talk to the IAC. They say that well, they would give, but if your lordship will dispose of whatever be in the merit.
No, since there is an order, I cannot modify that.
Yes, my lord.
And the perception is because of the anxiety expressed by the learned counsel for the petitioner, informant, victim.
Yeah, my lord.
Yes, she was.
Yes. Then I have to take, my lord.
Since it is Sahid Nagar, you get it.
Yes, my lord. Your lordship, I have 2 days, my lord. If you to 21st or 20th, I'll get it. I'm sorry, my lord. I'm not.
Mr. Vijay Kumar Mahanti for the petitioner, Mr. Standing Counsel for the state, Miss Janice Wallace. Your spelling is WALLACE.
Yes, your lordship.
JENI.
ZENISH.
JDNISE.
SH. Yes, lord.
The learned Standing Counsel submits that he shall obtain the instructions from the concerned police as indicated in paragraph 5 of the order dated 5/12/2023 and may be granted some further time. it is submitted that since the concerned police station is within the urban police district of Bhubaneswar, instead of SDPO, it should be the SCP. Accordingly, it is directed that the concerned ACP after a detailed field inquiry regarding the threat perception to the victim, informant, and their family, if any. A threat perception, if any कर दियो.
Yes.
Threat perception, if any, towards to the victim, towards the victim, oblique informant, oblique their family, and whether they are living life like any other ordinary citizen. Leading their life, THEIR. Shall provide instructions, list on equity.
Yes.
Yes, please. That J.M is also part of your name.
Sorry, Your Lordship.
J.M one.
Yes, M stands for Mary. MARY, Mary.
Okay. J.M. Yes, please.
Please, Your Lordship. In item number 13, the petitioner is in custody since 3/8/2020, Your Lordships. The last occasion, Your Lordships had ordered for the report from the Honorable ATJ and the District Bhubaneswar.
He is 3 months left only. Dispose कर देना.
Yes. Trial will be completed.
ମୁଁ ଲେଖିବି ନି କିଛି.
No, no.
ସିଏ ତ ଲେଖିଛନ୍ତି ମୁଁ କାହିଁ ଲେଖିବି.
Yes.
Yes, what was the material on record in 498 and 302?
Yes, my lord.
302, 498.
Here, my lord, one criminal incident, and my lord, there is a eyewitness's son, my lord.
Son has already been examined. Son was charge sheet witness number 2 and PW6. He has been
Now, I think Son is not supporting the prosecution case. That's
not supporting. Yes,
positions.
That is so, my lord, and on regarding, my lord, earlier assault, my lord, neighbors are there, statement of different neighbors are there. And apart from that, my lord, prior to this occurrence, my lord, the deceased was subject to.
This is that once he got admitted to AIMS, then subsequently during treatment he died. There was a injury at the lower part of the abdomen.
Yes, yes.
It has to be rejected.
Another 498 case was there prior to that, my lord.
Your submission is that she did not die due to the injury.
Did not die directly, not due to the injury, and it was not intentional. He had pushed his wife, but he did not intend to kill her.
No.
That is my only submission, Your Lordship. And there is no.
So I read that provision in the 299 300. It's a very clear cut provision. She died due to septicemia, septicemitis.
Septicemia. The charge sheet witness 2, PW6 is the son. He says he has not seen anything, and
so you will get acquitted in the maybe 3-4 months. Mr. Yes, what do you want anything to say further?
And another charge sheet witness number 9.
So I cannot notice then to grant you bail.
Yes.
It will be against the conscience of the court. You have killed your wife. If the only conclusion I can have now that you have killed your wife. Once you admit the injury was caused, but it was pushed and so that
also prior to that incident, another affair was against the present petitioner.
Actually, she was lying on the bed due to the earlier assault.
Yes.
The final assault became, which was a fatal, and she stayed in her home. Then
there he got the bail. After getting the bail order, my lord, all these incidents took place.
Was there a condition that you will continue to do the identical offense after getting bail?
No.
Mr. Ashutosh Mahanti for the petitioner, Mr. Standing Counsel for the state.
Only on the ground of mercy,
Additional session judge. Mercy should seek for the departed soul also, who died an unnatural, violent death for no fault of her. Did she deserve that death?
No, not
Beaten and injured by the husband.
Indian, not Indian.
You see that becomes a confederation as far as 439 is concerned. Even at times in trial also, you will see that there is not sufficient material, but the court being convinced that this person has killed, he only gets acquitted at the stage of appeal. Though that should not happen in case of trial. If there is no sufficient evidence, he should be acquitted. But here, I mean, the mercy to the departed soul also should be there shown. Some sympathy. She didn't deserve.
Informant is yet to be examined. Your lordships may keep this for next month. Let the informant be examined.
No point, because already perhaps you didn't mark what I said. I said that the trial just says that it will be taking another 3 months to complete the entire thing. So that is a saving grace for you. I mean, for the petitioner. Though I don't pass orders for expeditious trial, same as he has written.
Right.
So your purpose has been satisfied. Your efforts have been satisfied.
Otherwise, it could have been 5 months, 6 months.
5 months or 5 years, you have heard that.
Honorable
You
Court.
never know, you here also you will have 170 witnesses. So dispute between the prosecution and the defense is one prosecution is 168, defense is 169. And the PP will never hesitate. We will hesitate before withdrawing any witness because he will be blamed.
Yes.
Because nowadays every paper, every witness is being produced, so the trial
If you need to acquittal, then it will be very difficult on the part of the PP to solve.
I mean, simply saying that the matter is getting delayed is so easy.
Yes.
But there are so many, there's so much of nuances are there, so many aspects of it. And all the courts are overburdened. Bhubaneswar is at least you can be for sure say that it is overburdened.
Overburdened.
कौन लिख ले? The letter number 1984 dated 13/12/2023 has indicated the status of trial, which shows that out of 20 charge-sheeted witnesses, 8 number of witnesses have been examined. And the next date of posting is to 22nd 12 as on 13/12/2023. Next date is 2012 22/12/2023 as on 13/12/2023. Para. You want to merit disposal or you want just not to press it now?
Anything because you'll have a case of 3 months. You'll have to pass it on merits.
No, 3 months I am not recording. I don't know. Because I have not passed any order regarding that. The persons who are incarcerated, you must be seeing. So many persons are incarcerated. They don't have a right to expeditious trial. Do they not? Or they have? Each and every person has a right to expeditious trial.
I just seek the lordship's indulgence, mercy. If the lordship has already made up their mind not to grant will at least expeditious trial of 6 months. Lordships may pray to be reflected in order.
Being done. That is being done. After all, this whole process has achieved that. That process has achieved that. So that I am not saying anything. They may finish it within 2 months. What is there? They have given an outer limit of 2 months. 3 months.
3 months.
कौन लिख ले? The Learned Counsel for the petitioner submits that the petitioner is in custody since date of custody
3/8/20.
3/8/2020.
3/8/2020. The trial has progressed substantially and the petitioner be shown indulgence as far as prayer for bail is concerned. The Learned Counsel for the petitioner, the Learned Counsel for the state, referring to the materials contained in the case diary, the nature of allegations opposes the prayer for bail. ये देखिए बेटा तो ये पोस्टमार्टम रिपोर्ट in materials contained case diary, including the postmortem report.
My lord, here, my lord, they have
Just a prayer for bail.
my lord, I am giving the detailed report. That postmortem report actually, my lord, not legible. The lordship may see the detail they have written, my lord, in the city.
This court has the occasion to go through the case diary, matters contained in the case diary, as well as the autopsy report. At least your bail has caused your death. If you would not have been released from bail, you could not have assaulted her again at the same place with a Shilo. Pratham thara botole, second thara Shilo Puare.
ପ୍ରଥମଟା କାଚରେ ମାରିଲେ ଭଙ୍ଗା କାଚରେ
internal injury ହେଇଗଲା Shilo Puare. ଅଛି କି? ଅପରେସନ ହେଲା
ଅଛି ପେପର ଗୁଡା ସବୁ ଅଛି ତା ଦେହରେ
ଠିକ ଅଛି
ଭଲସେ ଦେଖାଯାଉଛି
Lordship, son has in fact testified that he donated blood and all the treatment expenses were also paid by him, by the accused, his father.
What does that show?
That maybe
suppose somebody slits somebody's slow throat. So heavy bleeding will be there. Will require 10 bottles or 20 bottles of blood. How much he can donate? It's too late in the day to donate blood after causing somebody's injury. And this kind of this opening of abdomen perineal, that surgery requires lot of blood actually. Who helped you to get bail in the first case?
That I have no instructions, Lordship.
You should get that. That's a very striking part of it. The victim herself moved the court to get bail for you. That is one of the statements. ଯୋଉ ପ୍ରଥମେ ତାଙ୍କର ମାନେ broken glass bottle ରେ ତାଙ୍କୁ injury କରିଥିଲେ, were arrested because you have two small children, nobody else in your family in Bhubaneswar. The lady herself tried her best and moved the court to get bail for you. only saying that 1.5 month hospitalization, that may favor you.
Right.
ଲେଖନ୍ତୁ ଏତେ ପୋଷ୍ଟମର୍ଟମ ଗୋଟେ ଅଛି ଏଥିରେ।
Safety seven.
Did you see this? Have you seen the postmortem report?
No, Your Lordship.
Since you are a young counsel, you must know the reasons. You should be satisfied. तो G additional remarks देखो, brief history of G, F of G देखो, कौन लिख ले? The Shulopore Chechile, that Mueller injury has caused extensive damage. G, if you understand.
Yes.
The alleged, having had the alleged counsel for the petitioner and the alleged standing counsel for the state, and after considering the material on record, this court is not inclined to grant bail to the petitioner at this stage. Accordingly, the petition stands dismissed at this stage. However, since the trial has progressed substantially and it is informed by the Honorable Additional Session Judge in season of the matter that that about 3 months further time is required. It is expected that the trial would be completed. As indicated by the letter in the letter dated 13/12/2023 of the Honorable Additional Session Judge, 4th Additional Session Judge, Bhubaneswar. Yes. Yes.
Item 14.
Much obliged.
You are saying 6 months. Or 4
6 months. Your Lordship will reflect 6 months. He has already been in custody for more than 3 years. So 6 months.
No, they say about 3 months.
3 months.
3 months से पहुंचे.
3 months action.
No, 3 months से मैंने टारगेट करी चलती है. हाई कोर्ट ऑर्डर जो दिखेगा 6 months.
नहीं से हाई कोर्ट सेटा करना है. जो बारंबार तो चिट्ठी लिखा ना ସେଥିପାଇଁ सब बुझी गले. चिट्ठी लिखिले ताको से सेटा तंग रही छै को. छाड़ देबे. ठीक अछि.
Much obliged.
14.
Mr. S.K. Jemna for the petitioner. Yes. Mr. Standing Counsel for the State, the Learned Counsel for the petitioner seeks accommodation to further accommodation to advance arguments as paid for list on Date current after vacation. 16/1/2024 to grant further opportunity to the petitioner. The learned standing counsel submits that case diary is available.
15.
Last occasion, Your Lordship, as per the direction of Hon'Ble Court, filed the memo, my lord.
My lord has called on the 164 statement as well as the DNA test report. My lord, we have got the 164 statement, but DNA test not yet conducted. That's it.
What is the age of this person? What is the age of the petitioner?
Age of petitioner, my lord. "39.
এটা 15 My lord, item 15 nobody is there. Is not
My lord, wrongly I have submitted.
Upon কোটা
16, my lord.
দেখো ছুটি পড়ে না পূর্বক রক্ষা 21 রক্ষা
How ওটা
non appeals for the petitioner when the matter is called to grant further opportunity to the petitioner list on 21/12/2023. The learned standing counsel submits that he has case diary, up to date case diary. He has received up to date case diary, including the statement of the victim recorded.
Last given my
You are Mr. Naik, Mr. Ramakrishna Naik. Mr. Ramakrishna Naik for the petitioner. Mr. 304201.
yes.
ଦିଟା ଅଛି ଆପଣଙ୍କ ରିପୋର୍ଟ ଅନୁସାରେ
Antecedent one and
ଆପଣଙ୍କର ୱାନ୍ ତ ଆପଣ କହୁଛନ୍ତି ସେଇଟା ମିଶେଇକି ଦୁଇଟା ହେଲା ତାହେଲେ ବିଡାନାସୀ
ଗୋଟେ
two local sureties, one family member. First paragraph, second paragraph, the land counsel for the petitioner submits that the petitioner is in custody since date ko अरे incarceration date टा कौन तू
ମୋ ପାଖରେ ନାହିଁ ଡେଟ୍ ଅଫ୍ ଆରେଷ୍ଟ
ଅଭିମନ୍ୟୁ ପାତ୍ର এটা 304 মানে 302 নয় কি 304 ইচ
4 sudden progress
sudden provocation
লিখলে डेट कोड पर छाड़ू डेट डैश लिख देता हूँ सिंस एते फाइनल प्रोसिक्यूशन रिपोर्ट हैज बीन सबमिटेड इन द मीनवाइल on एते and considering the period of incarceration and the fact that the final prosecution report has been submitted and the petitioner is being aged about
39 years
after final police report submitted he has arrested
he was absconded हजुर पाइगल 3/2/2020 ରୁ ଆରେଷ୍ଟ ହେଇଛି
3/2/20 अरे ठीक कहउचंती तो और फिर करेक्शन 3/2/20 फाइनल प्रोसिक्यूशन डेटा कौन आती फाइनल प्रोसिक्यूशन रिपोर्ट
6/18
28/6/18 28/6/18 28/6/18 उल्टा पलटा ହେଇଗଲା नहीं कि 18 पर से एब्सकॉन्ड करथिला 20 रे अरेस्ट हैला हाँ 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 सब was submitted earlier कर दियंतु सेंटेंस ठीक रहइबो was submitted earlier the petitioner be shown indulgence in view of the period of incarceration. It is submitted that the petitioner is a local resident and shall subject himself to the jurisdiction of the learned court in season of the matter and shall also abide by the terms and conditions that would be imposed if he is granted bail by the court. The learned standing counsel referring to the materials contained in the case diary as well as the nature of allegations opposes the prayer for bail. However, it is not disputed that in the meanwhile the final prosecution report has been submitted, and the past and there is only and the affidavit submitted by the petitioner on behalf of the petitioner, affidavit submitted on behalf of the petitioner indicating the past allegations of criminal activity against him is in sync with the police report received by the standing counsel that he has earlier allegations against him under section kite 480 IPC
379
379 ଆମର କୁହନ୍ତୁ affidavit 457 ଲେଖା ହେଇଛି
457 379 ଘରେ ପଶିବ ହାଉ ଟ୍ରେସପାସ
379 457 379 380 IPC. Having heard the learned counsel for the petitioner and the learned standing counsel for the state and considering the material on record and the affidavit signed on behalf of the petitioner, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, which shall also include a condition that there shall be two sureties, two local sureties, out of whom one shall be a family member of the petitioner. Any violation of any deviation from any of the terms and conditions shall result in filing a petition for cancellation of bail by the informant, victim, informant, law enforcement agency. Victim passed away. Yes. Disposed of accordingly. None appears for the petitioner when the matter is called. Petitioner none, Mr. Standing counsel for the state. None had appeared for the petitioner when the matter was last taken up. On 11/12/2023, appearance lekha ହେଇଛି lekha ନଥିଲା. Though when it was submitted by the learned counsel, Mr. Das, for the who had earlier appeared for the petitioner, that the petitioner has taken away the briefs after obtaining his consent to engage any other counsel. To grant further opportunity to the petitioner, list on 8/1/2024.
Yes, once is for treatment or letter.
The standing counsel, in fact, he produced last time, but I don't know why he is not pressing for. No one is appearing now. The counsel for the state counsel, standing counsel produces the up-to-date case diary, including the containing the statement of the victim recorded under section 164 of CRPC.
18.
ଆସିବ କି ରିପୋର୍ଟଟା? Petitioner none, Mr. P.K. Prada, standing counsel. The BL appeal was disposed of by order dated 20/11/2023, and the report was directed to be obtained from the concerned SDPO regarding the welfare of the victim and threat perception, if any. It can be passed over.
Yes, ma'am.
Yes.
I think I have received it.
So order টা পরে লিখিও না না এটা মাত্র। Yes. Let's call the next matter.
Yes.
Please, Your Lordship.
Yes.
Your Lordship, on the last occasion, Your Lordship had received the threat perception report and also.
You are Ms. Rautre.
No, Your Lordship, I'm Ms. J.
J. Jenna. Ms. J. Jenna for the petitioner. Mr. Standing Counsel for the state. Ms. Radhasri Rautre for the informant. Yes, Ms. Rautre, what do you say?
My lord, from last threatened occasion,
So ତାଙ୍କ ଯୋଉ ସେ ଟ୍ରେନ ରୁ ଫେରିଲା ବେଳେ ତାଙ୍କୁ ଘୋଡେଇକି ବାଡେଇଲେ।
ଆଜ୍ଞା ବିଲ ମଝିରେ ବାଡେଇଥିଲେ, and after that, my lord, once they attacked at your home also, and after the last 2 weeks before,
In fact, I had asked you for that reason that you have to counsel them.
In fact, Your Lordship.
Though if they are interested in welfare of the petitioner, their family, they should not behave this way.
Yes, Your Lordship.
So either I have to reject it or keep it. It will lie over to be considered later when the situation will improve.
Yes, Your
Because
Lordship.
again, the update again and report has to be obtained regarding that.
Your Lordship, only if I can make a submission, Your Lordship, because
Yes.
Your Lordship has taken a practical approach, which I bowed down to Your Lordship. But after 1711, Your Lordship, when Your Lordship asked for a threat perception report, my only case is if this allegation was brought after that, Your Lordship, then this allegation must be put into strict
Perspective.
examination. It
So it's
was-
perspective.
Yes, Your
You
Lordship.
see, the alleged occurrence is not like that. It's not because you see every day we are saying there is a threat perception or somebody are feeling apprehensive. Apprehension and threat are different.
Yes, Your Lordship.
They might be very scared.
They might be for
They
that.
might be scared. But here, you realize what is the allegation?
And the allegation is
When he alighted from the train, going to village in a hidar. So the hidar exact it's a dividing line between two cultivating patches of land. So somebody put a cover over his head and face. Then he was bitten and he was left like that.
Your Lordship, as of now, from the instruction that I have got, Your Lordship, there is a big chance that this can be a fabricated and allegation.
So let it be investigated.
Yes, Your Lordship, it has not been registered from whatever information I have got. This allegation, it has not even been registered. Let them proceed.
No. Actually, that's the first part. You see the police report. After that, she said something. Police report is that there are loggerheads, and so that is how I was asking you.
That I agree.
What to de-escalate?
Your
You
Lordship,
have to de-escalate. That's the only option. So that they don't do.
from the information that I received, Your Lordship, there is no such allegation. And Your Lordship, what I am
So
praying.
that is how I asked the investigating agency.
Yes, Your Lordship.
See whatever you just see that report.
I agree, Your Lordship. This was done after Your Lordship asked for a threat
So
perception.
this has nothing to do with her allegation. I mean, allegation of the informant.
Informant, Your Lordship.
They don't even refer to that. Your problem is that there is input from the definite input from the police. So let us know. Maybe you are correct that what they are saying is fabricated something, but that's not part of their part. It's not contained in this report.
Agreed, Your Lordship.
So this report is otherwise sufficient to reject bail. That I wanted to tell you, so that you counsel them. Let him cool his wheels inside for some more time.
Your Lordship,
You see, this is not a solution to this kind of a situation.
agreed, Your Lordship. However, if Your Lordship is competent enough to impose any kind of stringent condition, Your Lordship, the petitioner is 23-year-old. He may be even asked to leave the village if
You
that
see,
is.
the conditions to be imposed on the family members of the victim and the informant. How can it bail order impose conditions?
No, Your Lordship, that is
So that is the problem. That is the problem.
that is a separate issue altogether, Your Lordship.
Yes, so that is the problem. So because after that, after the 23-year-old boy was arrested,
Yes, Your Lordship.
his family members and parents think that the victim is the perpetrator. You see, that's the problem. That's the problem in the society. Why they are at loggerheads? Because if they admit that he has done something, then why they are at loggerheads with each other?
Either way, Your Lordship, that has not been done at the instance of this 23-year-old boy. Even if he is kept inside the custody, Your Lordship, there is no guarantee that such law and order situation would not
Let him test it.
Let that be
So let them test it. If he is no way connected with this, so let him test it then. But by staying behind custody and let them also test it.
Your Lordship,
That is not a submission to be made in this kind of sensitive matters.
no, Your Lordship, I bow down to Your Lordship, and I also agree that counseling is to be done, and I am doing it, Your Lordship. However,
No, counseling means how to de-escalate the thing.
since it is increasing more and more because of this proceeding,
You see, it's not illegal detention. It's not illegal detention.
Your Lordship,
So that's the problem.
Your Lordship,
Your entire case is that since the detention is illegal, so they are quite. They are what you call. They are very reactive.
no, Your Lordship, I do not want to defend their
So
action.
obviously, so that can't be the submission here.
Exactly, Your Lordship.
This is a detention sanctioned by law. There is an allegation of heinous crime against a minor, so he should be behind bar, and he's a major. And he's not a case of 19 or 17 or 18 years boy.
No.
He's well ahead of 18 years. He's 23.
Yes, Your Lordship.
Yes.
My argument.
So the consequences, so in this case, these arguments will not survive. Because if they are not liable for the consequences of their action,
Yes, Your
they are so passionate about that they feel that injustice has been done to their son. He has been illegally arrested. The girl has done all the mistake. So who else will suffer? They will suffer. I hope they will be watching this and they will understand.
In fact, Your Lordship, I bow
Yeah,
to Your Lordship.
they have to understand that.
Yes.
This attitude had spoiled. You see, still the attitude, the girl is treated as a victim. As a perpetrator. No, not as the victim. The whole psyche is that the boy is the victim.
I agree.
And he has not done anything wrong because boys are like that. You see, please appreciate this also. That is how I told her the last week also. The Srajasri Rautray, the Lorette Council, that she has also to counsel.
My lord,
You must consider that it's a case of both being teenagers. Relatively, the girl is a minor and he's relatively less aged boy. He's of 23 years.
This is my submission, Your Lordship.
ଆପଣ ଏଇଟା 21 ରେ ଆସୁ ଦେଖିବା ଆପଣ ଗୋଟେ ଅପଡେଟ୍ ରିପୋର୍ଟ ଆଣିପାରିବେ ଆପଣ what you do, you can give some undertaking.
Yes, Your Lordship.
ଆପଣ ଦିଅନ୍ତୁ.
Obliged.
And the problem is that next time you say, as the court has directed, we have filed an undertaking. You have to walk that extra mile. You can treat the victim and their family like this, as if they are the perpetrators of a crime and you are the sufferers. Here, the wrongdoer is the boy. The family has been a party to it indirectly that they are encouraging the boy to behave like that. That should be the attitude. Can you get an up-to-date status report by a quiz?
threat.
Threat to ଦେଇଛନ୍ତି ନାଇଁ ସେମାନେ threat ଲେଖୁନାହାନ୍ତି ସିଏ ଗୋଟେ peculiar report ଦେଇଛନ୍ତି ସେ law and order problem.
Yes, regarding this one, they said that they have not received it. That this has been given in.
not registered, my lord. I'm also said on
Right. You see, you are right that it has not been registered.
not registered, my lord. Only what happened, my lord, as my lord directed that to council. I already done that before 2 weeks, my lord. But my lord, on the day when I was talked with them, they clearly mentioned that, my lord, it was happened in the field, cultivated field. After that, my lord, they as the girl who is in school, says in school, she is unable to go to school also because in the midway they are threatening her, and in the family members has been detected me.
Problem, Miss Rautre, have they lost that complaint of the girl being threatened on the way? Where is that? Where is that registration? This has never been received by the police.
My lord, 3 times they have been went to police station, and police has just assured them that we will look into that. We will talk with the family to not doing such kind of things. And eventually, the police.
Also, it's a serious allegation. The police is not entertaining their complaint.
My lord, sometimes, my lord, dear lordship may kindly see, if you will go to other aspect, my lord, there sometimes, my lord, come with, my lord, different type of allegations and for settled scores, my lord, all those things.
No, here, there, at least there is a written report. Now you take action on this.
A written report will receive.
The other part is that, because why they will tell lies that we went to the thrice to the police station.
My lord,
You see, the police also, I understand police has a limitation. I mean, it's not kind of a preventive policing. Preventive policing, as far as this kind of a situation is concerned, is very difficult. But Ms. Rautre, see, traveling to school, there will be no problem.
It is always open for them to agitate there while going to the police station.
They are saying that they went to the police station, police did not respond thrice.
My lord, this has been given in the Phandi, my lord. Chodai Dhara Phandi.
Jyoti. Phandi mane not that je apanakar bit house.
Yes, ma'am. They say that nothing has been received from them. Let them, my lord, dear lord.
My lord, if they will not receive that, this is not our fault. The victim has been.
That is what I'm asking them.
And my lord, the main thing is from last 2 weeks, there's 3 contact numbers of the victim family with me, which is not connecting. And from last 2 weeks, I'm not getting.
Cannot do anything.
Yes, my lord, absolutely.
Cannot do anything. If they are not receiving the calls from the lawyer.
No, my lord, not connecting. And also, my lord, I'm only to define that I'm not expecting that.
Don't put any conspiracy behind that.
Yes,
Nobody can know why this network is connecting, or can't so sure that it is attributable to the. I mean, this petitioner's family or petitioner.
My lord, I'm not expecting that, but my lord, this is happening back to back, so that obvious, my lord, this.
No. You are too skeptical. They have to support the girl, the family. They have to take the responsibility. They can't simply go to the police because they have to be brave enough to go to allow her to go to school.
Absolutely.
You see, being apprehensive and that's another thing. But being threatened physically is something else.
Yes, my lord.
Receiving a threatening call.
About the last threatening call and the threatening, I husband submitted the paper, the FIR with the memo as per directed by.
I have never received it. That she says. In fact, I don't think she's aware of that.
My lord, and
So
at that
what
point of
she's
time.
saying, so there can be a fabrication of this story, but that is petitioner's counsel is saying, and that also is in sync with what they are saying, that they never received any complaint.
My lord,
If the petitioner is in custody, then what is the hesitancy of the police to receive a complaint?
This
It's
is
not that it's a fresh case.
yes, my
Logically
lord.
also, why they will refuse?
My
Why
lord,
they will refuse?
this is the reason there are 3 times just to the informant.
You must ask your client. You must ask your client that why the police will not, because already they have put somebody behind bar. Why they will not receive a further complaint against their family? What is the reason? What is their interest?
My lord,
You see, suppose this is the first instance you are going to the police and lodging a complaint. They are not registering. Then it's an issue. But they have already, and he's behind bar because of the police actions.
that is the reason, my lord, the family members have.
Everything is not good also, because that doesn't serve the purpose. And everyone is a right. Everyone has right of liberty.
That is the reason I'm showing that last 2 weeks I'm not getting any information from the informants side.
That doesn't help in adjudicating the matter.
Yes,
You see, I'm not considering a petition where if the person not responding to the phone call, what would happen? That's not the petition's, the prayer in the petition. You obtain instruction by 20th, if you let us try to take it on 21st.
Regarding lodging of this complaint. Or
No, any improvement in the situation. Because she says now she is not getting any instruction. Informant's counsel, they remain incommunicado as far as phone calls are concerned. Maybe they are not trusting her. I don't know.
My lord, actually back to back, they're getting this kind of prospection like threatening.
They should receive your calls or they should call you. Somebody in distress
Yes.
should not avoid the calls of the lawyer, or they should call you.
My
Your job is not to call them.
no, my lord.
Obviously, so I mean,
That is the reason.
So,
I was thought of my mind that to pray for one.
sufficient time has been given.
Yes, my
Why
lord.
should you adjourn his case? Why should the matter should be adjourned at your instance?
No, my lord.
Due to lack of instruction, I can record that. If you say that there is no instruction, I will record that and I will not adjourn the matter.
No, my lord.
Because you see, at least to my understanding is that I will record everything and pass a order.
Yes,
If you say that they are not giving you instruction for that reason, it can't be adjourned. No.
but my lord.
It is not their choice and luxury that whenever they pick up the phone, they will take some time to call you. If they are interested, they will receive your phone. No, that is not your job also. I have a different aspect that whether there is any. Then you obtain instruction. What are the plans for that prevention of law and order situation? It's a coach and up-to-date instruction. Because that can be a failure of policing. If they admit that they cannot control it, then it is a failure of policing. You tell them that.
If release on bail.
It is somewhat, no, it is somewhat irresponsible letter also. That's ଅଛନ୍ତି କାହିଁକି?
Yes. They say
ଯଦି ଦୁଇଟା ଫ୍ୟାମିଲି ଭିତରେ law and order situation ହେଇଯିବ, they cannot handle it. They apprehend a law and order situation.
Yes.
Then what is the policing part?
Yeah, they apprehend my lord every
It is like this, Mr. Standing Counsel, by releasing a boy of 23 years of age, can the court say that heaven will fall and they will fight it out, the family will cry among themselves? Can that be reason for determining somebody?
No.
That is the question. So the pertinent question is that whether victim has been threatened or not.
Yes.
And as you say, no complaint has been received. She says no recent occurrence earlier. By this time you try to pursue it. They should come, they can file affidavit.
I must ensure,
They can file affidavit here.
oblige your lordship by the next.
Such incidents or there will be no such incidents. You file that affidavit.
Oblige your lordship.
And as for you, since they are not contacting you, you will be saying no instruction.
Yes.
And if they contact you, the court is not waiting for the instruction. No court should do that actually.
I will take up-to-date instruction on the law and order situation. And what?
No, why they are saying law and order situation?
I love it.
And when hardcore criminals are released, they are not taking that plea. That is very interesting. But in their district, there is no hardcore criminal. Jajpur.
Yes,
Yes, my lord.
They are hardcore criminal.
The instruction should not be like that.
Victim, they are avoiding to appear in court.
I will like to talk with him and get the proper instruction.
The Lord Counsel for the petitioner reiterates her prayer for bail, considering her age to be about 20, the age of the petitioner being about 23 years, and he is in custody since 25/5/2023. And in the meanwhile, final prosecution report has been submitted on 24/6/2023. The Learned Counsel for the informant submits that despite her efforts to contact the petitioner's family to obtain up-to-date instructions, they are not receiving any calls.
Informants.
I'm sorry, the informant's family. The Learned Counsel for the informant submits that despite her efforts to contact the family of the informant who are looking after the case, they are not receiving, or you are saying something?
No, sir, not receiving.
The phone are
Not connecting after the last written information.
The phones are not connecting. No conspiracy theory in the
Yes, my lord. I am not one.
Para. The Learned Standing Counsel shall obtain up-to-date instructions in the matter from the Law Enforcement Agency. List on 21/12/2023. If you can get any affidavit
Oblige your
to support their claim that there will be no incident, you do that. I am not directing anything or observing anything for obvious reasons, because it's for you to, I mean, the petitioner's family to say on their own.
Bless you.
Yes.
That item 18, my lord, has passed over. My lord, we have not received any instruction regarding third perception. We'll take it, my lord, you'll also call it after tomorrow, my lord. Get it to telephone.
Petitioner done, Mr. Standing Counsel TK Praras for the state. Though the matter was disposed of by order dated 2011-2023, it was directed. The concerned police was directed to make local inquiry through the SDPO regarding the threat perception, if any, against the informant by the petitioner, against the informant and their family from the petitioner. And at Standing Counsel seeks further accommodation to obtain the updated instructions as paid for list on 21-12-23.
Item 20.
May I please address?
Yes, please, Mr.
My lord, the petitioner is in custody since 14/7/2023. Earlier,
You are Mr.
Vikas Chandra
Parija. Look, you have no power.
I have power.
Item 20.
Yes.
Mr. B.C. Parija. For the petitioner, Mr. Standing Counsel. तो बलराम खरा लिखा है चीज
Consent paper.
ओह अच्छा अच्छा आपण you are appearing apart from them or along with them?
Apart from.
बलराम खरा रमणीकांत पट्टनायक टी विश्वेश्वर समस्ते
सेटा टिके एपर सेपटा कि अछि रमणीकांत पट्टनायक विकास चंद्र परिजा and some air Honda. We are the advocates after getting consent.
Name of Mr. Balaram Khara appearing for the petition will be deleted. Yes, what do you say?
Mr. Ramanikant Patnaik and associate.
Yes, it is there. But everything has been written, so that is how it is confused.
But the petitioner is in custody since 14/7/2023. Earlier occasion, who has released on bail by this honorable court by the order dated 9/1/2019. This is a case of
condition that he will indulge in similar kind of activity.
No criminal understanding.
Belgium.
Belgium due to illness. He was unable to appear on the date for that reason NBW was issued and he was taken into custody.
Well, as for rejection,
instruction that
say order
verify kalegi.
That has not come.
Release order.
I know.
See, release order देखिए कि मैं 5 बार order टा करछि.
Yes, my lord. Regarding the health, actually he was facing rheumatism or not, my lord. That.
No. After he jumped the bail, so-called bail jump,
he was ill.
That was the only occasion he was taken into custody. That was the only reason, rather.
Yes.
No other reason.
In the meantime, trial has substantially progressed, my lord. In the meantime, most of the, my lord.
No, he was granted bail. You have not answered that. He was granted bail.
Yes.
So, how it is relevant whether trial has progressed, investigation is completed or not, post grant of bail?
Yes.
167 to no? Mr. B.C. Parija for the petitioner, Mr. Standing Counsel for the state on 5/12/2023. After hearing the learned counsel for the appearing parties, the following order was passed. In terms of the said order, the learned Standing Counsel submits that the petitioner was in fact granted bail by this court. The order dated 9/1/2019 in Bill April number 944 of 2018. Thereafter, as the additional session judge cum special judge Koraput in city number 126 of 2015, arising out of Machkund PS case number 64, would indicate the petitioner did not appear during the course of trial and was taken to custody subsequently. During course of trial on लिखिए 8/2/2023. Mr. Parija, it is correct?
My lord.
Yes. Having heard the learned counsel for the petitioner and the learned standing counsel, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, disposed of accordingly.
21.
Yes.
May I please, your lordship?
You are Miss Samal, P.K. Samal.
Again, B. Mr. B.
You are Miss B. Misra.
Again.
Miss B. Misra for the petitioner.
Sir, vacation, sir.
Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioner seeks further accommodation to advance arguments as prayed for Mr. Date है 10/1/20 24 10 Sunday no तो 10/1/2024. The learned say AC submits that case diary is available. Yes, next.
Obliged.
May I please, my lord? Last
Prashant Kumar Ponda for the petitioner. Yes.
last occasion, your lordship directed me to file an affidavit
Yes.
with regard to the status of the case, my lord. Now, my lord, status means, my lord, it is pending for all the cases are pending for the Viswankotta court, JMFC Viswankotta. But because of formation of new court that would be on 23rd, no file is made available, my lord. That is, I am not able to find out the.
Sir, last order you were referring to 3011 order.
Yes, yes. 1311, that is in.
Details of status of which case we were pending against the petitioner.
Already filed the affidavit.
Quebec.
That is filed in later, that is.
Can you tell the date?
Exactly date, my lord, I have not mentioned, my lord.
Affidavit date Quebec.
Date I have not mentioned, my lord. Order sheet, my lord, I have not mentioned.
Then how do I reflect that in the order? I can't reflect it. If you don't give the details, how do I reflect?
Not my
lord. The order is 3011. It can't be October, sir.
Prior to that, my lord, I have filed the
30. Kindly read the 3011 order. You are having copy of the 3011 order.
2023 first payment I have filed.
Sir, you are not listening then. I'm telling you that after 9/10/30/11 the order has been passed.
Yes, my lord.
So you are saying in October it can't be. October. Sir,
That order, my lord, I am requested to file another affidavit.
Sir, you are saying that you have filed that affidavit.
No, I have not filed because of the difficult ballot, because of permission of another
Mr.
court.
P.K. Ponda for the petitioner, Mr. S.S. Mahapatra, AC for the state, Learned counsel for the petitioner seeks further accommodation to file affidavit in terms of the order dated 30/11/2023. Further affidavit, further affidavit. How much time, sir?
The first week of January, my lord.
Affidavit by first week of January.
Yes, madam.
The affidavit, as paid for, the affidavit shall be filed by 5/1/2024. 5/1/2024. Copy of the affidavit shall be served on the learned counsel for the state to enable him to obtain instruction. List on 17/1. You have filed affidavit by 8/1 then?
Next second week of January, my lord, you will also list it.
Affidavit.
Yes, madam. First week I will file, and second week you will also make.
Second week 12, 8/12. 12. 8/1/12. Yes, next.
23.
Sir?
Niranjan Behra.
So Niranjan Behra for the petitioner, Mr. S.S. Mahapatra, AC for the state. Yes.
My lordship, though there was no direct or circumstantial evidence in the police report, last occasion my lordship directed to the government standing counsel to submit whether the accused number 2 was present at the time of occurrence. Only the matter was concerned for grant of bail, accused number 2, my lordship.
Oh, but how this was how this has not been investigated? You are saying that she's a lady. Instruction, Mr.
My lord, on the last occasion, lordship had directed only to with regard to the
Statement of the victim.
Yes, my lord. UD case registered and a statement of the victim has been registered or not. My lord, recorded or not. My lord, I have received the instruction that after occurrence took place on 1st April. And my lord, she was taken to hospital. The deceased was taken to hospital, and no, there was no complaint of any my lord, torture or something. For that, she was admitted in hospital, and there was reported as a medical legal case. Registered at medical as a medical legal case.
Medical legal case.
It was not informed to the police, or it was not investigated. After her death on 6th April. My lord, that was sent to the UDPS case was registered. It was intimated to the police by the hospital authorities, and thereafter it was proceeded. By that time, she deceased her already dead, and the FIR was registered on 7th. FIR, my lord,
FIR कौन plain paper मैंने police information ना नहीं
FIR देले my lord, the father of the deceased lost the FIR on 7th, my lord. 7th April. Deceased died on 4th April. My lord, set fire on 1st April. Thereafter hospitalized, and in criminal investigation, the father made statement that my daughter was subjected to torture, and with regard to demand of dowry, and family members set fire. But this fact only after registration of the FIR on 7th. By then, deceased had already died. For that, my lord, neither dying declaration 164, no statement was recorded of the victim. And the doctor has been examined by the, as per your lordship's direction. The treating doctor, my lord, P.L. Chanda, who had admitted the deceased in hospital, he was examined, and he stated to the police that as there was no allegation of any torture or malpractice by the in-law members, there was no complaint made to the police. Only it is
other disturbing part is that माने अपन 12 पेज से देखंतु
my lord. Yes, my lord.
12 पाइले
My lord.
मो झियर
My lord.
ना पेज को मिसिंग ही गला की
My lord.
नहीं अपन यदि 11 पेज लास्ट लाइन टा पढिए तो मिसुनी दा सारे कोन
11 पेज रो अनेक थोड़ा बुझासुझा करथिले कि समाधान होई पाला नाही
11 पेज रो लास्ट लाइन टा कोन अपन ब्रीफ रे
मो झियर गोटे पुओ
और तो किछि नाही
नो मतलब दैट इज इनकम्प्लीट
ताले सेटा कोन मिसुनी दा दिरे एनीवे ताले 12 को आसंतु
मतलब
1/4/23 तारिख रे ଯୌତୁକ ପାଇଁ ମୋ ଝିଅକୁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଦେହରେ ପେଟ୍ରୋଲ ଢାଳି ନିଆଁ ଲଗାଇ ଦେଲେ ଖବର ପାଇ ମୁଁ କଟକ ମେଡିକାଲରେ ଚିକିତ୍ସା କରାଇଲି ଫାଦର ହାଜ ନଟ୍ ଲଷ୍ଟ ଏନି ଏଫଆଇଆର
नो by that time father had not lost any FIR.
अच्छा after this order you say that the investigating agency has gone to the doctor initially where he was admitted or in the Kotak medical
police went after 7th.
I understand. After this order was passed, that why there is no statement of the victim when
he had gone and he had taken the statement of the doctor stated.
Initial जोड़ी जाइथिले
initial मतलब district headquarter hospital
केसीएच को गले सेठू से should refer गले कटक को से 1/4 परे 1 when she died
6th my lord
7/4 6/4
my lord. Expired on 6/4 There is 10
Is it not unusual that the father will also not lodge FIR?
Yes, my lord. That is only investigation taken to motion, my lord, after lodging of this FIR by the.
So what the treating doctor said that he had any, he did not have any information.
No complaint because she stayed in hospital.
And they are saying that Chacha, what is the Ali ବେଡ୍ ଟିକେଟ ରେ କଣ ହଉଛି କେରୋସିନ ନା ପେଟ୍ରୋଲ ରେ କଣ ଲେଖା ମାନେ ପୋଲିସ କଣ କହୁଛି କିଛି ପାଇଛି କି
ସେ କହୁଛନ୍ତି ଯେ only my lord of 40%.
Reason?
No, that there is no reason, my lord. For that, my lord, only medical legal case was registered in medical itself.
14 ଦେଖନ୍ତୁ 14 ରେ ଫାଦର କହିଲେ ତାକୁ କେରୋସିନ ଢାଳି
My lord.
FIR ରେ ଲେଖିଲେ ପେଟ୍ରୋଲ ଢାଳି.
Yes, my lord. There is, I find that variation is there in the statements. But
English ରେ ବି ଟ୍ରାନ୍ସଲେସନ ହେଇଛି ନ୍ୟାଚୁରାଲି ଲେଖା ହେଇଛି ପେଟ୍ରୋଲ ଆଉ ଆପଣ ଏଟା କାହାର ମୁଭ୍ କରୁଛନ୍ତି
Lordship for
ଆପଣ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ତାହେଲେ କୋଉଟା କଣ ଦେବେ
my lord, one is husband and another is
ଆପଣ ମୁଭିଂ ଫର
both my lordship because
ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଦେଲେ
man.
ସେ ଯୋଉ ଆପଣଙ୍କର ଯୋଉ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଆସିଛି କଣ ମତେ ଦେଖାନ୍ତୁ ତାହେଲେ really very surprising and suspicious also. If the family was aware, then initially I was thinking that the family was not there, but family they have got themselves. A subsequent order ପରେ ଏଇଟା ଯୋଉ କୋଉଟା ଆସିଛି ଚିଠିଟା
Subsequently, when the lordship directed to examine the doctor who has treated P.L. Chand and other treating doctors, my lord, he examined the doctors and taken their.
when the past order regarding 22,000 ନା କେବେ ହେଲା 7,000 It is very difficult to understand what has happened. Then why his husband will be in custody also?
Yes. From first to seventh, there is a big gap. From first on the day of occurrence as well as from the date of registration of the affair, there is a big gap. And if that statement will be taken into consideration even after 7 days that there was torture and previous torture, only death is either suicidal or homicidal. The burning of body.
Could be suicidal, could be suicidal burning.
If the allegations will be taken into consideration, then it is homicide because in their house they have either committed or suicidal. That is different. But allegations are there. Even if
What can be done?
lordship may pass.
I don't understand this because they don't complain to the police, they don't lodge FIR, no statement. And now, actually, consistently the doctors are saying that there is no complaint.
No complaint. That I have examined. I have also discussed with the IAC to take up seriously because the lordship had directed.
Because then something has happened, somebody has to be blamed.
Yes.
Usually that is the response of the society.
Suicidal.
If somebody died, so they may say that they have to be punished, but they should have lost the complaint.
That is
And it should have been different. Suppose on the first date on 1/4, the family of the father would have lost a complaint. Because he's aware that his daughter is born, he suffered burn injuries and he's accompanying the doctor.
Yes. That is he is saying in the affair. And had it been there, at least the condition of the deceased either to give a statement or not to give a statement, because lordship kindly see that is the main crux. That 40% burning. If 40% burning is there, definitely she was in a position to.
Unless there is some facial injury.
Yes.
Suppose kerosene or petrol was the flammable substance was poured over his face. That's unable to speak. That's another thing. But I don't understand what has happened here.
My lordship, last occasion, my lordship directed to the government advocate to submit whether they were present or not at the time of occurrence. That is the big question for this matter, my lordship.
No, I mean, the affair is not very clear.
My lordship.
You see, I am not against anything particular. I want to try to
judge.
I'm trying to pursue the truth.
My lordship.
To understand what could be the truth. Because the circumstances are very strange. You produce the copy टा आपन पाखरे अछि ना
FIR copy
नहीं FIR copy ना से जो केस डायरी जोटा आपन फर्दर रिपोर्ट आनी छथि जोटा
that with regard to registration of the medical
this up to date after
your lordship's direction.
हाँ
My lord.
Those 2 pages.
My lord.
Mr. N. Behra for the petitioner, Mr. S.S. Mahapatra AC for the state. The learned additional standing counsel refers to the earlier order dated 22/11/2023. On 22/11/2023, the following order was passed. Quote kar debe. That will simplify. On 1/12, the order dated 22/11/2023 was reiterated and the following order was passed. Taku quote kar dele. The learned the additional standing counsel submits that in response to the same, he has sought for instructions, and the IAC, the concerned IAC, that is Khoira PS, Khoira. The district of Balasore has provided instruction that is part of the further case diary. Copies of the said instruction along with the extract of the case diary is kept on record. Or this is attested copy. By provided instruction by letter dated 29/11/2023. এটা ରଖି ଦେବେ ରଖି ଫେରେଇବେ କଣ ତ କପି ନଥିବ
I'll get xerox of it.
ନେଇଯିବେ
My lordship, please consider only let the accused person, my lordship.
ରୁହନ୍ତୁ ଟିକେ ଆପଣ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି.
My lords.
The learned counsel for the petitioner submits that the petitioner is in custody. Both the petitioners are in custody since
My lordship, 9th April 2023
and 9/4/2023
and another
meanwhile
1st May 2023.
Petitioner number 1 from 9 April 2023, petitioner number 2 from
1st May 2023.
1/5/2023,
My lordship.
9/11 again. ସବୁ କାଟି ଯାଉଥିଲେ. It is submitted by the learned counsel for the petitioner. मूलରୁ ଲେଖନ୍ତୁ କାଟନ୍ତୁ ଆଜ୍ଞା.
submission submitted by the learned counsel for the petitioner that the petitioners that petition number was in custody was petitioner number 1 is in custody since 9/4/2023 and the petition number 2
1/5/23
from 1/5/2023. The petitioner number 1 is the son and the petitioner number 2 is the
mother-in-law.
they being the husband and the mother-in-law respectively. The learned additional standing counsel referring to the materials contained in the case diary opposes the prayer for bail. The learned counsel for the petitioner submits that considering the period of incarceration and the fact that in the meanwhile the final prosecution report has been submitted on
5/8/2023.
The petitioners be shown indulgence as far as prayer for bail is concerned. Para. As would be evident from the orders dated 22/11/2023 and order dated 1/12/2023. This court expressed this court wanted to verify from the prosecution agency as to the sequence of events that led to not recording of the statement of the victim who was alive, having suffered 40% burn injury from the alleged occurrence on 1/4 na 1/4/2023 till 6/4/2023 7/4 7/4 से एक्सपायर कर लेना 6/4/2023 she was taken to initially to the district headquarter hospital Bhadrak and the district headquarter hospital and they referred to the SCB Medical College and Hospital Para. From the affair, it is evident that the father has lost the affair and stating that his daughter was burnt by the in-laws. Her daughter suffered burn injuries inflicted by the in-laws, and he had brought his daughter for treatment. Para. From the case diary dated 6/11/2023, from the narration oblique recording in the case diary dated 6/11/2023, it is indicated that the investigating agency have examined the treating doctor at SCB Medical College and Hospital, SCB-MCH. As there was no allegation by any of the family members accompanying the victim when she was treated from 1/4/2023. कौन लिख ले सेंटेंस टा पढ़ो तो हाँ
By any of the family members accompanying the
allegation regarding any untoward incident.
by any of the family members accompanying the victim when she was
Treated from 1/4/2023 till 6/4/2023 in the SCB-MCH. Para. The learned counsel for the petitioner further submits that the petitioners are local residents and shall subject themselves to the jurisdiction of the learned court in season of the matter and shall abide by any terms and conditions that will be imposed by the if the court is inclined to grant bail to the petitioners. The learned additional standing counsel referring to the materials contained in the case study and the nature of allegations opposes the prayer for bail. Having had the learned counsel for the petitioner, the learned additional standing counsel for the state, and considering the material, particularly the case diary,
produced by the investigating agency, the court is inclined to grant bail. This court is inclined to grant bail to the petitioners subject to such stringent terms and conditions that will be imposed by the learned court in session of the matter. We shall also include a condition that any violation of public deviation from any of the terms and conditions that will be imposed shall result in filing a petition for cancellation of bail by the investigating agency oblique informant, disposed of accordingly. এটা ଆପଣ এটা ରେକର୍ଡ ଆପଣ ତାପରେ କପି କଲା ପରେ ଫେରେଇବେ କେସଟା ରଖିଲେ ତ ଉପରେ ଲେଖିଛନ୍ତି ଟେକନ୍ ଅନ୍ ରେକର୍ଡ yes next
Pardon me, Lord. On behalf of VP Rautra, I am seeking for adjournment.
Item 24.
My Lord.
Your name, sir?
Sunil Kumar Panna.
So S.K. Ponda on behalf of VP Rautra for the petitioner, Mr. S.S. Mahapatra AC for the state, learned counsel for the petitioner seeks accommodation, further accommodation. On 12/12/2023, the following order was passed. I will let you know. Adjournment is sought for on behalf of the learned counsel for the petitioner to advance arguments. As paid for, list on, maybe one, sir?
I don't know, after this.
17 So 17 or earlier you want?
He's directing me to seeking adjournment after vacation.
17/1/24. लिखिए मिस्टर डीके पंडा पर इंफॉर्मेंट लिखिए क्या ଆପଣ ଦେଖିଲେ ହଁ ଡିକେ ପଣ୍ଡା ଭାଇ ଆପଣ ସେ ଡିପୋଜିସନ କପି ଦେଲେ
ନା ଦେଇନାହାନ୍ତି
the learned AC and the learned counsel for informant submit that the copies of the depositions have not been served on them as undertaken by the learned counsel for the petitioner as reflected in the order dated 12/12/2023. The copies of the deposition shall be served on the learned AC as well as the learned counsel appearing for the informant within 2 working days. Yes. And the copy of the deposition shall also be filed in the court for consideration. तो perusal कर दे. Petitioner none. Mr. S.S. Mahapatra AC for the state, none appears for the petitioner when the matter is called. None had appeared when the matter was called last taken up on 1/12/2023. To grant further opportunity to the petitioner this term. No, next week दियंतु तपर week आसुनांती कोन on 11/1/2024. The learned state council shall obtain up-to-date instructions in the matter.
My lord, kindly note that my lord, depositions on the last occasion on 9/11, they have submitted that they have short copy of the depositions, my lord, through AGF's mail on the 26/9, my lord.
এটা কোন দিনে করছেন কইলে?
My lord, item
29/11.
They had submitted before this Hon'Ble Court that on 26/9/2023 they have filed the copy of the depositions on the right. But we have first, my lord, several
it is submitted by the learned AC that the statement of the learned counsel for the petitioner that they forwarded the copies of the depositions of the prosecution witness examined till date by email to the office of the Advocate General may not be correct, as on verification of the said email, they have not found any copies to have been forwarded. The paragraph the copies of the depositions of the PWs shall also be served on the state council Yes.
26.
Yes, 26. So Sushil Kumar Naik for the petitioner, Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioner seeks further accommodation to advance arguments as paid for list on 16/1/2024 to grant further opportunity to the petitioner. The learned AC has submits that he has opted with case diary and instructions in the matter. तो कितने केजी की?
मतलब 206 के 261 केजी में
Okay.
driver, my lord, and he is outside. Lordship may direct him to file affidavit because he is a man of Kolkata. So, my lord, it is very difficult on our part to find his criminal antecedents. We have written several times.
In view of the nature of allegations against the petitioner, the affidavit on behalf of the petitioner shall be filed, indicating the past allegations of criminal activity, if any. Para. The learned AC shall also intimate the investigating police to obtain up-to-date instructions regarding past criminal antecedents of the petitioner from his local area of residence to the SP of the concerned area.
Yes.
I would say in the state of West Bengal. State of West Bengal. Yes. So Jenna. So SK Jenna for the petitioner, Mr. S.S. Mahapatra. So S.S. Mahapatra, AC for the state. Yes, Mr. Jenna.
Offense main order 186, 294, 2333, 330, 307, 353, 506 and 34 IPC. Custody since my lord 26/7 2023. Charge sheet case में charge sheet
Highest offense is 307
है खाली मंडल है चीज पुलिस संगे से गुड जगह रे दुकान
आजकल पुलिस ने कंट्रोल कुछ नहीं मैंने कौन से
No, they were assaulting another. They were assaulting another when police.
Police was assault करें.
Police was.
छोड़ा करो. अपन भी carefully रोचन देता. You are not safe. Mr. S.C. Jenna for the petitioner, Mr. This affidavit is in sync with your instructions.
Yes, ma'am.
Police.
Yes. And also, my lord, the injury lordship may mention the injury were grievous.
One simple, one grievous.
Yes.
The learned counsel for the learned counsel for the petitioner, Mr. S.S. Mahapatra for the state, AC for the state. So that the hard no, appearance लिखिए. First paragraph लिखिए. तापर para 2 लिखो तो the learned counsel for the petitioner submits that the petitioner is in custody. One or more than one petitioner.
Two.
The petitioners are in custody since
26/7/2023.
26/7/2023. In the meanwhile, the final prosecution report has been submitted on
13 PVC 10
Considering the period of incarceration and the fact that final prosecution report is submitted and the petitioners are aged about
30 years, petitioner 1, petitioner 2, 35 years.
Correction कौन है वे? तो बुरा है वो नहीं. अंदर कोई कोई. तब कौन लिख लो? सिर्फ लिखो तो नहीं. Submitted that the petitioners should be shown indulgence as far as prayer for bail is concerned. Hello. It is submitted that the affidavit on behalf of the petitioners have been filed, indicating the past allegations of criminal activity. Para. It is further submitted that the petitioners are local residents. They shall subject themselves to the jurisdiction of the learned court in session of the matter and shall abide by the terms and conditions that would be imposed for grant of bail. Para. The learned Additional standing counsel referring to the materials contained in the case diary, nature of allegations, and one of the injury sustained by the victim being a grievous, one of the injuries sustained by the victim being grievous injury opposes the prayer for bail. ମାନେ ଆପଣ ସୁନାନା ତ ଲଗେଇଦେବେ ଲେଖିଦେବି
ନା
ସେଟା କାହିଁ କହୁଛନ୍ତି ସରି କୁହନ୍ତୁନି you must understand it's a continuous process of discussion. See the grievous injury, grievous injury. This is a prayer for bail. The learned counsel for the petitioner, however it is not disputed at the bar that the final prosecution report has been submitted in the meantime.
Yes.
And the statements made in the affidavit on behalf of the petitioner is in sync with the police report.
Yes.
Para. Having had the learned counsel for the petitioner and the learned petitioners plural and the learned additional standing counsel for the state, considering the material on record, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that will be imposed by the learned court in season of the matter. We shall also contain a condition that in case of any violation of public duration from any of the terms and conditions that will be imposed by the court to grant bail, for grant of bail, shall result in filing a petition for cancellation of bail by the law enforcement agency, informant, victim, disposed of accordingly. So Sushant Kumar Joshi, S.A. Joshi for the petitioner, Mr. S.S. Mahapatra AC for the state, Mr. R.K. Naik, advocate for the informant. The learned counsel appearing for the informant victim being present at the virtual court, Odisha High Court, Kolahandi at Bhavani Patna, addresses arguments. Mr. Naik, you are legal aid?
Sir.
Sir?
Please, your lordship, yes, I have.
You have been engaged to legal aid?
Sir.
Being engaged to legal aid upar korte. Learned counsel for the informant being engaged through the DLSA kar debe. But legal aid kar debe, DLSA. Yes, what is your instruction? You are opposing the prayer for bail.
Sir, I am opposing for prayer of the bail because all the offences are very serious and grave in nature.
No, that is that. I mean, the learned AC is there too. You have to only assist him.
Sir.
Yes. Yes, please. 164 statement.
Yes, madam. That is there.
What is the age of the accused?
Accused is 35 years old. He is a married man. And the victim is 15 years old.
Motorcycle ଆପଣଙ୍କର ଚାଲି ଯାଇଥିଲେ ସକାଳ 4ଟା ବେଳେ
initially offender 363 IBC.
ଆଉ କୋଉଥିରେ ଲପା ହେଇଥାନ୍ତା ସେଥିରେ ଇନିସିଆଲି କୋଉଥିରେ ହେଇଥାନ୍ତା ମୁଁ ଶିଖି ପାରିବି ନା the best part of the profession is that every day I am learning. Yes. So initially କୋଉଥିରେ ହେଇପାରିଥାନ୍ତା ଆପଣଙ୍କ ହିସାବରେ
minor 363 का हବ
ଆଉ କଣ ହେଇପାରିଥାନ୍ତା 302
ନାଇଁ ସଲ୍ଭ
376 ହେଇପାରିଥାନ୍ତା ଇନିସିଆଲି
ହେଇଛି that is there.
अरे इनिशियली जोटा आपण कहले कोन कहउछथि इनिशियली कैन इट बी 376
नो
देन व्हाई यू आर सेइंग दैट कैन इट बी पॉक्सो इवन
नो इनिशियली
सीधे चारटा बेले जाई कि बुलावली करके 7टा बेले आस्थांते और सेटा हितांता 376
नो
त खाली रहतांता आपण कर मिसिंग रे बढी नतांता
allegation that on the date of occurrence that 25/6/2023 at about 10 a.m. the parents of the victim did not found her, and subsequently they came to know that he fled away with the petitioner. That the petitioner and the victim both
this fellow was staying with his family.
Yes, both has from the same village, same port, Hamlet.
And this person, this married person, this perpetrator was staying with his family also.
Yes,
he is having children.
Yes,
then you have no case. You have no case.
As far
as bail is concerned.
So far, what the stage is concerned.
The learned counsel for the petitioner seeks accommodation to obtain instruction and advance arguments, and so to obtain instruction regarding stage of trial, present status of trial. The learned counsel for the petitioner seeks accommodation to obtain instruction regarding present status of trial and advance arguments. The learned to grant further opportunity to the petitioner list on
Reopening the first week.
first week with opinion, second week.
As it was.
10-1-20-24. The learned additional standing counsel produces the case diary, including the statement of the victim recorded under section 164 CRPC. The learned counsel for the informant opposes the prayer for bail. Yes. प्रत्येक डेट केवे कहले
10th.
10-1 मिस्टर नायक 10-1-24. Yes.
29 madam, on behalf of SP Das madam, after vacation madam.
You are Mr. You are also Mr. Das?
No madam, on behalf of SP Das.
Upon SK Das?
Manas Ranjan Pradhan.
Manas Ranjan Pradhan, M.R. Pradhan. Henceforth I'll remember. Mr. Manas Ranjan Pradhan, on behalf of SP Das for the petitioner. Mr. Gandhi kaun kale? What offense Gandhi has committed?
394. 394.
Ahimsa Parama Dharma na kaun. On the learned counsel, the adjournment is sought for on behalf of the learned counsel for the petitioner to advance arguments as prayed for list on 16-1-2024 to grant further opportunity to the petitioner. The learned AC refers to the reiterates his submission that the details of the past allegations of criminal activity should have been indicated in the affidavit filed on behalf of the petitioner through his wife, Para, as undertaken by, as indicated in the order dated 4/12/2023. The learned counsel for the petitioner shall obtain ultimate instruction regarding the details of the allegations, that is the PS case number, status of trial, comma, status of trial, comma, whether the petitioner has been released on bail in any of those cases, and other relevant instructions. Yes.
Okay. Sub-item.
Sub-item re kaun hoga?
Same matter. The affidavit file, my lord, their lordship kindly have a glance. They have from criminal assistance from serial number 3 to 5. Only GR case numbers has been given. No PS case has been mentioned. Lordship kindly. They have clarified with offenses, my lord.
कौन लिखले? ଆପଣ ଯୋଉଟା ଲେଖିଲେ କି ଡିଟେଲ୍ସ ସେଟା କଣ ଲେଖିଲେ ସେଠି? PS କେସ୍ ନମ୍ବର PS କେସ୍ ନମ୍ବର ଡିଟେଲ୍ସ ଅଫ ଆଲିଗେସନ ଲେଖି ଦିଅନ୍ତୁ, କମା ଡିଟେଲ୍ସ ଅଫ ଆଲିଗେସନ। ଜାଣିବନି, ଆପଣ ଜାଣିପାରିବେନି କି କିଏ ଜାଣିପାରିବେନି, ତ ସେ କରିବେ କଣ? ସେଟା କେମିତି ଆଣିପାରିବେ, କେମିତି ସେ ଯୋଉ କହୁଛନ୍ତି ଆମେ ଆଣିପାରିବୁନି ବୋଲି, କଣ ତାର ଆନ୍ସର କଣ?
ସିଏ ଆଣିପାରିବେ
ନା, ସେ ଆପଣ ଇଏ କହୁନାହାନ୍ତି, ମିଷ୍ଟର ପ୍ରଧାନ କହୁନାହାନ୍ତି, ବଟ୍ ବହୁତ ବେଳେ କହୁଛନ୍ତି ଆମେ କେମିତି ଆଣିବା, ତୁ ଜାଣିନୁ କିଛି।
ଆଣିବାନି, ଆକ୍ୟୁଜ୍ ପଚାରିଲେ ସେ କେତେଟା କେସ୍ ଫେସ୍ କରିଛି ସେ କହିବ।
ତାର ଯୋଉମାନେ ବିଶ୍ଲେଷଣ ଆଣିବେ,
ଆଜ୍ଞା, ସେ ଜେଲରେ ତାଙ୍କୁ ପଚାରିଦେଲେ ସେ କହିବେନି କୋଉ କୋଉ କେସରେ ଏଣ୍ଟାଙ୍ଗଲ ହେଇଛି।
ଏମିତି ବ୍ୟାଖ୍ୟା କରୁଛନ୍ତି, ସେ କେତେ କରୁଛନ୍ତି ଜାଣିପାରୁନାହାନ୍ତି, ବହୁତ ହେଇଗଲାଣି।
15, 17, 22 ଆସିଛି ଆପଣଙ୍କ ପାଖରେ।
ବେଲ୍ ବେଳେ ଜାଣିପାରୁଛନ୍ତି। ଠିକ ଅଛି, ସବୁ ଆଇଟମ ସେମ୍ ଅର୍ଡର।
ନେକ୍ସଟ ସେସନ ପାଇଁ ବି ପ୍ରିପାରେସନ ରହୁଛନ୍ତି, ଏଠୁ ଗଲେ ଆଉ ପୁଣି
ସାର୍ କଣ ଲେଖିବେ, ଏକା ଆପିୟରାନ୍ସ ସମାନ, ସବୁ ଆଇଟମ ଆପିୟରାନ୍ସ ସେମ୍। ନା ନା, ସରି, ଭାରତ ଭୂଷଣ ରାଉତରାୟ ଆପଣ ସେକେଣ୍ଡ କେସରେ ନୁହନ୍ତି, ଟିକେ ଆପଣଙ୍କ ନାଁଟା ରହୁ, ସେ ଅନ୍ ବିହାଫ୍ ଅଫ ଆଡଜର୍ନମେଣ୍ଟଟା ଦିଅନ୍ତୁ।
adjournment
non appearance କାଇଁ କରିବା?
ଆଜ୍ଞା
ଆପଣ ତ ଭଲ adjournment ନଉଛନ୍ତି।
ନାଇଁ ନାଇଁ ସେ ସାଙ୍ଗଟା
ସିଏ ବି ଆପଣ କଣ ଶତ୍ରୁ?
ଶତ୍ରୁ କେହି
so popular in the bar. Yes. ତାଙ୍କ ନାଁ ଲେଖିଦେବେ ଆଉ। I pray for one adjournment. Mr. Nityananda Mahapatra for the petitioner. Mr. Devashish Naik AGA for the state. The counsel for the petitioner seeks further accommodation to obtain instruction and advance arguments as paid for list on second week. List on 18/1/2024. So
30 my lords, Mr. Mahapatra.
Mr. S.S. Mahapatra.
31 is mine.
Mr. S.S. Mahapatra AC କରିଦେବେ appearance ଟା. The learned AC submits that case diary is available. Yes.
31.
Lords, on behalf of SK Pari, kindly adjournment the matter.
Miss case लिखिए 31 में 60 of 2005. Your name?
Itisri Maharana.
Miss Itisri Maharana on behalf of
SK Pari.
No. For senior advocate, don't say that.
Okay, sir.
You cannot appear on behalf of a senior advocate. Senior advocate is not holding any brief. He's engaged. On behalf of Mrs. Minalini Pari, M.S. Sahoo for the opposite party, Mr. Devashish Naik for AGA for the state. Appearance लिखिए. As paid for by the learned counsel for the parties. List on 11/3/2024.
Obliged, Mercy.
This, my lord, is one of those few cases where at least there is some merit.
Okay. No, there is observation on 2011. The learned counsel for the state shall go through the order, copies of the deposition.
My lord.
Before the learned trial court, apart from his submissions, made in support of the prayer for the condemnation of bill to appraise this court regarding merits of the case. Se order ta repeat कर देवे. Miss case से लिखी हुए on 2011/2023 paragraph 1 लिखते हैं ना. The following order was passed. Paragraph 1 टा quote कर देवे. तापर लिखिए कौन? The learned counsel for the opposite parties seeks accommodation. List on एते हो. Yes.
32.
32.
big
with 77 এটা তো মেইনটেনেবল বলে কোন স্যার আছে
Again, there's an SR report also. Again,
566 days delay.
Actually, 2/376 to the SR report. SR report
SR se କହୁଛନ୍ତି what we are discussing, they say that it is 378(1) and 3 maintainable over 377 रे sessions को जिबे.
Then your lordship may direct
liberty होउछ आपण
to withdraw to liberty to the appropriate court of law, and the delay, my lord, in filing the in between the filing and that may be
सेटा केंति होबो कि कोन छि कहले आपण फाइलिंग रे 566 दिन हे छि.
that will be taken.
566 I cannot condone now.
566 my lord cannot touch.
566 होबनी.
after now.
हां. The following order was passed. The stamp report dated 7/12/2023 of the assistant registrar assistant registrar of the registry indicates the following. At a page 3 to देखिए लिख देवे. लिखा है maintainability, then colon, then section 377 कोट रे लिखिबे. देखिए लिख दे पारा. In view of the order dated 3011, the order dated 30/11/2023 was also passed after hearing the learned Standing Counsel for the state. Today, the learned the AG also refers to the said provisions contained in the CRPC. And it is fairly stated that after the amendment with effect from 23/6/2006, the appeal would lie to the learned Sessions Court under section 377 of the CRPC. Para. Accordingly, the petition stands disposed of. However, with liberty to move the Sessions Court, the period of pendency before this court that is from 20/4/2006 till filing of the move the Sessions Court within how much time? I have to fix a time. Within 4 weeks.
Within 4 weeks.
Within 6 weeks.
6 weeks.
Within 6 weeks. Within 6 weeks.
The
period of pendency before this court from the date of filing, that is the filing date
10/1/2005.
10/1/2005 from 10/1/2005 till disposal, that is 18/12/2023 shall be considered in view of the sections limitation act 5 na 7
5.
नहीं जोटा रे अच्छी जे अल्टरनेटिव प्रोसीडिंग गुड फेथ रे
ओहो सेटा 7 बदर
shall be considered to be bona fide to the extent that the remedy of to the extent that the present petition was pursued bona fidely. Pursued bona fidely. However, the period of delay, then suppara, however, again suppara ko lekhe however, comma, regarding the period of delay in filing the CRL LP on 10/1/2005. No opinion on merits is expressed by this court, which shall be considered on its own by the learned Sessions Court if the appeal is filed within 6 weeks. Yes.
33.
Petitioner none.
Well, it is in process. Last time also in process. That is rejection of 311 petition, my lord.
Petitioner none. Mr. Standing Counsel for the state. None appears for the petitioner when the matter is called. None had appeared when the matter was last taken up on 15/11/2023 and it was urgent to grant further opportunity to the petitioner. The defects as pointed by the staff reporter by the office note dated 13/11/2023, reiterating the earlier note dated 29/8/2012, has not been removed. Para. The learned Standing Counsel referring to the prayer in the petition that is challenged to the rejection of a prayer made in a petition filed under section 311 of the CRPC
For recalling the witness.
Submits that nothing would survive at present before this court for adjudication. Para. Having heard At the learned standing counsel, the petition stands disposed of.
34.
The conviction under section 417 for 7 years.
Okay.
Which was confirmed in the appellate court, my lord, has resulted the revision.
That surrender certificate not filed, যেটা যে ওটা order ଥିଲା Justice Patel করা বোধে।
Surrender certificate. Surrender because of granted bail, my lord.
No. Mr. That is 3/1/13 order.
No.
3/1/2013. The bail application shall be filed after he surrenders.
Therefore, my lord,
সেটা নাই এপর্যন্ত নাই তারপরে লিস্ট হয়নি আর গোটে থর এই 2023 রে ফার্স্ট টাইম লিস্ট হলা 1/11/2023 রে
you have to take instruction.
You have to take instruction. The learned Mr. Manas Chan for the petitioner, Mr. Standing Counsel for the state, learned counsel for the petitioner seeks accommodation to obtain instructions in terms of the earlier order dated 3/1/2013 regarding filing of the surrender certificate by the petitioner as noted in the said order. Para. In after as prayed for list on 13/2023. And further opportunity.
Sorry, my lord, the copy of petition may kindly be given to us, my officer.
The learned standing counsel submits that his case brief has been misplaced. The learned counsel for the petitioner shall serve an extra copy of the petition and the learned in the learned counsel for the state.
My lord, 23 to 24. My lord, I said to 13 March 2023. My lord, I said.
I'm sorry.
Okay, 20.
Again. In some orders, some notes I have written 24, the files are returned.
In Chalibo.
In Chalibo.
35.
Yes, Mr. Bhuya. Mr. L. Bhuya for the petitioner, Mr. Opposite party by blank. Yes.
Non-appear. Non-appear.
You are for the opposite party?
No, I am appearing for the petition of the last occasion, your lordship is directed to verify whether the notice is sufficient or not. In the meantime, there is noting that notice is sufficient.
ସେ ତ କିଏ appear କରୁନାହାନ୍ତି କଣ ମାନେ ନୋଟିଂ ଯଦି କିଏ appear କଲେନି କଣ କରାଯିବ after we were taking it up after 10 years ଆପଣ ନେବେ notice ଆଉ ଥରେ last thorough noting ହଉଛି ଯେ non appears for the petitioner, that's it.
On the last occasion, I have appeared on 7/11. Your lordship directed office to verify whether the notice is sufficient and posted to today.
No, ସେଟା ଆପଣ ମତେ 3-4 ଥର କହିଲେ କଣ ମୁଁ ଜାଣିପାରୁନଥିଲି ଆପଣ 4 ଥର କହିବେ ମୁଁ ସେଟା ଜାଣିପାରୁନି କି ସେଟା ମୁଁ ଭଲ ବି ଜାଣିପାରୁଛି ଆପଣଙ୍କର ଇନଭିଟେସନ ନୋଟିସ ଟା ଗଲା ସର୍ଭିସ ରିଟର୍ନ ଆସିଲା କି ତାଙ୍କ ପାଇଁ କି ଆପିଲ କରୁନାହାନ୍ତି ଆ ଭିତରେ ପଳେଇଲାଣି 10 ବର୍ଷ ଆପଣ ଫ୍ରେଶ ନୋଟିସ ନିଅନ୍ତୁ the learned counsel for the petitioner submits that since no one is appearing and the matter is for the opposite party এটা মিসকেস রে লিখিবে IA টারে 35 IA মিসকেস হচ্ছে not IA মিসকেস IA 1544 of 2013. The learned counsel for the petitioner submits that since no one is appearing, he may be granted leave to take notice afresh to the opposite party, or I will condone the delay. Then I will take note.
Yes, ma'am. Delay may be condoned. So,
ସେମିତି କରିବା ସେଟା କଣ ଆମେ ତ କିଛି ହିୟରିଂ କରନେ କିଛି ନାହିଁ on the face of it ତ condone କରିଦବା that again becomes କଣ ଲେଖିଲେ opposite party issue notice in the limitation as well as in the admission matter to the opposite party by registered post with AD. Requisites for issuance of notice by registered post with AD be filed within in the present correct address of the opposite party within 3 weeks.
yes, ma'am.
List after SR. The requisites shall contain copies of the petition along with the limitation petition. Okay. But both they need to notice. Yes. Question of admission, admit the hearing and question of admission, you take notice.
36.
Mr. Manish Din on behalf of S. Naik for the petitioner. Opposite party blank, the learned counsel for the petitioner seeks accommodation. As prayed for list on 11-3-2024.
37.
So A. Misra.
37th,
I'm sorry, your name, sir?
My name is Spandan Mahanti.
Mr. Spandan Mahanti, Mr. S. Mahanti on behalf of A. Misra for the petitioner, opposite party blank. IA लिखिए, the learned counsel for the petitioner seeks accommodation. As prayed for list on 18.
Okay. May I please?
Yes.
38.
It's IA notice जाता है 38 रे.
Notice.
Right. IA 75 of 2019.
10/2/2020 matter. Issue notice to the opposite party.
कौन किसी दाइन और ऑफिस नोट किसी अच्छा वैलिड सर्विस एज 2020 रे
And if he is not turning up, may take it off.
notice both on admission and
दरकार हबनी
अरे appearance तो नहीं केमती करिवि
no
I understand je but admission by hearing केमती करिवि
no, it's a complaint case.
I understand.
Order 138 Act.
Yes.
And against the order of acquittal, my lord, I have come up against the leave, my lord. Now, if my lord allow the leave, it will be, my lord, taken up and hearing will be made.
I'll not without hearing I'll not allow.
No, my humble submission, my notice has gone. And
notice that has not gone on, sir, not on maybe admission. It's on limitation and no one has appeared since 2020.
My lord, content the limit.
So obviously I have to issue notice again for the admission hearing.
No.
CPC रे सुनतो आया अपन जोटा क्वेश्चन में बुझिले अपन किनु सेटा CPC रे एडमिशन हियरिंग तल काई दिया होची व्हाट इज योर आंसर
No, my humble submission, since a case where first
प्लीज सेटा कि मैं बुझि पर नथानी कहते अपन कोन अपन बुझि पड़लो नो दैट्स नॉट द पॉइंट सर आई एम आस्किंग यू समथिंग एल्स कया कथा जी इन ए कंप्लेंट केस अब if I am in all matters I am hearing in a complaint case so as far as 138 is concerned all matters I am hearing so here I have not heard as far as the admission matter is concerned limitation delay I will condemn.
That's all only.
That's all. So but you take notice on
obviously after that the moment delay will condone it will come.
But I am not converting into appeal now.
No, let the delay be condoned so that it will come for admission. Thereafter it will be admitted to again notice. After
they appear, I will condone the delay. No problem. Or today also I condone the delay. There is no difference as such. But as far as the requirement of notice is concerned, I am telling you.
My humble submission. Because of the fact that notice had been to the opposite party, they have not turned up. So right now, only but they have, because of the fact that they have been accurate, they may or may not have any intention to proceed further.
That is business issue. That we are not discussing, sir. We are not discussing whether the delay will be condoned. But after that, I have to issue them notice for admission.
Obviously, yes. Obviously.
So please wait for that. The office note put up by the registry dated the 10/2/2020 indicates that AD from the sole opposite party returned after valid service. I election to para in view of the since one is appearing for the opposite party, the learned counsel for the petitioner submits that delay may be condoned. Para since one is appearing, let notice be issued on admission to the by registered post with AD in the present correct address. Requisites be filed for issuance of notice by registered post with AD within 3 weeks in the present correct address. List after SR. Yes.
Delayed and condoned order.
Delay I am not condoning purposefully because let them come so that I can look.
The same thing, Miller, with all this.
I understand, sir. How it will benefit you?
No, the delay will be condoned will come for admission, Miller. One part will
so I have issued. So I have noted your submission that you want the delay to be condoned. The orders regarding the final orders regarding the condom. No. There you are not correct.
No, I don't blame you for a moment.
You also blaming because you are not allowing me to complete the sentence. When did I condone the delay and I have not admitted the matter?
No, that's why my humble.
Your anxiety is that if the delay is not condoned.
So far, one case is when I have no anxiety. So far, the procedural aspect is followed. Here, my lord has initially issued notice to the opposite party for condonation of delay.
সেটা 5 টা বলে কোন হবে
এটি ମୁଁ ଖାଲି କହେ ନ କହି ଜାଣି ମୁଁ ଯଦି ବୁଝିପାରୁନି।
কোনটা বুঝপারনা কোনটা বুঝপারনা
ଆଜ୍ଞା issue notice has been issued to the opposite party for their appearance.
সেটা ଆପଣ ତ 5 ଥର
କି ଗୋଟେ condonation of delay for notice ଟା ଗଲା. They have not turned up. Unless and until the delay will be controlled, my lord, not the case will not be admitted or no notice for admission will go, my lord.
There were absolutely wrong.
Then I am sorry, my lord, whatever.
It is submitted by the learned counsel for the petitioner that unless the delay is condoned, the matter cannot be admitted. The admission notice cannot be issued. On the face of it, such submission is not correct. Since the petitioner did not appear after notice being sufficient, the court has issued notice on admission without admitting the matter. And the question of delay shall be considered in appearance of the opposite party. Yes.
39.
Next.
My lord, I am appearing on behalf of Mr. Durga Prasad Nanda, Senior Advocate, for OP Party number 1.
Petitioner none. Mr. Your name, madam?
Maryada Divedi.
Miss M. Divedi for R.K. Kadongo. BP Panda for the opposite party. You don't appear for a senior counsel. Never mentioned for a senior counsel.
Sorry.
Because he is not holding any brief.
Sorry, madam.
The learned counsel for the petitioner submits that the opposite parties the non-actors for the petitioner when the matter is called to grant further opportunity list on 19th of March. Yes, next.
I'm so sorry. No, Melos. I was just saying, Melos, that item 32 that we have withdrawn to approve the sessions court, the certified copies may kind.
Yes, 32 रे गोटे लोके डॉक्टर बनेचंती 32 लिखियो the certified copy of the impugned order impugned shall be returned after retaining a copy of the retaining attested photocopy of the said order.
Item 40.
Yes. Petitioner none. Opposite party blank. None actors for the petitioner when the matter is called to grant further opportunity list on.
Pardon, my lordship. My lordship, I am appearing for item 39, my lordship.
Happening, you are there for the petitioner or the.
My lordship, for petitioner, my lordship. My lordship, can it be passover or my lordship can be taken
No,
to
39. When you are appearing for the opposite party, you are along with Mr. Deepu Nanda or you are.
on behalf of Mr. Nanda, my lordship.
So that has been mentioned. That is already gone.
Yes, my
Yes. Your presence has been noted. Miss Marana, your presence has been noted.
Much obliged, my lordship.
Miss Divedi was there. She's there, still there in the court. If you can see her, she's there. You just come to the camera. Now you can see her.
Yes, my lordship.
Yes,
Sorry,
yes.
my
She's there.
Yes, my lordship.
Yes.
One.
40 ଟା ଗଲା 40 ରେ ଆପଣ ଲେଖିବେ ପିଟିସନର ନନ୍ ଅପୋଜିଟ୍ ପାର୍ଟି ମିଷ୍ଟର B.R. ମହାନ୍ତି ଅପୋଜିଟ୍ ପାର୍ଟି ଲେଖିବେ ଆପଣ B.R. ମହାନ୍ତି 11-3 ହେଲା ସେମ୍ ଅର୍ଡର 41 ମିଷ୍ଟର ଅରବିନ୍ଦ ମହାନ୍ତି for the petitioner opposite party one Mr. Devashish Naik.
Lakshman from the opposite party number 2.
Opposite party number 2.
Lakshman, the last occasion also no one appeared on behalf of the petitioner.
No, today they have appeared.
Oh, timely.
ଆପଣଙ୍କର ନାଁ କଣ?
Chirag Purohit.
Mr. Chirag Purohit for the opposite party number 2. The learned counsel for the petitioner submits that as per his instruction, the petitioner has unfortunately passed away during pendency. He shall obtain alternate instruction as paid for list on 12-3-24. Yes, next. 42.
May I please? I am for opposite party, not say.
Petitioner none, Mr. H.K. Behra.
Sanjeev Kumar S.K. Das.
So Sanjeev Kumar S.K. Das on behalf of D.R. Bhokta for the petitioner, opposite party. Petitioner none, Mr. S.K. Das on behalf of D.R. Bhokta, opposite party. The learned counsel for non-appeals for the petitioner when the matter is called to grant further opportunity list on 18/3/2024. 4:30 तो only the mentioned matters will be taken up. Mention order account to
44.
Mr. B.R. Mahanti for the petitioner. Opposite party blank.
Item 43.
Sir, but since after 4:30 scheduled timing of the court, I will not go to the list because I can't observe that no one is appearing. So only those have been mentioned. There is quite a good number of matters have been mentioned. That is another thing. But I'll take up those because that have been mentioned by the learned counsel. Yes.
All right.
Yes.
Item 44.
Mr. B.R. Mahanti for the petitioner, opposite party blank. The learned counsel for the petitioner seeks accommodation to advance arguments. As paid for his term, 5/3/2024. So जोटा गोटे मैटर थिला that is 38 से तो सबमिशन ला कौन लिखले अब तो देखले it is submitted by the learned counsel for the petitioner that admitted तो को सेंटेंस है नहीं कुछ अच्छा लागला अपन कौन लिखले his submission is that ଆମେ ଆଉ ଥରେ ଲେଖନ୍ତୁ ଆପଣ ମତେ କହିବେନି ଯଦି ସେ ଗଲା ପରେ କଣ କରାଯିବ ଠିକ ଅଛି ଛାଡ଼ନ୍ତୁ ତା ଅର୍ଜନ ହେଇଛି ଆଉ yes next
47.
Mr. B.R. Mahanti for the petitioner, Mr. Opposite party blank. The learned counsel for the petitioner seeks accommodation to obtain instructions as paid for list on 12/3/2024.
48.
Mr. Niranjan Singh for the petitioner, opposite party blank. Same order, 15/3/2024.
49.
Mr. N.R. Ponda on behalf of S.K. Purohit. Same order, opposite party blank. Same order, 15/3.
51.
51, Mr. Manish Dhir on behalf of Sarthak Naik for the petitioner. The learned counsel for the petitioner seeks accommodation to advance arguments. Seeks accommodation, stop. Yeah, stop. तापर लिखिए आज पेज for list on 12/3/2024.
52.
Mr. Ramesh Chandra Sahu for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation. As paid for list on 14/3/24.
53.
J. Raut on behalf of Bharati Das. Mr. Standing counsel for the OP number 1. Mr. S.S. Mahapatra. 53, Mr. S.S. Mahapatra for OP1. OP2 blank. So same order, 11/3/24.
54.
Aroma right for petitioner. S.S. Mahapatra AC for the state. Same order, 12/3. Then for hearing.
57.
56 na 57. 56. Mr. R. Patri on behalf of PC Jena for the petitioner.
Mr. Devashish Naik KJ.
Mr. Devashish Naik KJ for the state. The learned counsel for the petitioner seeks accommodation to advance arguments as paid for list on 14/3/24.
57.
The memo is filed on behalf of the petitioner stating that the petitioner doesn't want to proceed with the matter. Memo is taken on record. The matter stands disposed of. এটা লিখিত নাটা কହୁଛନ୍ତି ସେ SR Pradhan on behalf of Jaydeep Pal for the petitioner. Opposite party blank. 57 लिखले SR Pradhan on behalf of Jaydeep Pal.
59,
Mr. Petitioner blank, Mr. Rupam Misra on behalf of T. Misra for the opposite party. The learned counsel for the opposite party seeks accommodation as paid for list on 5/3/24. Yes, next.
60,
Mr. S.K. Jenna for the petitioner.
Myself.
Mr. Standing Counsel for the state. Learned counsel for the petitioner seeks accommodation to advance arguments as paid for list on 13/24.
63,
Mr. K.K. Sethi on behalf of B.S. Dasparida. For the petitioner.
Yes.
Mr. Standing Counsel for the state. Learned counsel for the petitioner seeks accommodation to advance arguments as paid for list on 14/24.
64,
Mr. Sanjay Kumar Pradhan for the petitioner. Mr. Standing Counsel for the state. Learned counsel for the petitioner seeks accommodation as paid for list on 15/3/2024.
66,
Mr. Ravi Shankar Samal for the petitioner. Mr.
Mahapatra.
S.S. Mahapatra ASC for the state. The learned counsel for the petitioner seeks accommodation to advance arguments as paid for list on 4/3/24. ଆଉ କିଛି ପାସ୍ ଓଭର ରହିଲେ?
66 na.
Yes, Mr. Standing Counsel.
No.
Thank you. କୋଉଟା? ନାଇଁ ଆଉ ପରେ ମ୍ୟାନେଜ କରିହବନି। ସେତିକି ରହିବ। ଆପଣ କେତେ ଗଣିତ